We'll hear arguments in number 73, 1766, United States of America against Nixon. And the cross-petition, Richard M. Nixon against the United States. Mr. Jaworski, there has been a request for additional time. The court grants that additional time of 1/2 hour, I understand. That's correct?
Correct.
It'll be allowed to each side, and we will not interrupt the argument with any recess. We'll go right through until you've finished. You may proceed whenever you're ready, Mr. Jaworski.
Mr. Chief Justice, and may it please the court. On March 1st last, a United States District Court grand jury sitting here returned an indictment against 7 defendants, charging various offenses, including among them a conspiracy to defraud the United States and also to obstruct justice. John Mitchell, one of the defendants, was a former Attorney General of the United States and also chairman of the committee to re-elect the president. Another, H.R. Haldeman, was the president's chief of staff. Another, John Ehrlichman, was assistant to the president for domestic affairs. The others were either on the president's staff or held responsible positions on the re-election committee. In the course of its deliberations, the grand jury voted unanimously, with 19 members concurring, that the course of events in the formation and continuation of the conspiracy was such that President Nixon, among a number of others, should be identified as an unindicted co-conspirator in the bill of particulars to be filed in connection with the pretrial proceedings. Now, although this particular decision and determination on the part of the grand jury occurred in February, it was a well-kept secret for 2.5 months. The grand jury, of course, knew it. The members of the prosecution staff knew it. It was done so to avoid affecting the proceedings in the House Judiciary Committee. And it was so kept during these 2.5 months until it became necessary to reveal it as a result of the President's motion to quash the subpoena, as I will indicate subsequently in my argument. Now, to obtain additional evidence, which the special prosecutor has good reason to believe is in the possession of and under the control of the President, and which it is believed by the special prosecutor is quite important to the development of the government's proof at the trial in United States versus Mitchell et al. The special prosecutor, on behalf of the United States, moved for a subpoena ducis tecum, and it is the subpoena here in question. The district court ordered the subpoena to issue, returnable on May the 2nd. And the subpoena, of course, called for the production of tape recordings in advance of September the 9th, 1972, which is a trial date. And this was done to allow time for litigation in the event litigation was to ensue over the production of the tapes, and also for transcription and authentication of any tape recordings that were produced in response to the subpoena. Now, on April the 30th, the President released to the public and submitted to the House Judiciary Committee 1,216 pages of edited transcripts of 43 conversations dealing with Watergate. Portions of 20 of the subpoenaed conversations were included among the 43. Then on May the 1st, the President, by his counsel, filed a special appearance, a formal claim of privilege, and a motion to quash the subpoena. Now, for the United States to conduct a full and appropriate hearing on a motion to quash the subpoena, it became necessary to reveal the grand jury's finding regarding the president. And this was first done by the special prosecutor calling on the Chief of Staff, General Alexander Haig, and the President's counsel, Mr. St. Clair, and advising them of what had occurred 2.5 months prior. And then, on the following morning, advising Judge Sirica of what had occurred in camera, and pointing out the necessity of this being used in connection with the arguments on the motion to quash because of their relevance and the necessity of these matters being made a part of the proceeding. Now, the special prosecutor joined counsel for the President in urging that the matter be heard in camera, which was done. 3 of the defendants had joined the special prosecutor in moving for the subpoena. All of the defendants, at the time of argument in camera to Judge Sirica, opposed the motion to quash.
I don't see the relevancy of the fact that the grand jury indicted the President as co-conspirator to the legal issue as to the duty to deliver the pursuant to the subpoena that you are asking for.
The only relevance, Mr. Justice, lies in it being necessary to show under Rule 17C that there is some relevance to the material that we were seeking to subpoena.
Yes,
and
17C presupposes a subpoena running against a party, and the President is no party. He's not a defendant in one of these cases.
That's correct, sir, but it was also felt that it would be necessary to show why. In order to prove this conspiracy, and in order to provide all of the links in the conspiracy, it was deemed necessary to show that the President was named as an unindicted co-conspirator, and also that this proved.
I thought that was primarily just for the knowledge, information of the House Judiciary Committee.
No, sir, that is not correct, sir. It became very important, Mr. Justice, for us to have that as a part of the proceedings so that we could use the various links in the testimony so as to show that the conversations were such as to make one admissible as against a co-conspirator.
The grand jury sent it to the House Committee, didn't it?
The grand jury sent nothing of an accusatory nature to the House Committee, no, sir. What the grand jury sent to the House Committee was the evidence that had been accumulated, and it very carefully excised from it anything by way of the grand jury's interpretation or anything along that line, Mr. Justice. Now, in its opinion and order of May 20th, the District Court first
still be here, Mr. Jaworski, whether or not the President had been named as an unindicted co-conspirator, but that simply gives you another string to your bow. Isn't that about it?
It's true that it admits some evidence that would otherwise not be admissible.
Right, but even had the President not been named, you would still have subpoenaed at least part of this material.
There's no question about that, yes, sir.
You'd still be here.
That's right, sir.
You're not.
That's right, sir. But in order to present the full picture, and in order to present, that also was a part of it. District Court denied the motion to quash and the motion to expunge. They had also been talking.
No one yet has ever suggested that if you're in a criminal trial, conspiracy trial, and some evidence is offered of an out-of-court statement of someone who's alleged to be a co-conspirator, that it's enough for the prosecution to then show that the grand jury had named him as a co-conspirator.
No.
That never gets you, will never get you
No.
over the...
And we don't so contend.
Well, then, that was the point of your, that was the direction of your...
No, this was in connection with the subpoenaing of this evidence, Mr. Justice. In other words, this was in connection with showing that we had the right to this evidence.
Well, I understand that.
Yes, sir.
But,
and that was the point.
But you do not suggest that that's all you need to show, is that it?
No, sir.
Of
course not.
You don't suggest that the grand jury finding is binding on the court, or not?
I do suggest that it makes a prima facie case. And I think under the authorities it so does.
Well, let me understand this, Mr. Jaworski. You don't suggest that your right to this evidence depends upon the President's having been named as an unindicted co-conspirator.
No, sir.
And so for the purposes of our decision, we could lay that fact aside, could we?
What I was really doing in pointing to that...
Well, could we?
Yes. Primarily was in order to show a reason for the grand jury's action. There's also before this court a motion to expunge the act of the grand jury in naming the President as an unindicted co-conspirator. And I was trying to lay before the court the entire situation that warranted that action.
Mr. Jaworski,
yes, sir.
As I understand your brief, you go beyond what you have addressed so far. I think you say that the mere fact that the President was named as an unindicted co-conspirator forecloses his claim of privilege.
Well, we certainly
page 91 of your brief.
We certainly make that as one of the points which I intend to discuss at a later point.
In other words, that reduces him in and of itself to the status of any other person accused of crime.
I don't say that it forecloses. What I think we suggest is that it does present a situation here that should not make the application of executive privilege appropriate. We do say that.
But only prima facie.
Prima facie, that's correct. But when you get to the matter, Mr. Justice Powell, of balancing interests, we do feel that that particular situation is a factor that is important. And this is why we laid stress on it. The court's order, of course, was to deliver to the court the originals of all subpoenaed items, as well as an index and an analysis of those items, together with taped copies of those portions of the subpoena recordings for which transcripts have been released to the public by the President on April the 30th. Now, this case presents for review the action of the lower court. Now, may I, before I get to the jurisdictional points, briefly state what we consider to be a bird's eye view of this case. Now enmeshed in almost 500 pages of briefs, when boiled down, this case really presents one fundamental issue. Who is to be the arbiter of what the Constitution says? Basically, this is not a novel question, although the factual situation involved is, of course, unprecedented. There are corollary questions, to be sure. But in the end, after the rounds have been made, we return to face these glaring facts that I want to briefly review for the final answer. In refusing to produce the evidence sought by subpoena duces tecum in the criminal trial of 7 defendants, among them former chief aides and devotees, the President invokes the provisions of the Constitution. His counsel's brief is replete with references to the Constitution as justifying his position. And in his public statements, as we all know, the President has embraced the Constitution as offering him support for his refusal to supply the subpoenaed tapes. Now, the President may be right in how he reads the Constitution, but he may also be wrong. And if he is wrong, who is there to tell him so? And if there's no one, then the President, of course, is free to pursue his course of erroneous interpretations. What then becomes of our constitutional form of government? So when counsel for the President in his brief states that this case goes to the heart of our basic constitutional system, we agree. Because in our view, this nation's constitutional form of government is in serious jeopardy if the President, any President, is to say that the Constitution means what he says it does, and that there is no one, not even this Supreme Court, to tell him otherwise.
Mr. Jaworski,
yes,
the President went to a court. He went to the district court with his motion to quash, and then he filed a cross petition here. he's not, he's asking the court to say that his position is correct as a matter of law. Is he not?
He's saying his position is correct because he interprets the Constitution that way.
Correct. And he's submitting his position to the court and asking us to agree with it. He went first to the district court and he's petitioned in this court. He's not. He has himself invoked the judicial process, and he is.
Well, that's not entirely correct, Mr. Justice.
Well, didn't he file a motion to quash the subpoenas in the district court of the United States?
Sir, he has also taken a position that we have no standing in this court to have this issue heard.
As a matter of law, he's asking he's making that argument to a court.
So that
as a matter of constitutional law, he is correct.
So that, of course, this court could then not pass upon the constitutional question of how he interprets the Constitution if his position were correct that I had.
As a matter of law, if his position is correct, then he is the sole judge.
That's right.
And he's asking this court to agree with that proposition as a matter of constitutional law.
But what I'm saying is, if he is the sole judge, and if he's to be considered the sole judge, and he is an error in his interpretation, then he goes on being an error in his interpretation.
Well, then this court will tell him so. That's what this case is about, isn't it?
Well, that's what I think the case is about, yes, sir.
He's submitting himself to the judicial process in the same sense that you are. Is that not so, Mr. Jaworski?
I can't see
You take one position and he takes another.
Well, Mr. Chief Justice, in my view, frankly, it is a position where he says the Constitution says this, and nobody is going to tell me what the Constitution says, because up to this point, he says that he and he alone is the proper one to interpret the Constitution. Now, there's no way to escape that, because the briefs definitely point that out time after time.
I think this matter may be one of semantics. Each of you is taking a different position on the basic question, and each of you is submitting for decision to this court.
Well, we start.
Maybe, sir.
We start with a Constitution that does not contain the words executive privilege. Is that right?
That's right, sir.
So why don't we go on from there?
All right, sir. That is a very good beginning point, but of course there are other things that need to be discussed too, and as much as they've been raised.
Perhaps it would further narrow the area if, as I take it from your briefs, you do emphasize there is no claim here of typical military secrets or diplomatic secrets or what in the Burr case were referred to as state secrets. None of those things are in this case. Is that right?
That is correct, sir. And we do point to the authorities to show that there is a difference in the situation here. I do think that it's proper, as much as I regret to have to do it, to point that the President's interpretation of what his action should be in this particular set of circumstances is one that really requires judicial intervention, perhaps more so than a normal one would. I think that we realize that there is at stake the matter of the supplying of evidence that relates to, the two former close aides and devotees. I think we're aware of the fact that the President had publicly stated that he believed that these two aides of his, Mr. Haldeman and Mr. Ehrlichman, would come out all right in the end. Added to that the fact that the President has a sensitivity of own involvement is also a matter that calls for the exercise of the question to which Mr. Justice Douglas alluded as one that is somewhat unusual. Turning now to jurisdiction, before the court are the two questions of statutory jurisdiction. The court directed the parties to brief and argue.
Mr. Jaworski, at
Yes,
this
sir.
point, help me over one hurdle. Do you feel that the mandamus case as such is here? I search your petition.
Yes, we do, sir.
I search your petition for certiorari in vain to find even a mention of it. And I wondered, it's a technical question, but what is your position that the issues in any event are here?
Yes, sir.
Whether the case is
Yes, sir.
or it's not?
We say it's here not only because of the appeal itself, but also because of the petition for mandamus. Now, we did Mr. Justice discussed that in one of the briefs. Now, it may be that it wasn't originally when we filed the original brief on jurisdiction.
You mentioned it in your second brief on the merits.
Yes.
But not at all in your petition for certiorari.
Well, we did in the, it was in the footnote on page 2 of the petition for writ of certiorari, Mr. Justice. Well, I would think so, but there really is no issue between the parties here on the issue of jurisdiction. I mean, there's no argument as between the parties on it, and while, of course, the parties can't agree on it, I must say that on 3 different bases, the jurisdiction does exist as we see it. Now, I'm not yet getting to the question of the intra-executive matter that has been raised, but I am discussing now the statutory basis of jurisdiction. And but to answer your question directly, sir, this is correct. We are standing upon not only the matter that this is an appeal that properly had been in the Court of Appeals, and for that reason has been moved up here properly under 1254.1. We also say that the court has jurisdiction over the petition and cross-petition under 1254.1 because they present for review all questions raised by the petition, by the President's petition for writ of mandamus. And then we also say that in addition to that, the All Writs Act gives this court jurisdiction to proceed.
Of course, if in a mandamus action, Judge Sirica would be the party respondent, and he's not a party in this case, and he's not represented by counsel here, is he?
As far as I know, he's not. No, sir. In fact, I'm sure he's not.
The mandamus would be Nixon versus Sirica, would it not?
But it was brought up by the President in their petition for mandamus. That's right. That's the way it got into this court. Raises the same questions, actually, that were raised on the matter that we brought up on.
Well, what was the chronology, Mr. Jaworski? The notice of appeal from Judge Sirica's order was the first step taken to get to the Court of Appeals, was it?
That's, I believe, right, sir.
And while that was pending, then I gather the President's petition for mandamus was filed.
Right, sir. Yes.
And then the last step was that you filed the petition to bypass.
Right, sir.
And that petition to bypass applied, I gather, to whatever case was pending in the Court of Appeals.
That's correct, sir.
And at that time, the case pending was both the appeal from Judge Sirica's order,
right, sir,
and the President's petition.
Mandamus, correct.
Do you feel there are not 2 cases?
No, sir, they raise the same questions.
And yet you could bring each up separately if you so chose.
Could have, sir, yes.
Seems to me there are 2 cases.
But inasmuch as they present the same questions, it occurred to us that it was appropriate to rely upon the jurisdiction as to both of them.
Except I would suggest again that with respect to the mandamus action, one of the parties isn't here in court, represented by counsel. He is the party respondent.
Well, it is... I don't have the record before me, but I must say that and I will not make an outright representation that Judge Sirica is, and that's why I hesitated a few minutes ago, was made a party. After all, it was brought up by the President. But I am advised by a note just passed me by Mr. Locavera that Judge Sirica is a party to that proceeding.
Who represents him here?
I don't know of anyone representing him here, Mr. Justice.
Has he filed any brief or made an appearance at all in any sense?
So far as I know, not.
Well, if you're right, that in any event, Judge Sirica's order was an appealable order.
That's correct.
If you're correct in that submission, do we ever have to reach any issues raised by the mandamus?
No, we would not. We were pointing out that the jurisdiction rests on a 3-pronged basis.
But the mandamus is not your action.
It's not, no, sir.
And you're not obliged to defend it.
That's correct, sir. We, however, were pointing out that the same issues really were raised by it if the petition is properly before the court. Now, if there are no further questions on the matter of statutory jurisdiction, I would like to pass to the intra-executive dispute. First, we recognize, of course, that jurisdiction cannot be waived, and nothing that is presented here is with the idea of suggesting even remotely that there is any waiver with respect to the questions of jurisdiction. But we do say that the contention that there is an intra-executive dispute and that for that reason this court cannot pass upon these questions is not sound. And before discussing the cases, however, I think that it would be appropriate for us to undertake to place this in the right perspective. Let me say first that we stand upon two bases. First, that the orders that were entered creating the office of the special prosecutor and delineating his authority, even the original order at the time that my predecessor was acting as special prosecutor, had the force and effect of law. We also point to the fact that the arrangement made itself with the acting Attorney General that I made, if I may point to it, and one reason I have no reticence in discussing the facts is because the facts are undisputed. There's been no dispute raised as to just what actually transpired. The situation is one of the arrangement itself, which the acting Attorney General points to with respect to the matter of independence having been discussed by him with the President, thus meaning that the President himself had approved the setting up of this particular office and the rights and the responsibilities that it has under the Charter. Now we set this out in the appendix, of course, pointing precisely to what the authority and the responsibilities and the obligations of the special prosecutors are. One of the express duties that's delegated to the special prosecutor is that he shall have full authority for investigating and prosecuting, among others, allegations involving the President, and the delegation of authority expressly states, in particular, the special prosecutor shall have full authority to determine whether or not to contest the assertion of executive privilege or any other testimonial privilege. Now, in the instance of my appointment, unlike the appointment that had been made prior thereto, there was an amended order, and it referred to assurances given by the President to the Attorney General that the President will not exercise his constitutional powers to affect the discharge of the special prosecutor or to limit the independence that he's hereby given, and that he will not be removed from his duties except for extraordinary improprieties on his part and without the President's first consulting the majority and the minority leaders and the chairman and ranking minority members of the judiciary committees of the Senate and House of Representatives, and ascertaining that their consensus is in accord with the proposed action. And then that the jurisdiction of the special prosecutor will not be limited without the President's first consulting with such members of Congress and ascertaining that their consensus is in accord with his proposed action. Now, at the time...
It's not important. What does consensus mean? Unanimous?
No, sir. It had been interpreted by the acting Attorney General in conversation as meaning 6 of 8.
I take it when you make reference to this, you are in effect suggesting that your position is certainly different than if a United States attorney were prosecuting this case.
That's correct, sir. I think we have what might be termed a quasi-independent status, where there were delegated to this particular office the performance of certain functions, and there's no reason why the President couldn't have delegated those to us. As a matter of fact, when...
Mr. Jaworski,
yes,
quasi-independent in the sense of an agency?
Yes, sir. For instance, as a comptroller of currency, he has a status somewhat similar to that, and we know that there are suits brought between the Department of Justice and the comptroller.
Yeah, that's
just the other day.
I have trouble with your position being similar to U.S. Attorney because the U.S. Attorney is absolutely under the thumb of the Attorney General.
Well, I didn't say it. What I meant was that we had an independent status that was really different from the status of the United States Attorney.
I'm sorry.
I thought that was the way I answered the question. Now, I should say that it's interesting when the case of Nixon versus Sirica was before the Court of Appeals. Professor Charles Allen Wright, who was then arguing that case, and who was not on the original brief, but I observe is on the reply brief filed on behalf of the President, at that time argued with respect to the particular office of the Special Prosecutor. Now, in this instance, we have a division of function within the executive in that my friend, Mr. Cox, referring to Archibald Cox, has been given absolute independence. It is for him to decide whom he will seek to indict. It is for him to decide to whom he will give immunity. A decision that ordinarily would be made at the level of the Attorney General, or in an important enough case, at the level of the President. But the President's present counsel, in his motion to quash, as he does here, except the words used are different, but the effect is the same, is contending to the court that the President has the right to determine who, when, and with what information individuals shall be prosecuted.
Nixon against Sirica was different in that the parties there were the grand jury on the one hand, represented to be sure by the special prosecutor, but the grand jury, which is an adjunct of the judicial branch of government on the one hand, and the chief executive on the other. And here, now that an indictment has been returned, the two parties are both members of the executive branch. Isn't that not correct, that there is that difference?
Yes, but the independent, yes, sir, that is correct, but I don't think it's a distinction as to the substance,
Well, you are a member, you're United States, people of the United States whom you represent. You are not a member of the judicial branch, unlike the grand jury in Nixon against Sirica. You're a member of the executive branch of government, are you not?
That's correct, sir, yes.
And there is that difference.
There is that difference, yes, but I don't think that the description to which I pointed as to the independent status of the independent executor would be any different in the Sirica case as it would be in this case. And I was merely...
No, you're, if anything, more independent than Mr. Cox was under the regulations.
That's correct, sir.
But that doesn't really go to the question that I raised.
Yes, sir. I realize that. Now, may I, however, indicate very briefly, and I know this is an important question, but I do feel that the facts ought to be before the court in detail, indicate just what did transpire with respect to how these particular regulations, this order, was interpreted by the President's acting Attorney General, and also by the Attorney General designate, and also by the President himself, and by the President's Chief of Staff, General Haig. Mr. Bork, in hearings at a time when Congress was pressing the bill of an independent special prosecutor, testified that although it is anticipated that Mr. Jaworski will receive cooperation from the White House in getting any evidence he feels he needs to conduct investigations and prosecutions, it is clear and understood on all sides that he has the power to use judicial processes to pursue evidence if disagreement should develop. It was further pointed out...
You're quoting from whom at what time?
Acting Attorney General Bork's testimony in the House.
On what occasion?
After I had been appointed, and in connection with the hearings on the bill to establish an independent prosecutor by congressional act.
Thank you.
Yes. Then he further said, I understand and it is clear to me that Mr. Jaworski can go to court and test out, and these are the important words, and test out any refusal to produce documents on the grounds of confidentiality. And Attorney General Saxby, then a designate, who was also present at the time that this matter was discussed and at the time that I accepted the responsibilities, testified that I had the right to contest an assertion of executive privilege and stated that I can go to court at any time to determine that. Now, the President himself, as we point out in our brief, in announcing the appointment of a new independent prosecutor, stated that to the nation that he had no greater interest than to see that the new special prosecutor has the cooperation from the executive branch and the independence that he needs to bring about that conclusion of the Watergate investigation. The President's Chief of Staff, at the time that this appointment was accepted, and at the time that the new regulations were then drafted by the acting Attorney General, had assured me, and this is a part of the record, because a letter was written at the request of Senator Hugh Scott to the White House as a result of discussions that he had with General Haig, in which I sent a copy of the testimony that I had given to the congressional committees to the White House so it would be fully aware of it, and the receipt of it was acknowledged without any change in the testimony. So I had been assured of the right to judicial process by him after he had reviewed the matter with the President and came and told me that I would have the right to take the President to court, and that these were the key words in this arrangement, and that the right would not be questioned. Of course, this independence that was given to the special prosecutor actually was but an echo of public demand. And if I may be permitted to say so, it was the only basis on which, after what had occurred and a predecessor had been discharged, it was the only basis on which that the special prosecutor could have felt that he could come in and serve and undertake to perform these functions. Now, it's important, I think, to observe that counsel for the President, in his brief, by accepting the proposition that the President and the Attorney General can delegate certain executive functions to subordinate officers, implicitly has conceded, so we think, the validity of the regulations delegating prosecutorial powers to the special prosecutor. The regulations specifically provide, as you will notice from the appendix, and we have set them out, that the Attorney General will not countermand or interfere with the special prosecutor's decisions or actions. This is also a part of the Charter. Thus, to argue, as has been done in these briefs, that the separation of powers precludes the courts from entertaining this action because it is the exclusive prerogative of the executive branch, not the judiciary, to determine whom to prosecute, on what charges, and with what evidence, we think misses the point. What has evolved from the regulations, in our view, is a prosecutorial force with certain exclusive responsibilities. And this is why I say that to some degree it could be described as a quasi-independent agency. It's not unlike our situation is the case we alluded to a few minutes ago, decided by the court just a week or so ago. It's not unlike the case of the Secretary of Agriculture versus the United States. This is the first time that there has been an action brought by one member of the executive branch against another official in the executive branch. And we refer to these cases in our briefs in detail. Now, I want to make it clear that the President at no point, of course, delegated to the special prosecutor the exclusive right to pass on the question of executive privilege or any other privilege, attorney and client privilege, or any other testimonial privilege. What we are merely saying is that we have the clear right to test it in this court, and this is on what we stand. Well, because of the passage of time, if I may, I think I should get to other discussions unless there are questions on this particular point. Passing to the merits, we would say that if there is any one principle of law that Marbury and Madison versus Madison decides, is that it is up to the court to say what the law is. And almost to the point of redundance, but necessary because it was a landmark decision, Chief Justice Marshall reasoned, we think with clarity and emphasis, that it is emphatically the province and the duty of the Judicial Department to say what the law is. And this court, of course, through the years, has reaffirmed, consistently applied that rule. It's done it in a number of cases. And Powell versus McCormick in the Youngstown Steel seizure case, and Doe versus McMillan. And a footnote, I think a very important one, appears in that opinion when Mr. Justice White pointed out that while an inquiry such as involved in the present case, because it involves two coordinate branches of government, must necessarily have separation of power implications. The separation of powers doctrine has not previously prevented this court from reviewing the acts of Congress, even when it is pointed out the executive branch is also involved. Now, there are a number of cases that speak to that. I think one of the cases that perhaps went into greater detail and also points out quite a distinguishing feature is the Gravel case, whereas in the Gravel case the court did hold that it was appropriate to go into certain matters where privilege had been exercised on the part of a senator on behalf of his aide. There are two things that I believe clearly help us in that decision and also other decisions as far as the questions here are involved. One is that the speech or debate clause is in the Constitution, as is the journal clause, is in the Constitution. It's written in there. And this is what was invoked. I don't find anything written in the Constitution, and nothing has been pointed that is a writing in the Constitution that relates to the right of the exercise of executive privilege on the part of the president. Another very important thing that's pointed out in that case is that it did involve an examination into wrongdoing on the part of those who were seeking to invoke the privilege.
Is the term executive privilege an ancient one?
I beg your pardon, sir?
Is the term executive privilege an ancient one?
It has been used over a period of time. How ancient, Mr. Justice Brennan, I'm not in position to say, but certainly it has been one that's been used over the years, but it is not one that I find any basis for in the Constitution.
Are you now arguing that there is no such thing as executive privilege?
No, sir.
I didn't think so.
No, sir. But I said that there had no basis for it in the Constitution.
You think, if anything, it's a common law privilege? Is that your point?
Yes, sir, and that it has been judicially recognized, and appropriately so in a number of cases as we see it. We do not think that it is an appropriate one in this case. But we certainly do not for a moment feel that it has any constitutional base.
In Scheuer against Rhodes, I thought we held that there is a common law privilege in the executives dealing at the state level, but that it is a qualified privilege. Is that not so?
Mr. Chief Justice, that is exactly the point. This court has examined a number of situations. And in some situations, as I think was pointed out earlier, where military secrets and such as that were involved, or national secrets of great importance, the court has taken a good close look and has upheld privilege. But
when you say has taken a good close look, without looking at the evidence sometimes, taken a good close look at the claim and the basis of the claim, is that what you mean?
That's what I mean, yes.
But doesn't this court say that it did have constitutional overtones?
Said it had constitutional overtones, and I don't know in what case it may have been used, but
Court of Claims, I think.
Yes, but it certainly has never placed it in the Constitution, so far as I'm aware of, and the President's counsel, who have carefully examined the authorities.
Right.
That was Kaiser Aluminum and Chemical Corporation.
Yes.
The Court of Claims, and that phrase was used.
It's judicially tailored?
Yes, sir.
Is it your view that there are no inferences to be derived from the doctrine of separation of powers? Are you saying this is purely an evidentiary privilege?
That the privilege as recognized judicially may have been tied into the separation of powers doctrine, we don't deny. What we say is that separation of powers doctrine, in the exercise and the calling for executive privilege, has not been applied in a number of instances involving both Congress and involving also the executive, despite the fact that even in a congressional situation, a speech or debate clause is there. What I am saying is that the separation of powers doctrine, as was pointed to in the Doe versus McMillan case, has not been permitted to stand in the way of this court examining, yet from the standpoint of whether the executive privilege should be permitted or not. This is what I'm saying.
In Reynolds, the court ended up treating the assertion of privilege there as an evidentiary privilege, but it did allude to the fact that there was a constitutional question and said the court wasn't reaching it, as I recall.
On the issue of executive privilege, I should point out here, is a very narrow one. And I think it's important that we bear this in mind. It doesn't involve a very large or broad privilege rights. What it really narrows down to is a somewhat simple but very important issue in the administration of criminal justice, and that is whether the president, in a pending prosecution, can withhold material evidence from the court merely on his assertion that the evidence involves confidential communications, and this is what it really gets down to. We know that sovereign prerogatives to protect the confidentiality necessary to carry out responsibilities in the fields of international relations and national defense are not here involved. And there is no claim of any state secrets or that disclosure will have dire effect on the nation or its people. Actually, I think when we get to weighing and the non-disclosure as against disclosure, and I think when we begin to weigh the balance of interests, it would seem to me that the balance clearly lies in favor of a disclosure in a situation such as this circumstance here. Of course,
That certainly would not be true in case of the Fifth Amendment was involved. But that's not present here.
Not present, Mr. Justice Douglas, and there is no question but what the Fifth Amendment is very plainly written out in the Constitution and is invoked as a clear constitutional privilege. I think that it would be of help if I may point out to the court that there is an excellent article that we have alluded to in our briefs by Professor Berger that appears in the Yale Law Journal, which discusses the Aaron Burr case at length and also other cases that have been pointed to since the time of that case. And if I may just say very briefly that he summarizes the situation by saying that the heart of Marshall's opinion was therefore justly summarized by the Court of Appeals in the Nixon-Sirica case and the Tapes case that we have talked about. The court was to show respect for the president's reason, but the ultimate decision remained with the court. And we're not suggesting for a moment here that the matter of executive privilege should not be looked into. This is not. It deserves to be tested. It should be tested, and we urge it to be tested. But the ultimate decision is not one of saying that it is absolute, it rests in the Constitution, that doesn't entitle anyone and doesn't authorize anyone, doesn't even authorize this court to look into it. Because if the courts are the ultimate interpreters of the Constitution and can restrain Congress to operate within constitutional bounds, they certainly shouldn't be empowered any less to measure presidential claims of constitutional powers. I wanted briefly to make mention of the question that has been raised by counsel for the president that involves a motion to expunge the finding of the grand jury's action that the president is to be named as an unindicted co-conspirator along with a number of others when the pretrial proceedings are gone into and the bill of particulars is being filed. And I say that the grand jury's finding, painful as it is, I think on the part of the court must be considered as being valid and is sufficient to show prima facie. It is sufficient to show prima facie that the president was involved in the proceedings in the course and in the continuation of the particular conspiracy that was charged.
Well, is that the issue, Mr. Jaworski, or is the issue whether there can be a collateral attack?
That's also another issue. But I merely wanted to point out that I believe that this court would not go into the grand jury's findings, but it's a prima facie matter, and that this court would not go into it for the purpose of determining a matter of that kind.
I thought we had put that issue aside a while ago. I just don't understand what the relevance is to this case.
Well, I have to agree with you. Neither do I see what the relevance is of the matter of saying that there's another argument advanced here, and that is that the president can't be indicted. And I don't know what the relevance of it is in this case either, very frankly, because it isn't before the court. And yet the argument is made, and many pages of briefs are devoted to it.
I'm just wondering, Mr. Jaworski, why you aren't content with just arguing it is irrelevant without taking on the right...
Well, this is why I skipped the argument with respect to the matter of whether he could be indicted or not. But inasmuch as this question had been raised and briefed and a motion exists before the court, I have to agree that it is relevant. But it is a part of the case. That's the only reason I alluded to it. And I have no interest in spending much time on it.
Well, except part of the grounds on which you rest in subpoenaing this material is the fact that the president has himself been named as a co-conspirator, an unindicted one. And that's true, isn't it? That's part, at least, of the grounds upon which you rest in subpoenaing this material. And the response to that is the president cannot constitutionally be named as an unindicted co-conspirator. So to that extent, it's in this case. The question's in this case.
Well, I don't think it's a matter that, very frankly, has any particular basis to it, because I don't see how this court could be asked to substitute its judgment for that of the grand jury.
Well, that's something quite different again, whether or not there was sufficient evidence before the grand jury to justify the grand jury in naming the president. That's quite a different, and as the Chief Justice suggested, a collateral issue.
That's right.
But the issue of whether or not the president can constitutionally be named by a grand jury as a co-conspirator, even though an unindicted one, is at least tangentially before us, because it's the fact that he has been named by the grand jury that is part of the grounds and part of the foundation upon which you have based your subpoena ducis tecum.
Not only that, I think that it has, to pinpoint it, in our view, a materiality, because it does relate to the question of the proof that we are seeking, the relevance of the proof that we are seeking. Mm-hmm. And this gets into, of course, a discussion of matters that are sealed, in which I cannot discuss with the court.
Right.
But whether or not they had the authority, they did. It is a fact that the grand jury did it.
That's correct, sir.
And so I don't see how we have anything to do with whether they had the authority or not. It's a fact. Isn't that true?
That's, I think, correct. Now,
I thought the heart of this case was the rights of defendants in criminal trials.
That is very much...
It may be exculpatory and free them of all liability. I don't know, but
Well, it certainly is in the case. Now, and of course, what you have reference to also, I'm sure, Mr. Justice Douglas, is the Bray and Jenks, the Bray opinion, Maryland versus Bray, and the Jenks. And this is a part of the case. However, it happens not to be a part of the appeal, although it is a part of the case. But as far as our position is concerned, it doesn't relate to that. But certainly it's true that this material, as we had pointed out in our communications to the President, may well involve exculpatory matters. And we time and again pointed out we wanted them not simply because we felt that there were matters that needed to be developed in connection with the prosecution, but that they could well contain exculpatory matters.
So the Brady question really lurks just in the background, does it not? That is, if you get information, whatever you get,
will be available.
You would concede is available to any defendant.
That's right, Mr.
Who can
Chief
make
Justice.
a showing.
That's correct, sir.
And the question of whether or not the defendants under the Brady Doctrine are entitled to subpoena information and material that's not now in your possession but is in the possession of the President was an issue that was left undecided by the district court.
That's correct, sir. It's not before this court.
Right.
I believe, with the permission of the court, unless there are further questions, I'll reserve the rest of the time for the close. All right.
Mr. St. Clair.
Mr. Chief Justice and members of the court, my learned brother has approached this case, I think, in a traditional point of view, namely, this is an attempt by a special prosecutor to obtain what he thinks is desirable evidence in a criminal prosecution that he has the responsibility for. Not once, however, have I heard him mention what I think is really involved, at least in significant part, and that is the co-pendency of impeachment proceedings before the House of Representatives and the realistic fusion that has taken place with respect to these two proceedings and the promise of continued fusion, as I understand my brother's position. May I quote from page 50? I think, sir, they really are. First, by way of factual background.
The sole authority to impeach was in the House.
That's correct.
Authority to try was in the Senate.
Right. And the court shall not be used to implement or aid that process, which is what is happening in this case. This case wouldn't be here on July the 8th.
Just how is this done?
All
How
right.
is this case implemented?
I would like to review some of the facts for you in this regard.
Which are in the record?
Well, yes, my brother has mentioned them to you.
No, but are they in the record, not what he's mentioned?
Yes, yes, sir.
Well, we're just an adjunct of the House Judiciary. This case should be dismissed as improvidently granted, shouldn't it?
Exactly right, sir. Not only that, it makes the case unjusticiable at least. Now,
And the district court's decision stands. Is that what you want?
no, the case should be dismissed, sir.
If we dismiss as improvidently granted, I submit that the district court's opinion, which the judgment would stand.
Then I would retract what I said. This case should be dismissed.
Well, the case would be on appeal in the Court of Appeals if we dismissed it.
All right.
Are you now talking about the bypassing of the Court of Appeals?
No, sir. I'm talking about the proceeding before the district court through the Court of Appeals to this court.
Well, but if we dismissed this appeal as improvidently granted, it would go back to the Court of Appeals.
Well, as I say, I think this case should be dismissed, period.
No, really what you mean, isn't it? You think that the order of Judge Sirica should
set
be
aside.
vacated and set aside.
That's right.
Well, that's
Yes.
quite different from dismissing the case.
I agree.
That's deciding it on the merits.
Yeah.
That's right. That's what I'm trying to get across to this court, perhaps unartfully. This case should be disposed of, be it by vacating the order below or not. But in any event, it is improper in our view that this case should be heard in the context that it is now being heard. We wouldn't be here on July the 8th before a crowded courtroom if it was not recognized generally.
Well, it's a political question here.
Exactly
It's a political
right.
question in the district court.
And therefore, it's a non-justiciable issue in this and in the district court. What has happened in this case is...
Did you argue that to the district judge?
I believe we argued the non-justiciability argument. Yes, sir. I know we did. But if you're...
Your position is that the issuance of a subpoena jus tecum is not a justiciable issue.
In this context at this time, sir, what has happened is this. As you know, on February the 24th, a grand jury secretly named the president, among others, as an unindicted co-conspirator. That fact was not made known. On March the 1st, an indictment was returned against a number of the president's chief aides. Coincident with that, and in an open courtroom, the assistant prosecutor, special prosecutor, handed up to the judge a bag together with a sealed letter requesting that this material be sent over to the House of Representatives. The president took no position regarding that proposal because he considered it to be probably appropriate, under the belief that there was nothing accusatory in that material. Judge Sirica himself reviewed the material, found nothing accusatory, and said it would therefore be quite appropriate to send this material to the House of Representatives, not realizing and not knowing that the special prosecutor had previously obtained a secret charge against the president and others, which was definitely accusatory.
As I understand it, was not among the material that was conveyed to the grand jury. There seems to be, if I'm... At least that's what I understood Mr. Jaworski to tell us this morning.
The material that was turned over was before the grand jury.
Now, just a moment. I understood Mr. Jaworski to tell us this morning, very unambiguously and explicitly, that the fact that the president was named as an unindicted co-conspirator was not conveyed to the grand jury.
It was the grand jury's
to the House of Representatives. To the House of Representatives.
No, it was not. The material was sent to the House of Representatives in the belief that it was non-accusatory in nature. It was simply a recital of fact.
Exactly, and that's what Mr. Jaworski has represented again to us this morning, was the fact of the matter.
But Mr. Jaworski had available to him, unknown to the judge and unknown to counsel for the president, a secret indictment naming the president as a co-conspirator. The accusatory part followed later.
Now, followed in what form?
By a newspaper leak.
Yes, it wasn't sent from the court over to the House.
It didn't have to be. All they had to do was read the newspaper. There can be no question about it. And therefore, I say, this case has to be viewed realistically in the context that it is now being heard.
I'm not sure. Perhaps you can help me. Are you suggesting that there was some duty on the part of the special prosecutor to disclose to the district judge that there was this secret indictment before the judge passed on whether the material should be sent to the House?
I think it would have been quite appropriate because the judge's decision was based on the proposition there was nothing accusatory, that under the circumstances absolute fairness was appropriate and required insofar as the president was concerned. No one could argue that the indictment as a co-conspirator or naming as a co-conspirator does anything but impair the president's position before the House of Representatives. That should, in my judgment, have been made known to the judge. I don't know what he would have done under those circumstances. His decision was based solidly on the proposition there was nothing accusatory in the material. Now, my brother says in his brief that this material he now seeks, of course, will be available to the House committee and will be used to determine whether or not the president should be impeached. So this fusion is going to continue. And under the Constitution as we view it, only the legislature has the right to conduct impeachment proceedings. The courts have been, from the history involved and from the language of the provisions, excluded from that function. And yet the special prosecutor is drawing this court into those proceedings, inevitably and inexorably. No one could stand here and argue with any candor that the decision of this court would have no impact whatsoever on the pending inquiry before the House of Representatives concerning the impeachment of the president.
Well, how far does your point go? Let's assume that a murder took place on the streets of Washington, of which the president happened to be one of the very few eyewitnesses. And somebody was indicted for that murder, and the president was subpoenaed as a witness. Would you say he cannot be subpoenaed now because there's an impeachment inquiry going on, and the courts absolutely have to stop dead in their tracks of doing their ordinary judicial business?
I would not say that. I don't think he could be necessarily subpoenaed. I don't think the president is subject to the process of the court unless he so determines he would give evidence. But the murder would have, in this case...
You're saying that the courts, as I understand it, have to stop dead in their tracks from doing their ordinary business in any matter involving, even tangentially, the President of the United States, if, as or when, a committee of the House of Representatives is investigating impeachment.
No, Justice Stewart, I'm not. The subject matter of these two matters is the same subject matter.
Well, here are
Should the president...
7 people have been indicted, 6 of whom remain under indictment. A trial is scheduled for next September 9th.
Right.
The prosecutor is preparing for that trial. He's trying to, under Rule 17 of the Federal Rules of Criminal Procedure, to adduce matters to be used in evidence at that trial. You say that cannot go forward because of some tangential effect, or you say a direct effect, upon some other matter going on in another branch of the government. And how far does
I say it should not go forward at this time at the very least, because the subject matter being inquired of in large measure before the House committee is exactly the same subject matter being involved in this argument.
How do we know?
Namely, should the president produce tapes?
Well,
should he
what
not
in
stand on
these tapes involves the impeachment procedure?
Pardon?
What in any of these tapes is involved in the impeachment procedure?
Well, if Your Honor please, the House of Representatives have subpoenaed
Well, I don't
these
know
and
what's
more
in them.
tapes.
I don't know what's in the tapes. I assume you do.
No, I don't.
You don't know either. Well, how do you know that they're subject to executive privilege?
Well, I do know that there's a preliminary showing that they are conversations between the president and his close aides.
Regardless of what it is.
Regardless of what it is, it may involve a number of subjects.
But does not the special prosecutor claim that the subject matter is the same?
He claims that, but he has no way of showing it. In fact, he says it's only probable or likely. He has no way of showing that they, in fact, involve the subject of Watergate.
His claim is honored, but this court, all that would happen would be the evidence would go to Judge Sirica, who would examine it in camera.
I presume that's so, and it would be made available to the special prosecutor. The special prosecutor says that, of course, this would then become part of the impeachment proceedings, and there we are.
Mr. St. Clair, going back to this murder witness situation, if the president, any president, witnessed an automobile accident and was the sole witness, or a murder, as Mr. Justice Stewart suggested, you're not indicating that his testimony, his evidence, would not be available to the court, but merely that he can't be subpoenaed, but might give it by deposition, as several presidents have.
That is quite correct. That is quite correct.
The testimony of justices of this court has been given in past times by deposition.
Really as a matter of accommodation, not as a matter of assertion of a right of one branch over another. But the point I want to make, Justice Potter, is that the same subject matter is inextricably involved in both proceedings, now proceeding on at the same time. And, the House of Representatives has not sought...
Why are you willing to give up 20-something?
Well, that's a very good question I'd like to answer. The decisions that are made in an impeachment proceeding, Justice Marshall, are essentially political decisions.
Oh, I'm talking about in this case. You say you'll give up 20 of them in this case.
Yes, we will, because they've already been made public.
The tapes or transcriptions?
We are, as soon as a judge approves some method of validating the accuracy of these tapes, they can have the tapes. But you have to understand, a tape is a part of a reel. A reel may cover a dozen conversations. So there's a mechanical problem of trying to validate or be sure that this is correct. But it's only a mechanical problem. But once that's solved, subject to the judge below's approval, they have the availability of that.
Would the tapes that you're willing to release be valuable to the Watergate Committee in Congress?
We think so. That's why we made them.
Well, I thought you said you didn't want them to have anything.
No,
that
sir.
This was merely an evidence, a way of getting stuff over to them, but you're going to get them some.
I say this. I say the president should decide as a political matter what should be made available to the House. That the court ought not to be drawn into that decision. The House takes a different view. The House has subpoenaed something in the neighborhood of 145 tapes. And that's a political decision.
So that the House can get them, the President can get them, and the only people I know can't get them is the court.
The President has not honored any of the subpoenas other than the first one issued by the House. So that there is a dispute in the House now between the President and the Committee on the Judiciary. It's essentially a political dispute. It's a dispute that this court ought not to be drawn into. And this result of a decision in this case would inexorably result in being brought into it.
You haven't persuaded me that we're drawn into it by deciding this case. How are we drawn into the impeachment proceeding? By deciding this case?
The impact of a decision in this case, undeniably, Mr. Justice Brennan, in my view,
well, any number
cannot have, it will not be overlooked.
Any number of decisions of this court has...
but I would think it would be an inappropriate thing to do at this time because there is pending...
Well, that's a different thing. You've been arguing we have absolutely no authority constitutionally to decide this case.
I will argue that in a moment, but I'm arguing now only that you should not. I'm arguing now, sir, only that you should not, because it would involve this court inexorably in a political process which has been determined by the Constitution to be solely the function of the legislative branch. And it cannot be that the impact of this court's decision in this matter, which is one of the principal matters now pending before the House, would be overlooked. It would certainly, as a matter of realistic fact, have a significant impact.
But as I said before, we have the beneficiaries here are 6 defendants who are being tried for criminal charges. And what the President has may free them completely.
Mr. Justice Douglas, it may. The Brady issue, we don't believe, is properly before the court. It has not been briefed by us nor by my brother.
Not decided by the district.
And was not decided by the district court. I would only say this, that in the experience that I've had in connection with cases tried, such as the Stans-Mitchell case in New York, the Chapin case in Washington, the Ehrlichman case now going on, there has never been a claim that the President has not made available appropriate and adequate Brady material. But I don't believe it's before this court at this time. What is before this court is a prosecutor's demand for evidence. And I direct my remarks for a moment to that problem. He says that, in effect, we have no right to be here, that we have delegated the who, the when, and with what issues to him. We have delegated the who and the when, and pursuant to that, he has indicted a number of people, and he has indicted them at such time as he thought appropriate. But even he contends that we did not delegate to him what presidential conversations would be used as evidence. That was reserved, and he concedes that that is the fact, and that's what it's issue here, not when and who is to be indicted, but what presidential communications are going to be used as evidence. And that's what the issue is in this case.
Mr. St. Clair, you left me in a little bit of doubt about this mechanical problem. I think perhaps we diverted you from it. Are you suggesting that on a given tape, which is a real type of thing, having an hour or more of material, or maybe several hours?
Or 2 or 3 days.
2 or 3 days, oh, I see. That the first 3 hours might be the material which has already been transcribed and released. The next 3 or 4 hours might be a conference with the Joint Chiefs of Staff or the Chairman of the Atomic Energy Commission on the program to give underdeveloped nations, for example, aid for peaceful uses of atomic energy. Matters totally irrelevant but confidential. Is that your argument?
It's my argument and the fact. For example,
well, and you want some mechanism set up so that these things can be screened out.
They have been screened out in the transcripts. Whatever has been published to the public, we are quite prepared to verify the accuracy of. Now, in the course of those transcripts, there are first portions left out.
Have you at any time tendered or proffered a statement that a particular tape from 18 minutes after 11 until 3 o'clock that afternoon, including the lunch hour, included a conference with the Secretary of State, the Secretary of Defense, and someone else having to do with totally unrelated matters. Has that kind of a tender been made to
No, we've simply published the portion of that conversation that did not relate to that with the notation that a portion has been left out.
But no explanation of why it's left out.
It was left out because it did not involve presidential action as it related to Watergate or something to that effect. We did not disclose the substance of that left out material.
Is there any particular reason why at least the identity of the conferees could not be made?
There might well be such a reason. My proffer to my brother has been that we will verify the accuracy of the printed transcript. So this 1,240-odd pages of presidential conversations that are available to the public and available to him will be usable in the trial. Now, this may well involve a mechanism approved by the court involving counsel for the defendants to be satisfied, so that they're satisfied that the copy is accurate. But this all has to be expurgated out of a reel of tape that may involve several days' conversation. But it's essentially a mechanical problem.
But in the tapes that they asked for in this subpoena, this is taken, which is the only thing before us, has any effort been made to say what, if any, part of that can be released?
Other than the 20 that are already published, no effort has been made as yet, sir.
Why not?
Because, if Your Honor please, we haven't felt that it's been necessary to do so, because we firmly feel that the President has every right to refuse to produce those.
You don't think that a subpoena, these are taken, is sufficient reason for you to try?
But we moved to quash...
You just ignored it, didn't you?
No, sir, we didn't. We moved to quash it.
And the difference between ignoring and filing a motion to quash is what? I want his answer. What?
Well, if Your Honor please, we are submitting the matter...
You're submitting the matter to this court.
To this court under a special appearance on behalf of the President.
You're still leaving it up to this court to decide it.
Well, yes, in a sense.
Yes.
In a sense.
No, well, in what sense?
In the sense that this court has an obligation to determine the law. All right? The President also has an obligation to carry out his constitutional function.
For us to decide whether or not executive privilege is available in this case.
Well, probably the question is even more limited than that. Is the executive privilege, which my brother concedes, absolute, or is it only conditional?
I said in this case. Can you make it any narrower than that?
No, sir.
Well, do you agree that that's what's before this court and you're submitting it to this court for decision?
This is being submitted to this court for its guidance and judgment with respect to the law. The President, on the other hand, has his obligations under the Constitution.
Are you submitting it to this court for this court's decision?
As to what the law is, yes.
If that were not so, you would not be here.
I would not be here. Now, my brother says, I have no right to even challenge his right to be here. And I'd like to deal with that for a moment. This is, as we point out in our brief, essentially an executive department matter. Whatever may have been the arrangements between the branches of the executive matter with respect to evidentiary matters, and in fact there were no arrangements regarding evidentiary matters, it is not the function of the court to direct or rule what evidence will be presented to it by the executive and the executive's duty of prosecuting. If this was a United States attorney, this case wouldn't be here, of course. It's here only because certain things were delegated to the special prosecutor. But the special prosecutor was not delegated the right to tell the President what of his conversations are going to be made available as evidence. That was specifically reserved, and the only thing that my brother can do is argue about it, and that's what he's doing right here today.
Now,
therefore,
why wouldn't this case be here if it's for a United States attorney? I think I agree with you, but I'd like to ask you.
Well, the United States attorney would be directed.
By whom?
By the President.
I thought
or the Attorney General at the direction of the President.
Was the one who directed the United States attorney.
Well, by the Attorney General at the direction of the President.
Well, no. In the normal case, the President doesn't know anything about mine-run federal prosecutions. That's fair to say, isn't it?
I think so, but most cases don't involve presidential
And in fact, in mine-run cases, the Attorney General doesn't know much about them.
I think that's so.
But let's just a moment.
With all due respect.
Right. So a United States attorney brings a prosecution, and in the course of that prosecution, he, before trial, subpoenas under Rule 17 of the Federal Rules of Criminal Procedure. He subpoenas material in the custody of the President. So what happens?
The President says to the Attorney General, I'm not going to produce this material.
No, well, it's the United States attorney subpoenaing it under your hypothetical case.
That's right.
And so what happens?
And the President, in my view, the President would instruct the Attorney General to instruct the United States Attorney to withdraw his motion.
And the United States Attorney says, I'm not going to do that because
we'd have a new United States
sworn to
Attorney.
uphold justice. And, well, now, how would you have a new United States Attorney?
Well, I'm being a little facetious. And
I'm being serious because
I think that United States Attorney, in all respects, would and should be removed from that case. The executive power of the government is not vested in the United States Attorney. It's vested in one man, and that man is the President of the United States.
By statute, it's vested in the law enforcement is vested in the Attorney General.
Yes, but that statute, which my brother cites in his brief, does not deprive, nor could it deprive, the President of his constitutional authority to be the chief law enforcement officer. He shall take care to see that the laws are enforced. The executive power is vested in him, in one man. And the Attorney General is nothing but a surrogate for the President of the United States.
But I'm afraid your argument would be is a very good one as a matter of political science, and it would be a very fine one as a matter of constitutional and probably statutory law, except hasn't your client dealt himself out of that argument by what's been done in the creation of the special prosecutor?
Perhaps,
as you've just pointed out,
perhaps
the
as
special
to everything,
prosecutor is quite different from a United States attorney.
Right. Perhaps with respect to everything except the President did not delegate to the special prosecutor the right to tell him whether or not his confidential communications should be made available as evidence. So that within the package of executive powers, normally represented by the executive department as to who shall be prosecuted, that's been delegated to this gentleman. He's exercised that power. When? He's done that. With what evidence? He's done that, as we'll deal with in a few moments. But not with that portion of the evidence that's available that constitutes presidential confidential communications. That's been specifically reserved. And the special prosecutor cannot, and even if the President did give him that authority, probably could not, as a constitutional matter, delegate that. But in any event, he did not.
What? He could not.
The right to order the President to give up confidential communications. That was not delegated.
Not the unfettered right to get it, but the right to go to court and ask a court to decide whether or not he's entitled to it.
Right, and the President, under no circumstances, gave up any of his defenses with respect to that.
And you're making those defenses
and
right
I'm making them right now. And even if we did agree between us that we would vest this court with jurisdiction, simply because of the politics of the situation, this court, by all of its decisions, would not accept the vesting of such jurisdiction.
Well, why not?
Because this court determines its jurisdiction. The parties can't agree that it has it.
Yes, but and if surely you're right, as I say, a lawsuit between the Secretary of Commerce, for example, suing the President over a matter of executive policy, we both agree would be unthinkable. And since any cabinet officer is the creature of the President who appointed him, the answer would be you're fired. If you want to.
If it goes that far.
If it goes that far.
That's right.
But aren't we here met both factually and, I suggest, legally with quite a different situation?
I think not in the terms of separation of powers, if I may. My brother's point of view is he views himself as the United States as distinguished from a member of the executive branch. And in his brief, he invokes the United States as really a fourth entity.
Well,
constitutionally, a special prosecutor with the powers that my brother suggests he has is a constitutional anomaly. we have only 3 branches, not 3 1/3 or 3 1/2 or 4. There's only one executive branch, and the executive power is vested in a president. Now, if for political reasons the president wants to dole out some of those powers, he may so do, and has done in this case. But he cannot vest jurisdiction on a court that otherwise the court would not have, nor should the court accept jurisdiction.
But hasn't your client also inhibited himself from the ultimate sanction that you suggested he could impose with respect to your hypothetical United States attorney, i.e. the sanction of dismissing the special prosecutor?
That is
and
correct.
As a matter of law,
That is
regulations that have the force of law.
That is correct. And he has not been dismissed.
And until or unless he is,
nor is he likely
we
to
have
be.
a case or controversy of a very real kind.
The point is, if I may make it, the only issue here is whether the president gave up his right to protect the confidentiality of his conversations.
Certainly.
No claim is made that he did.
You're a living testimony of the fact that he did not give up his right
And my
to
brother
defend his
concedes.
position in court.
The very fact that the delegation to Mr. Jaworski gave him the right to contest the president's claim of privilege presupposed that the president had a right to assert the privilege, not the right to assert it necessarily with complete finality. That's what we're really arguing about here today, isn't it? Now,
if we get beyond the subject matter situation, now if this were the Nixon against Sirica case, where you didn't have what I think is a dispositive problem in this case, namely the lack of jurisdiction in the judicial branch to determine this intra-executive branch. If we had a grand jury subpoena, as was true in the Nixon against Sirica case, then you have intra-branch, and the court would have a better standing in its responsibility to see the grand juries which are under its jurisdiction to have such evidence as they thought appropriate. But we're well beyond that stage. 17C requires a great, a much more restricted form of evidence. It's got to be relevant and admissible. It's nothing like a grand jury subpoena.
Mr. St. Clair,
yes, sir.
With reference to your point about whether there are 3 branches or 3 in some fraction, is not the Comptroller General something of an autonomous, fractional, more than a 3rd branch figure?
Well, I don't think that the Comptroller General represents, if Your Honor please, that the basic constitutional structure has been changed.
No,
it may be that he has executive and he may have legislative functions.
He may proceed with reference to the executive branch, and I would assume with reference to expenditures of the legislative branch, and without consulting either one of them. Is that not?
I understand. He is created by a legislature. It's very much like a semi-independent agency. Yeah. In one aspect, he's an agent of the legislature. In the other aspect, he's an agent of the executive. But we don't have any more than legislative, judicial, and executive branches.
But Mr. Jaworski, as I understand it, is claiming that he's somewhat like, not necessarily precisely like, but somewhat like the Comptroller General. That he may make decisions and that Congress cannot recall him short of I believe, a 15-year term for the Comptroller General. And the President, no President can fire the Comptroller General. And I suppose the court could not fire him.
Well, I'm sure the court couldn't. I'm not too clear about the President under the Myers case. I really haven't thought that much of it. It could be that he could be fired, but I think that's really somewhat beside the point, because this issue really turns on an admission that as to the element of the executive power here involved, namely presidential conversations, they weren't delegated. So whatever else may have been delegated, those were not. And this court has no jurisdiction to resolve a dispute as to whether or not they should be given up, because that would involve this court in the prosecution of the case, and the judicial...
Can this court decide what's necessary for a trial of a criminal case?
It can, sir, with respect to third parties, But it should not involve itself with the executive function of prosecuting the case.
My only question was that this is a subpoena ducis tecum that was issued by a judge, right?
Yes, sir.
Slightly judicial.
Entirely judicial.
And that's what's before us.
And that we moved to quash, because
But that's what's before us.
the denial of our motion to quash is one of the issues before us. That's right.
The only thing before us is whether or not the subpoena should issue.
I guess it's about the same thing as whether or not it should be quashed. I think that amounts to the same thing.
So that's not political.
Well, it is not in the context of the proceedings here, but in the context of what is in fact involved in this case, it is, I suggest, political, in the sense that this information being sought, admittedly, will become available then to the House.
Well, when you mean political, well, I don't see where the House has got anything to do with the point that I'm talking about. You said this is political and not judicial. And I submit it could be judicial because it involves the issue of subpoena.
Well, the question is it a proper issue of a subpoena?
That's right.
Judges make mistakes, as do lawyers, and maybe even presidents, for all I know. But the point I want to make with you, sir, is that this is an executive function, an executive decision, one not delegated.
Well, the executive function, as I understand your discussion, as to whether you should voluntarily turn them over to the special prosecutor. We are past that stage. We are now at the stage where the prosecutor has asked the court to assist him, and the court has assisted him. Does that not take it a step beyond pure political or executive?
We submit that the court improperly assisted him, that the court has no right to determine what the executive will offer in evidence.
Now you get that. I see.
And this is the function of the president. No one has contended that the president has given up his executive responsibilities under the Constitution, and certainly the prosecution of criminal cases is an executive function.
And that's absolute. Now you're arguing absolute privilege.
Yes,
absolute
sir.
Executive, even though every day or so you issue other ones.
I beg your pardon?
You turn tapes loose every day or so, don't you?
No, we don't turn them loose every day, but we have turned a number loose in the president's discretion in which he thought was the appropriate thing to do. And that's his determination that governs, we suggest.
And you get ready to turn 20 more tapes loose.
No, these would be repetitious, Your Honor, of what already has been made public.
Well, I thought you said in your brief you would turn 20 loose.
Well, those would be the tapes of 20 conversations already made public.
And you release those tapes.
We'll provide a means whereby their accuracy can be verified. To release a whole reel of tape involving a number of conversations poses a mechanical problem.
You're still saying the absolute privilege to decide what shall be released and what shall not be released is vested in one person, and nobody can question it.
Insofar as it relates to the presidential conversations, that is correct, sir.
But you're now dealing,
that's another issue,
Mr. St. Clair, with the jurisdictional question. And as I further understand it, that argument of yours, at least I got it from the brief, involves at least two separate concepts, and maybe three. One is that this is an intra-branch dispute, and that argument would be equally valid under the analogy you use in your brief if this were a dispute between, let's say, two committees in one of the houses of the Congress, and one committee sued the other for jurisdiction of a particular matter. You suggest, and probably quite correctly, that that would not be a matter for the judiciary to determine. That's one argument, that this is purely an intra-executive branch controversy, as it would be between two congressional committees. This is intra-Article 2 branch. The hypothetical case would be intra-Article 1 branch. That's one argument. And then you have quite a separate argument, it seems to me, i.e. that the president, constitutionally, is the chief prosecutor, since he is the executive, and that it's not for the courts to decide what a prosecutor shall use in prosecuting a criminal case. Now, aren't those two separate arguments? You make both of them under this rubric.
That's correct, sir. I don't know how separate they are, but I certainly make them both of them.
It seems to me they're quite separate.
But I'm making both of them, and if they're separate, fine. Now, with respect to...
Well, the second argument would have no relevance at all to your analogy of the legislative branch.
Well, I don't want to mislead the court into thinking that I believe Mr. Jaworski has no right to determine any evidence that he can use.
But ultimately, you tell us that it's constitutionally the president as chief executive, and therefore as constitutionally the chief prosecutor, or whatever the statutes might provide, has unrestricted discretion to determine what evidence he will or will not use in prosecuting a case.
That is correct.
Which is quite a different concept from the other concept. You make them both under the same rubric, as I say, but it seems to me they're quite separate arguments.
And I think they're well-founded in the law.
I know you do, or you wouldn't make them.
Now I'd like to move, if I may, to briefly the suggestion that the issue here is non-justiciable on the grounds other than I've already mentioned, namely the context in which this case unfortunately now finds itself. It seems to us, briefly, that the case is non-justiciable for somewhat more technical reasons. First, this is an issue where someone has to exercise some discretion. There are no real bounds or standards by which that discretion should be exercised, and by traditional standards of this court, where that exists, then this court ought not to take the case. Secondly, it seems to me there is a textual constitutional grant if we assume that the grant of executive power includes the means by which that can be effectively exercised. A second ground. Third, of course, there is the political involvement which I have suggested. Therefore, I suggest quite briefly that even if there is subject matter jurisdiction, the case is non-justiciable for these additional reasons. The standards of Baker and Carr and Powell are not applicable here. There's no individual's rights who are being protected against the onslaught of government. The president is not here as an individual. He's here as a constitutional officer in whom the executive power is vested. There is no philosophy that would support a finding of justiciability on the grounds that we're strengthening the democratic process, as was true in Powell and also to a greater extent in Baker and Carr. If anything, a decision in this case against the president would tend to diminish the democratic process. This president was elected on the theory that he would have all the powers, duties, and responsibilities of any other president. And if it's determined that he doesn't, there is a certain amount of diminution of the political aspect of the case, insofar as the constituents who voted for him are concerned. This president ought not to have any less powers than any other president ought to have. And one of the necessary results, as I view it, of my brother's argument is that because of the circumstances of this case, Richard Nixon is, let's say, an 85% president, not a 100% president. And that can't be constitutionally. The framers of the Constitution had in mind a strong presidency. As we know, they considered a number of alternatives, maybe a presidency consisting of 3 members. All of those suggestions were discarded, and a strong presidency was decided upon, may I say, to the distinct advantage of this country as history has developed. Now, by reason of an action of a grand jury, the special prosecutor suggests that this president has something less than any other president would have. I would only call your attention to the action of the framers in the Constitutional Convention when the issue was raised as to whether or not a president who was under impeachment should be suspended during the pendency of the impeachment proceedings. And the decision was definitely he should not, because the framers envisioned a strong, active president, even in the course of impeachment proceedings. They did not want this country to be led by someone who didn't have those full powers, even if he were then under impeachment. And indeed, this president continues to function as president, as he should, even though there are impeachment inquiries underway.
Mr. St. Clair, if I may interrupt you again, is what you're telling us now directed to your point that this is a non-justiciable political question, or is it directed to your point that that executive privilege is absolute and that the determination of it is to be made?
I think it involves both. It's non-justiciable, if I may, because it does involve the court in a political matter. Now, the mere fact that politics is involved, of course, has not prevented the court from taking action in appropriate cases where individual rights are involved or where the franchise of voters could be strengthened by a decision in the court. I'm suggesting in this case the converse is true. Therefore, the justification between in Baker and Carr and in the Powell case is not available or not applicable here. Furthermore, however, the argument still, in my view, has force with respect to the consequences of the grand jury action in naming him as a co-conspirator, which we suggest they were not qualified to do. The President is not above the law by any means, but the law as to the President has to be applied in a constitutional way which is different than anyone else. Namely, we suggest that he can only be impeached while in office and cannot be indicted until such time as he no longer is in office.
Well, let's assume we accept that proposition. What follows from it?
Well, then the naming of the President by a grand jury as a co-conspirator, if that has the effect of diminishing the President's rights, it's a pro tanto, if I may say, impeachment.
I should think you could run the argument the other way, saying that since the President cannot be indicted, then all that can happen to him is that he can be named as an unindicted co-conspirator.
That could be said, but by the naming him of an unindicted co-conspirator, we suggest, is an intrusion by the grand jury on a function that is solely legislative and not judicial.
Well, a president could be sued, could we, for back taxes or penalties or whatnot?
Well, in questions of immunity, I think individually he could be.
The Constitution speaks of persons, any person.
That's correct. I think the President could be sued for back taxes in his individual capacity. But in terms of his power to effect the responsibilities of his office, to protect the presidency from unwarranted intrusions into the confidentiality of his communications, that's not a personal matter.
It may be, and one of these defendants might be completely exonerated from something in one of those tapes.
As I've suggested, that if that defendant will satisfy a court that there is such a tape and will identify it or even come close to it and persuade a court that that would exonerate him, or there's reason to believe it might, I don't believe we'll have a question. But that's not what my brother here is asking for. He's asking for a set number of tapes, not for Brady purposes, although he throws that in, but he really wants them, he says, for prosecution. And I'd like to review with the court the question of the necessity shown for this, because even on his theory of a qualified privilege, there has to be a showing of some necessity. Now, we should understand, I'm sure the court knows, that all of these individuals here involved have testified before the Senate Select Committee, with the exception, I believe, of Mr. Colson, who now has pled guilty under a plea bargain where he's agreed to cooperate, so the special prosecutor has the full benefit of his testimony. They have testified on one or more occasions before a grand jury. In addition, the President has furnished to the special prosecutor the transcripts and tapes of the critical conversations involved in this alleged conspiracy, and I might review those very briefly with you. Mr. Dean, in his Senate committee testimony, suggested that on September the 15th, the President acknowledged knowledge of a cover-up. He changed that later to testimony that he believed that was so, or it was an inference. But in any event, the President furnished that portion of that tape of the conversation with Mr. Dean. Mr. Dean also testified that on March the 13th, 1973, he discussed the cover-up with the President and efforts to blackmail the President by one of the defendants who broke into the Democratic National Headquarters. Later it developed that that was mistaken, that it was actually on March the 21st, and the grand jury indictment proceeds on the theory of March the 21st. The tape of the conversation on March the 13th was furnished. All of the conversations between the principals, being 2 in number, on March the 21st were furnished. The conversation between the individuals and the president on the next day in the afternoon, March the 22nd, was furnished. And a large number of additional conversations were furnished. Now, if Reynolds means anything, and Reynolds, in addition to the Kaiser aluminum case, noted a constitutional question, as I think one of the learned justices suggested, one of the reasons for not facing that issue in that case was it was not necessary, because in the case there was a crash of a bomber that was on a secret mission, and the court said that the parties had the testimony of the witnesses, the survivors, and other testimony, so it wasn't necessary to get to the constitutional question. I suggest that that's true here. It's difficult for me to conceive a prosecutor who has more evidence than this prosecutor has. He has the full benefit of a Senate Select Committee investigation, which staff had 50-odd lawyers, existed for a year. He has the benefit of his own investigation, of a grand jury that sat for 19 months, with an investigative staff of similar proportions. He simply says, I need this because I want to present all of the evidence in the case. He does not say...
You suggest then that even if the prosecutor could get this from a normal third-party witness, he can't get it from the president because of executive privilege, that there must be a further showing beyond the relevance showing of 17C.
Well, as we point out in our brief, a tape of a conversation is very raw material.
Your answer is yes, isn't it?
Yes.
That there is a further showing necessary.
That's right. Does he really need this? What does he say he needs it for?
But how does a district court go about deciding a question like that in advance of trial, unless the prosecutor lays out his entire evidence and says, it's my judgment that this is evidence. Without this evidence, I might lose the case.
He doesn't say that. He made a showing to the court below. The showing is available to you here.
But you would suggest that he would have to do that.
He has the burden. He has the burden under Reynolds, under Kaiser aluminum, and so forth, to show that he needs it. And what does he say he needs it for? He doesn't say he needs it to obtain conviction.
Well, Mr. Secretary, while I've got you interrupted, I want to ask you something else.
Yes, sir.
And it's related to this. No matter how absolute the executive privilege is that you claim on behalf of the president, I assume you're talking about conversations to which the privilege would apply.
Yes.
Now, is it...
We have to make such a showing, and I say that's our only burden.
You wouldn't suggest that every conversation the president has while he's in office would be subject to executive privilege.
No, it has to be a confidential communication.
Well, it has to be in the course of his duties as president.
Yes, but it's president
carrying out his duties as president under the Constitution.
Yes, sir.
Now, I don't suppose if he was talking with one of his aides, Mr. Holden, Mr. Ehrlich, went about an investment of his out in California or some other place.
Or a tennis game or whatever.
Yes, you wouldn't suggest that...
And my brother doesn't suggest that's what he wants either.
Well, how about conversations about a campaign, about the next campaign? Now, that's hardly
that gets a little closer.
No,
The president is a political office, too.
It isn't very close to executing the laws of the United States, is it? He's running a political campaign.
I don't think it's very close, no.
And so conversations about that subject matter.
My brother isn't seeking any such conversation.
Well, I know, but shouldn't the president have to say, at least, even if the privilege is as absolute as you say it is, shouldn't he at least have to say, I believe or assert that the executive privilege applies to this tape because this conversation is in the course of the performance of his duties as president?
Well, as I read some of the cases...
You haven't done that either, have you?
We have not done that. We've simply responded to an assertion that these all relate to Watergate, assuming that to be the fact.
Would you automatically say every conversation about Watergate is in the course of the performance of the duties of the President of the United States?
I would think it would be, yes, sir.
Why is that?
Because he has the duty, A, to enforce the laws, that is to prosecute these cases, and B, he had to take care to see that the laws are enforced, that is to investigate them. And much of this material does relate to the investigation, as 1,200 and some pages of the public transcript fully discloses. But I would be ready to concede, and I don't think it's a difficult problem between us, that the President should show that the circumstances are appropriate for the claim of such a privilege, and I think such language appears in Mink and perhaps even in Reynolds and in Kaiser Aluminum. Simply, it has to be a confidential communication, first of all.
And how about, do you concede, or what is your view of the privilege with respect to whether it reaches factual assertions in a conversation? The difference that was made in the Mink case and in others with respect to opinions and judgments as distinguished from facts.
Of course, Mink, I believe, was a statutory case. Well, that was one of the exceptions.
So what is your view? Would you say that if a conversation is merely a recitation of fact, it is still covered by executive privilege?
Yes, it is. If it's confidential and it's between the President and some advisor with respect to him, because otherwise...
That hasn't got much to do with the decision-making process, just pure cold facts.
It might well have to do with the decision-making process if the facts are such as were developed in the course of an investigation with regard to the existence of a obstruction of justice charge, much of which the President was involved in. But the fact against opinion decisions really relate to another situation, as I suggest in the statute. But the conversation that the President has with his advisors, we suggest, is absolutely privileged. It's a discretionary matter that he has to exercise in what he's going to release and not release. And since Marbury and Madison, Mississippi and Johnson, it's been clear that the courts will not direct a president to exercise his discretion in any manner. This is not to say that the courts won't strike down, as in Sawyer, excessive action on the part of the president, or excessive action on the part of the legislature. That has happened a number of times. But it's a far different thing to suggest that the court should undertake to direct the president to exercise his discretion in a certain manner. It's not a ministerial duty by any means. It's a matter of discretion. There's some things he feels he properly should, under the circumstances, make available, and others he shouldn't.
The discretion in that particular instance, one here, involves the relevancy of materials to a criminal trial. And that normally has been a part of the judicial power under Article 3, not the executive power.
I'd like to discuss very briefly Gravel, if I may, for example. I think this raises a very important question. There is, of course, an explicit speech and debate immunity provided in the Constitution. As our brief indicates, the reason for this is quite clear. It's to protect the legislature from unwarranted invasion from the executive and perhaps even the judicial. Does not mean that the executive is not entitled to substantially the same thing by implication. And at least in the civil field, as we've pointed out, the courts have worked out by implication as a necessary ingredient to the function of the duties of the executive an absolute immunity from civil liability for actions taken within the sphere of the official. Spaulding and Vilas, I guess, is the leading case, cited Barr, Mateo, and other cases. If such a matter can be worked out with respect to the executive on civil matters, we suggest there is no reason why, and in fact the court should spell out a similar exemption in criminal matters, especially as they relate to the president himself, because while I said the president is not above the law can only be made applicable to him in a certain way while he is in office. Now, if a junior congressman can commit a crime on the floor of the House as apparently as possible under Gravel and Johnson, is it to be said that the President of the United States has less immunity than a junior congressman? I think not. So that I suggest to you that common sense and proper construction of the Constitution, implying within the grant of executive power all of those necessary ingredients to make it work to be effective, which would include immunity and criminal immunity. The President, we suggest, cannot be indicted, can't even be named as a co-conspirator, because that's an assumption of a legislative function under the Constitution. And therefore we suggest that even if this is criminal, the President is immune from the ordinary criminal process. He's not immune from process. But that process that's available to the President is the process of impeachment, which does not include the function of the judiciary branch. And therefore we say that if, under Gravel, a congressman is entitled to immunity even from criminal conduct for actions taken within the legislative sphere of his conduct, then it would be very hard to support a proposition that the President, as the chief executive of the country, is entitled to less.
Except they didn't put him in the Constitution.
Right, and the reason they didn't, sir, was it was not found to be necessary. They didn't put civil immunity in the Constitution either for the executive branch, and this court has found, of course, that there is such immunity. I'm sorry, sir. It was a speech and debate clause case, and it even forbade, as I understand the Gravel case, grand jury inquiry into motivations and actions of the senator and his aide.
Because the Constitution said so.
Right, and I suggest the Constitution, by clear implication, provides the same not only for the executive but for the judicial as well, but certainly for the executive.
And if we can't find it in the Constitution, what happens to your argument?
Well, I would suggest you should find it in the Constitution. It need not be explicit. It can well be implied.
The question is, if we can't find it, what happens to your argument?
If you cannot find it.
Yes, sir.
Then, if Your Honor please, that portion of the argument is lost as far as this court's concerned, I guess.
You haven't lost your other point, which is this court can set up the same kind of privilege that they've set up in other ones.
That's correct. And we're suggesting that it should in this case. Not necessarily because a great deal is now left to be gained by expunging the grand jury action. My brother is right. The damage has been done, and we think quite improperly so. We think the tactics involved with the prosecutor in seeking to make enlarging the scope of admissible testimony is hardly worth what has been done here, but it's been done. But it seems to me history would be served by granting the relief we have prayed for below, namely to expunge this. Secondly, it seems to me the American people would feel better about the fairness of the issues now pending before the House if this act, which we say was improper and illegal, were expunged. But insofar as the mechanisms of this case are concerned, it destroys or removes a basis upon which they contend they are entitled to these documents. And I'd like to address that for a moment.
We've been asked many times to do that in other cases respecting grand juries. Up to date, I don't think we've ever come anywhere near doing it.
And up to date, you've never had a President of the United States named as a co-conspirator either, sir.
That's very true.
And the President of the United States, and I don't mean to be facetious about it, but the President of the United States, we suggest, can be proceeded against only by impeachment while in office. And his powers are unabated until such time as he leaves that office. Now, with respect to this suggestion that a grand jury finding is prima facie evidence...
That, of course, never been decided either.
No. This case is unusual in many respects. This suggestion that a grand jury finding is prima facie evidence, and therefore the President has lost whatever privilege he otherwise would have had, isn't borne out by either the facts or the legal issues and principles involved. A grand jury finding is not prima facie evidence. Even if it's mentioned in an opening argument in a criminal trial, there's a grave risk of a mistrial. The cases cited by my brother, particularly the Clark case, are clearly cases which require a showing in court, or in Clark, a showing to the judge that there was prima facie evidence of wrongdoing. You may recall that's a case involving an investigation into a juror, as to whether or not the juror had performed properly, and the juror, it had been shown, had testified falsely in the qualifications that she had never had any business relations with one of the parties, when in fact she had. The court said, well, there's a finding of wrongdoing, and based on that, now I will look into the juror's deliberations to see what she did. But Justice Cardozo made it very clear that if he hadn't been able to make a prima facie showing of wrongdoing by evidence before him, there would have been no cause for letting in the light, as he put it. And the Ewing case and other cases, in which are relied on by my brothers, are all cases where there was a prima facie showing in a courtroom. Now, a grand jury charge is not prima facie. In the first place, it's only accusatory. It's not even admissible in, nor can it be referred to in a trial. Secondly, it can well involve incompetent evidence, as this court recently decided, and it's totally inappropriate to suggest that a president who otherwise would have a very valuable privilege, and I think I should emphasize the value of this privilege, because it is a valuable privilege. All you have to do is read Justice Reed's decision in Kaiser Aluminum, and he spells it out quite clearly, the importance and value of this privilege. To simply say to have a grand jury make a charge that destroys that privilege is an argument that I don't think can be sustained.
Mr. St. Clair, you have not mentioned in your argument a few moments ago on the question of the absence of any provision for immunity for judges or the presidents. You haven't mentioned the holding of this court in Pearson against Reid, where, as I recall it, the court assumed with a sentence or two that there was absolute privilege for the judiciary, but that the privileges of the executive, in that case, policeman, was qualified. The court had no difficulty in concluding that it did not require an express constitutional provision to spell out an absolute privilege for judges. These were state judges in that case, of course.
Well, if Your Honor, please, I don't believe that simply because the Constitution does not explicitly state the immunity, as it does in the Speech and Debate Clause, should this court hold it does not exist in criminal matters. I would like to make one point with the court, however, because I'm sure the point will be raised concerning Justice Kerner, for example. There's a distinct difference, as we point out in our reply brief as we view it, between a president of the United States, a single individual in whom the entire executive function is vested. A president serves 7 days a week, 24 hours a day, and only he, or those under him, performing his function, can exercise the executive function of our government. Now, if a congressman or a senator, or even if a judge,
or a vice president,
is removed from his duties, matters go on. But a president doesn't have that opportunity to take a vacation. It's vested in one individual, and deliberately so.
This is pretty far afield from the basic question here, which is the testimonial privilege.
We say it's a constitutional privilege.
Not prosecutorial immunity, but for testimonial privilege is what we're dealing with here.
That's correct. I think so. I would want to make the point with you that we think that the privilege we're arguing for is both common law and constitutional.
I understand that.
It's constitutional because it's inherent in the executive power.
I understand your argument.
And it's common law because it's always
matter whether or not a judge can be prosecuted criminally, or
it has to do with
nothing
questions
to do with
of immunity.
testimonial privilege, does it?
Well, my brothers seem to think it does, because they say because of the implications of criminality here, the president has lost something he otherwise would not have had.
I understand. May I, since I've already interrupted you, may I
please do
prevail upon your good nature a little more, Mr. St. Clair, to ask you whether it is your claim that any of these materials have to do with what have sometimes been called matters of state, i.e., matters of international relations or national defense. Mr. Jaworski assured us that they did not involve matters of state, but I would like to hear what you have to say about that, because, as you well know, both the commentators and court decisions have made a dichotomy between the privilege that exists with respect to ordinary general confidentiality on the one hand of the executive and matters of state on the other, to which a higher privilege has sometimes been thought to be accorded.
Well, I think if a higher privilege has been accorded, it should not, but in any event, the privilege of confidentiality is not unimportant. However, let me direct myself to your question. The answer to your question is no one knows.
But you
won't know until you listen to these tapes as to what subjects are discussed. My brother can only state that it's probable they relate, at least in part, to whatever he says, Watergate. Or it's likely that it might. And I've had the experience, for example, where circumstances were such that the House committee felt that it was likely that a conversation took place between the Attorney General, Mr. Mitchell, and the President regarding plans for surveillance of the Democratic Party. When you looked at the conversation, it wasn't there at all.
But in this case...
So I have no way of knowing, nor does the prosecutor know, what additional matters may be interwoven into these conversations. One thing is certain.
In believing Mr. St. Clair and understanding Mr. St. Clair that in this case, to date, no representation has been made by affidavit or professional representation or otherwise that any of these materials have to do with national defense or international relations.
No, and no representation can be made to the contrary either.
And that would be, therefore, a matter to be, under the existing order, now under review of Judge Sirica, that would be submitted to him later in camera.
If this court finds...
I say under his existing orders.
Yes, that's right.
Right.
And the President, presumably, if he were to comply with that order, would make such a representation in an appropriate case. But the fundamental point is that we believe, for the reasons stated, that the President's right to confidential advice is important, and it's actually fundamental to the proper functioning of his government. And in many instances, I suggest, is even more important than military matters or matters of state, so to speak. Because no matter what the conversation is, of course, it's the thought that it might become public that involves then this chilling effect that we've made reference to in our brief under the First Amendment, but as a practical matter. And I can see it myself. The communications are not free and open because who is to say that it won't be called before a grand jury? And most everyone in the White House has been called before a grand jury, sometimes several times. The FBI has interviewed every secretary that had any knowledge of any aspect of this case. This prosecutor has a plethora of information. He says he wants to try this case with all the evidence. Well, he knows better than that. Nobody tries any case with all the evidence. You'd be buried in minutiae. You select the evidence that you think most appropriate to your case. You don't try it with all the evidence. And this special prosecutor has mountains of
information.
information.
Who is to determine how much evidence a prosecutor needs? Only the prosecutor.
That's correct. That's correct. Not the court.
Don't you agree?
And if that evidence constitutes presidential confidential communications, then I suggest, if Your Honor please, the President determines that.
Many cases have been lost because the prosecutor had too much evidence.
Well, I suggest that's probably the fact here. So when my brother says, I don't need this evidence to win these cases, in my opinion, but I need them so I can present all the evidence. I've been trying cases long enough to know, and so has he. That's not what he's really after.
Yeah, I've tried a few too. But St. Clair, I was just wondering, where do you see the burden here is on the prosecution?
The burden under 17C is clearly on the prosecution. And the burden is clearly on the prosecution on every other aspect.
Right. And now, how much is enough for our phrase we've been kicking around, prima facie?
Well, I suggest whatever was considered by this court in Reynolds to be enough is more than enough in this case, We have the testimony of every individual involved. A number of them have pled guilty. Dean has pled guilty. Colson has pled guilty. Kalmbach has pled guilty, et cetera, all under plea bargains where they are under obligation to fully cooperate. This prosecutor is not, nor does he say at any point that he needs this information to prosecute successfully these cases.
Just to pinpoint another issue, let's assume for the moment that we didn't agree with you on your test of privilege, and let's just assume that the only issue that was left in the case was the 17C issue. Now,
then the president wins, in my view.
Well, because?
Because the prosecutor cannot show that the evidence he seeks is relevant and admissible. Because of the nature of the circumstance, he doesn't know what's in there.
Well, I suppose there are two parts to the question. One, how much of a showing does he have to make as to what might be on the tape? And secondly, if that matter that he claimed is on the tape, is that relevant and admissible under 17C?
We'd have to know what the matter was, what the issues in the case were, but under Bowman and Iosa, it's not enough to show that it probably is or might be or is likely to be. It must be shown to be relevant and must be shown to be admissible.
But
and that's why it's not a third-party
Mr. St. Clair, you can't put an impossible task on someone who wants a subpoena against a third-party witness or against anybody else as to showing what is precisely in some documents, I suppose.
Well, if you want to utilize a 17C, then I suggest that's what you have to do.
He's never listened to the tapes. He doesn't know precisely what's on them. You would say that he could never subpoena a tape unless he had already gotten it.
As a prosecutor, that's right. Well, as a grand jury, that's another matter. If he had sought these under a grand jury subpoena, we would then be directly faced with Nixon against Sirica, which we happen to think was improperly and incorrectly decided. But under 17C, we're dealing with a prosecutor's subpoena. The decided cases make it quite clear there must be a specific showing of relevance and admissibility. Now, if he can't do it because of the nature of the matter, then that's his problem, not mine.
The cases you're talking about are cases where a defendant sought discovery of evidence from or sought material in a prosecutor's file.
Most of those cases are, but there is at least one case, I think it's Grossman, that says the rules are equally applicable to the prosecution. It's cited in one of the footnotes in our brief. But a 17C subpoena is conceptually a subpoena for known information. Conceptually, if the prosecutor is looking for things, he should utilize a grand jury subpoena. In that case, I think in Bowman, they wanted the prosecutor to produce each document he was going to use in the presentation of his case. That's specific. It's obviously relevant and admissible.
So once he gets through with the grand jury, he shouldn't be using a subpoena to develop his case.
That's correct. And certainly not under these circumstances.
Do you think that's the practice in the...
I think it is the practice. I think that the grand jury practice is far greater than perhaps the Constitution has envisioned. It's really used today, frankly, as an effective discovery tool.
May I get back to what seems rather fundamental to me? Let us assume that it had been established that the conversations we're talking about here today did involve a criminal conspiracy. Would you still be asserting an absolute privilege?
Yes, quite clearly. And under the analogy with Gravel that I made.
Right, and as I understand it, the public interest behind that privilege is the preservation of candor in discussions between the President and his closest aides.
Quite clearly so. The simple reason,
right.
Sir.
May I follow that up?
I'm sorry.
What public interest is there in preserving secrecy with respect to a criminal conspiracy?
The answer, sir, is a criminal conspiracy is criminal only after it's proven to be criminal. And we're not at that point yet.
My question was based on the assumption that it had been established that the conversations did relate to a criminal conspiracy.
That is, the case has been tried and the defendant is found guilty.
Well, it could have been established in various ways. As you've just said, a number of people have already confessed, and these people were participants in some of these conversations.
But the fact that one defendant confessed does not make the other defendant guilty.
Of course. But anyway, your answer is that you would still...
First of all, the answer is yes, even if it is criminal, but more importantly, it is yes, because criminality is something that is not necessarily determined at the time that you must resolve the issue, and that you should not destroy the privilege in the anticipation of a later finding of criminality which may never come to pass. It is quite conceivable that a number of these defendants will be found innocent. And in fact, in theory, they are innocent right now.
What is the public interest in keeping that secret?
To avail the President, if Your Honor please, of a free and untrammeled source of information and advice without the thought or fear that it may be reviewed at some later time when some grand jury, in this case, or some other reason, suggests there is criminality. For example, it's very important... I'm sorry.
You did release him for the grand jury in this case.
Yes, in the President's discretion, he did that. And it's a discretionary matter. But for example, the simple matter of appointments, if I may, an appointment of a judge. It's very important to the judiciary to have good judges. It's not at all unheard of for lawyers to be asked their opinion about a nominee. Now, if that lawyer wants to be sure that he's going to be protected in giving candid opinions regarding a nominee for the bench, it's absolutely essential that that be protected. Otherwise, you're not going to get candid advice. Now, this isn't a state secret. It isn't national defense. I suggest it's more important, because that judge may sit on that bench for 30 years.
Well, don't you think it would be important if the judge and the President were discussing how they were going to make appointments for money?
I'm sorry, sir, I didn't understand your question.
Don't you think it would be important in a hypothetical case if the about to be appointed judge was making a deal with the President for money?
Absolutely.
But under yours, it couldn't be. In public interest, you couldn't release that.
I would think that that could not be released if it were a confidential communication. If the President did appoint such an individual, the remedy is clear. The remedy is he should be impeached. Let me give you...
How are you going to impeach him if you don't know about it?
Well, if you know about it, then you can state the case. If you don't know about it, you never had it.
You're on the prongs of a dilemma, huh?
No, I don't think so.
If you know the President's doing something wrong, you can impeach him. But the only way you can find out is this way. You can't impeach him, so you don't impeach him. You're losing it someplace wrong.
Well, this is, I think, what was suggested in the Seaboard case, where the court said, well, gee, if that's so, then fraud could be all covered over and so forth. Human experience has not demonstrated that that's a fact. Very few things forever are hidden. Secondly, however, this case is not that case. As I pointed out, there is a plethora of information. This is not a case where there is no information. If anything, there is more than enough.
What you're telling us also could be argued the other way, that there's been a waiver, and neither
that is suggested by my brothers.
Your brother have talked about waiver. I don't suggest that.
My brothers suggest a waiver, but this privilege is not like Fifth Amendment privilege or attorney-client privilege, where if you let out one word, you've lost the whole thing. That would defeat the purpose of it. As we point out in our brief, public policy requires as much publicity as the President, in his discretion, determines would be appropriate, and the more information, the better. And if you rule that one utterance constitutes a waiver, you're not going to get it. You're not going to have that thing. This is a discretionary privilege that the Constitution, by implication of necessity, and history has shown, is inherent in the executive function, as indeed it is in other functions. We've cited in our brief similar examples of the legislature insisting upon such a privilege, even against subpoenas from courts, the executive, and the courts themselves.
Mr. Sinclair, you're cutting into your...
I know I am. I do appreciate being reminded of that, and I think I would preserve it, which I think is 10 more minutes.
Mr. Mr. Lacabara.
Thank you, Mr. Chief Justice. If I may, I would like to advert first to procedural questions that Mr. Justice Blackmun and Mr. Justice Stewart have raised about whether the mandamus case is properly here. Mr. Justice, we did in our certiorari petition refer to the fact that we were trying to bring before the court for review before judgment in the Court of Appeals the order of the district court, which we said the President had tried to obtain review of in two ways in two cases in the district court, in the Court of Appeals rather, and we gave the docket numbers of those two cases. And that certiorari petition was filed on the 24th of May, and Judge Sirica, who was the respondent, as Justice Stewart properly notes, in the mandamus case in the Court of Appeals, was served with a copy of the certiorari petition, as he had been served with the mandamus petition, as indeed had all the respondents who were otherwise before the court, the defendants in the United States against Mitchell. On May 28th, in accordance with a motion that was filed in the Court of Appeals, a copy of which I believe is in the files of this court, the Court of Appeals transmitted to this court the records in both of those cases, the appeal and the mandamus cases. Now, Mr. Justice Stewart, with respect to Judge Sirica's appearance here, he is a party before this court, and I believe there's a letter on file with the clerk of this court from Judge Sirica in which he states that he will not appear separately. The United States, through the special prosecutor, is appearing on behalf of Judge Sirica, as indeed we would have in the Court of Appeals, to uphold his decision enforcing our subpoena. So the case procedurally is properly before the court, both with respect to the appeal and the mandamus proceeding. I'd like to...
I'd like to ask before you get too far up. Let's assume you get by the jurisdictional matters and also the standing question, the intra-executive dispute matter, and we get to the executive privilege, or we get to the merits, so-called. Which end of this case would we normally start at anyway? The 17C end or the executive privilege end?
Well, I think normally you might start at the 17C end, because that would provide for conceivably for a disposition on non-constitutional grounds if you found that we had not made a sufficient showing to satisfy the ordinary requirements of that rule. So in accordance with the court's normal jurisprudence...
Judge Sirica found that you had satisfied the requirement.
Absolutely.
Well, what's the scope of our review?
We have made the suggestion that any appellate court reviewing this kind of determination applies a standard of whether the district judge, who was intimately familiar with this indictment, and with the 49-page appendix showing that we submitted in demonstrating why each of these 64 subpoenaed conversations was material, he made the finding that we had clearly demonstrated relevance and an evidentiary nature.
What's our standard of appellate?
And your standard of review should be whether he has abused his discretion.
Clearly erroneous?
Clearly erroneous standard, yes, sir.
What about the standard, though?
I'm sorry.
The basic standard he followed.
What about the basic standard?
I think the parties are in agreement that Bowman Dairy and Iozia, that district court decision, established the basic criteria.
The government is in agreement that the standards of Iozia must be satisfied in this case under 17C.
Well, we have suggested that it's possible that a lower standard can be applied.
That's what I'm asking you. What is your position?
Well, my position would be that when you're talking about a subpoena to a third party as distinguished from an intra-case subpoena between government and defendant, a lower standard of relevancy or materiality...
So the parties are not in agreement at all?
Well, we have suggested that even if the proper standard is applied, that we meet that standard because of the showing that we made that each of these items
You mean a necessity standard?
Necessity in the sense of being relevant to the issues to be tried and being of an evidentiary nature. Now, the necessity standard comes in more in determining whether the executive privilege claim should be overridden if, apart from the waiver fact and what we call the Clark point...
What about Mr. St. Clair's argument that under 17C you can't possibly satisfy its requirements because you don't know what's in the tapes?
Oh, well, that obviously we don't think is a proper legal standard, and the courts have said. In fact, we go back to Chief Justice Marshall's opinion in the Burr case, where exactly the same a suggestion was made by the United States Attorney in opposing the subpoena that Burr hadn't specified which portions of General Wilkinson's letter were really going to be material, and Chief Justice Marshall applied with his eloquent common sense, of course not, because he hasn't seen the letter yet, but he's made a sufficient averment that it does contain something material, that at least it should be brought into court. Now, we have, as I say, gone much further than Colonel Burr did.
Now, you think IOSA just means only evidentiary and relevant? Is that your reading?
When you're talking about just a subpoena between the parties, yes, sir. They talk about other criteria, which I think are really subsumed, whether it's a fishing expedition, whether you're going off on a frolic. But as the later cases, as I believe Judge Sirica indicates, seem to have distilled that.
So you don't think IOSA and Bowman requires any showing that this particular evidence be something more than evidentiary and relevant?
That it be critical? No, sir, I don't believe so. I think that, as you were suggesting before, and as Judge Sirica held, it's never been the law that once an indictment is returned, the prosecution is not entitled to continue gathering evidence. The burdens of proof before a grand jury and a trial jury are clearly different. It's an abuse of the grand jury process that has been held to use a grand jury subpoena, as Mr. St. Clair suggested, to continue gathering evidence after an indictment is returned.
But you apparently concede that you can't use it just for discovery.
Yes, sir.
And you say that the evidence you're seeking by a subpoena, you must make some kind of a minimal showing of admissibility. You can't, for example, seek something that would admittedly be inadmissible hearsay.
Well, I hope I'm not conceding more than I should, but the rule does talk about subpoenaing material from a person on a showing that it will be relevant. It's the Rule 17, and I'm taking a position which is narrower than, of course, you're suggesting, Mr. Justice, that I might take, but in all candor, the rule talks about subpoenaing documents from a person, not only from a party, Mr. Justice Douglas. I believe you earlier mentioned that the rule applied only to subpoenas to parties, but the rule specifically provides for subpoenas to persons who are not parties to the case. But it says, and this was the clause that we were relying on here, the court may direct that the books or papers be produced before the court at a time prior to the trial or prior to the time when they are to be offered in evidence. So there does seem to be some natural focus about the evidentiary nature of the materials.
I get the government's position because it is a rather important part of the case.
Yes, sir. We insist, as Judge Sirica found, that with citation of chapter and verse, if I may, in our 49-page showing before the district court, with references to sworn testimony, as well as with representations about what witnesses will testify at trial, we demonstrated why each of these subpoenaed conversations satisfies the Bowman-Dairy-Iozia Rule 17c standard. Now, that leads me into the related point. What is the relevance of the grand jury's finding that the president was a co-conspirator in this case? It has been alleged that we did this in order to prejudice the president's rights. I think we have sought to demonstrate in our reply brief that that was in no sense...
Mr. Lacaver, I don't think it'd be very hard to understand the relevance of a showing at the trial for purposes of evidence that certain people are co-conspirators.
Yes, sir.
For purposes of the introduction of evidence. But that's a little different question than the relevance of the grand jury having come to that conclusion.
Yes. Normally, I will concede, it is not the practice, as anyone who's been a prosecutor knows, for the grand jury, if it is not identifying the co-conspirators in the body of its indictment, to place them on the record. It is fairly common practice, however, for an indictment to say, in addition to the defendants, the named persons are unindicted co-conspirators. This is not an ordinary case.
That may be so, but even if they name it in the indictment, that isn't enough on which to base the introduction of out-of-court statements by an unindicted co-conspirator.
Yes, that was the point that I wanted to get to in discussing what we call our Clark argument. We have never argued, and of course there would be no basis for arguing, that the mere grand jury finding, whether on the face of the indictment or in the grand jury's minutes, that the president or any of the other 18 unindicted co-conspirators were members of this conspiracy, would itself be enough at trial to warrant the judge's admission of extrajudicial statements given by those co-conspirators. We're not making that contention here. The issue arises because a motion to quash a subpoena was filed prior to trial, and the basis for that motion was a claim of executive privilege, a governmental privilege that exists for the benefit of legitimate governmental processes. We countered that apart from Nixon versus Sirica and the balancing process, and apart from the waiver argument that we also develop at some length, this president, as difficult as it was to say this, not because of the evidence, but because of the inherent awkwardness of it, this president is not in a position to claim this public privilege, for the reason that a prima facie showing can be made that these conversations were not in pursuance of legitimate governmental processes or the lawful deliberation of the public's business. These conversations, as we showed in our 49-page appendix, and as the grand jury alleged, were in furtherance of a criminal conspiracy to defraud the United States and obstruct justice. We did not rely, even before Judge Sirica, and we do not rely here, merely on the fact that the grand jury made this determination. We do submit that for purposes of a pretrial consideration of a subpoena that is challenged on grounds of executive privilege, we are not confronted with the need that we will be confronted with at trial, and which we fully intend to discharge, of showing by evidence to the trial judge that the president and the other co-conspirators were members of the co-conspirators.
One of your grounds for the non-applicability of the privilege is that these conversations were in the course of the conspiracy.
Yes, sir. And
that you say is satisfied by merely the grand jury?
No, sir. No, absolutely not.
No, just a moment.
I'm sorry.
It isn't satisfied merely by the grand jury finding, so a court must go on and make its own determination. If they were going to agree with you on this ground.
Let me back up a little. I see the point that you're making. We are taking the position that the grand jury's determination is conclusive on the court on two issues. A, that a conspiracy existed, and B, that President Nixon was a member of the conspiracy. That is not enough, we concede, to override a claim of executive privilege, because, as Mr. St. Clair well says, he is still the president, and he still is in a position to invoke executive privilege. Where we have said we must bear an evidentiary burden to the satisfaction of the court is on drawing the nexus between the subpoenaed conversations and the conclusively determined prima facie showing that there is a conspiracy of which the president is a member. We made that evidentiary showing to Judge Sirica. That showing is before this court. Judge Sirica found that that showing was sufficient. And for that reason, as I believe his opinion, although it had to be guarded because these items were placed under seal, reflects that he did make the showing.
That showing, or such a showing, could arguably have been made whether or not the grand jury had named the president. Could it not?
Yes, sir. It could have been made as an evidentiary matter.
Exactly.
But we
don't
are...
you say it was?
Pardon me?
Isn't it your position that it was independently of the naming of the president as an unindicted co-conspirator?
Yes, sir. The evidence that was placed before Judge Sirica, we would submit, would be sufficient to make that showing. And we have said that that is not legally necessary, that we did not have to prove a conspiracy, in effect prove the whole case that may take 3 months to try in order to defeat a claim of executive privilege before trial. This court has frequently said that the criminal process would be burdened down unduly if proceedings were preceded by many proceedings. That's exactly what we have here. We submit the evidence is sufficient. Judge Sirica, the evidence, this is a situation in which the showing that we did submit, intrinsically we submit, tracks the allegations of the indictment and provides independent evidentiary support for those allegations. We have said, though, that it is not legally necessary in a proceeding like this for the court independently to decide whether the grand jury had enough evidence before it to say there is a conspiracy or that a particular individual was a member of the conspiracy. We said all you need to find is that we have shown that these conversations were in furtherance of that conspiracy.
Mr. Locavara?
Sir.
Let's back up a minute. Do you concede that an incumbent president of the United States could not be indicted and tried for crime?
No, sir.
You do not? You think he could be?
We have not expressed a position on that, Mr. Justice Powell.
Let's assume for the moment that he could not be. Would you still argue that a grand jury had the power or the right, and if so, by virtue of what?
Yes, we argue that.
As an unindicted co-conspirator.
We do, in fact, make that argument at some length. I guess all of our arguments are made with too much length. But we do argue at length, sir, seriously, that the question of presidential indictability, which we offer some views on, just to show that the question is an open one, because of our obligation, we believe, to the law and to the court, is not really determinative of the question that is really in this case, to the extent that the court reaches the expungement argument advanced by counsel, or to the extent that the court does not reach the so-called Clark argument that executive privilege just cannot be invoked here. The issue of presidential indictability does not determine the issue whether an incumbent president can be named as an unindicted co-conspirator by a grand jury. We have shown in our brief why even persons who do have some constitutional immunity, and counsel argues that implicitly under the framework of the Constitution, the president should have an implicit immunity from prosecution. Even such persons can be and frequently are named by grand juries as unindicted co-conspirators. The practical arguments that may militate in favor of a judicial recognition of some unique immunity for the president alone, not for circuit judges, not for Supreme Court justices, not for members of Congress, but the president alone, it may be held at some later date, is immune from prosecution. But that by no means suggests the answer to the question here. And the grand jury elected not to test that issue.
The thing that I was wondering about is that there is only one president, and the executive power is vested in him. And I do wonder whether or not the precedents you set with respect to other people would vest the authority in a grand jury, either on its own motion or because of what some prosecutor suggested, while the president is in office, to name him as an unindicted co-conspirator. With grand juries sitting all over the United States, and occasionally you find a politically motivated prosecutor, that's a rather far-reaching power if it exists.
It is, Mr. Justice, and there's no doubt about it. We are conscious of the delicacy of the issue. We have suggested, however, that although there is some conceivable opportunity for abuse, our judicial system, our democratic system, is based on several fundamental propositions, one of which is that grand juries usually are not malicious. Even prosecutors cannot be assumed to be malicious. We also assume, as this court regularly holds in First Amendment cases dealing with public officials, that we have a resilient society where people can be trusted to sort out truth from falsehood. We have a robust debate. I submit to you, sir, that just as in this case a grand jury would not lightly accuse the president of a crime, so too that the fear that perhaps without basis some grand jury somewhere might maliciously accuse a president of a crime is not necessarily a compelling reason for saying that a grand jury has no power to do that. I think the system may be vibrant enough to deal with that, and I think the inherent dignity of the presidential office and any incumbent provide him with a notable check against being defeated or as my colleague says, impeached by the action of a grand jury. This is perhaps the most notorious event and notorious case in recent times when the grand jury's action was disclosed. I venture to say that although it was a difficult time for all concerned, including the prosecutors as well as other counsel and the president and the country, the president has not been displaced from office. He still is president. He still functions all in accordance with his constitutional powers.
Mr. Lockevar, I wanted to get to this mechanical question that Mr. Sinclair brought up. Assume for the moment that a given tape, one of the 40-odd, 46 is it that you're asking for?
64, sir.
64, I had it transposed. One of the 64 tapes is, in fact, 1/8 of the total time, which might be several hours, apparently, because they're long tapes. That 1/8 of it involves discussions of the people who are under indictment here. But that 7/8 of it, in fact, now, you'll have to assume this, includes conferences with the secretaries of the cabinet, the joint chiefs of staff, the chairman of the Atomic Energy Commission, very high-level people, and perhaps some staff people as well. Including in those conversations some highly sensitive material. Not sensitive in the sense that it's national military secrets or diplomatic secrets, but sensitive in the sense of confidentiality. Would you not think that some mechanism ought to be available that if the participants are identified, as you've got them all identified by the voluntary submission of the President, as to the 64, that if the participants are identified and the time frame specified, that the certificate of the major persons present, that the subject was atomic energy, all sorts of other things, would be sufficient to foreclose a court from examining it in camera?
Well,
I'm
to foreclose
would you think so?
The answer to my question, Mr. Chief Justice, is yes, because these are the procedures that have been set up in the Court of Appeals decision of Nixon versus Sirica, which were found to be eminently practical when the tapes subpoenaed by the grand jury were submitted. These are 6-hour reels. And under the so-called index and analysis, which the Court of Appeals in that case required to be submitted, and which Judge Sirica here has required to be submitted, counsel for the President says this is a 6-hour reel. The Watergate-related portions are minutes 312, no, that's too many, 112 through 146. Prior to that, there's a meeting between the President and the Secretary of Health, Education, and Welfare on a school bill. After the Watergate-related discussions, there's a meeting between the President and representatives of the National Association of Manufacturers. What has happened is that White House counsel has come to the judge's chambers with the original reels. They have marked the beginning of the Watergate-related portions on those reels for the court to make his independent determination. This is Watergate-related and therefore offset by whatever overcoming of the privilege has been held. And after that is done, a copy of the Watergate-related portions are made. The judge does not listen to the non-Watergate-related portions, which are still covered by a presumptive executive privilege, which we have freely conceded from the time the grand jury began this process in July of '73 to our briefs in this court.
Then, as to this hypothetical 7/8, there is, you suggest, no disagreement between you and Mr. St. Clair and Mr. Jaworski and you on the one hand.
That's correct, sir. And I might say that under the procedure that was worked out, this may predate Mr. St. Clair, so you'll have to rely solely on my representation. The President indicated a willingness to allow the judge to listen to a few moments of conversation on either end of the portion of the tape that had been listed in this index and analysis as being Watergate-related, just so he would have an assurance that there was a transition from one subject to another subject. That was agreed to by the President as being, if a minimal intrusion on the confidentiality privilege for an unrelated subject, certainly by no means an excessive one.
Mr. Lockevar, I know you have only very few minutes. Are you going to address Mr. St. Clair's opening argument that the pendency of the House Judiciary impeachment inquiry either should lead the court to conclude that this whole business before us is a non-justiciable matter, and therefore necessarily that Judge Sirica's order should be quashed, or in any event, that because of the possible effect of a decision on the issue presented upon the impeachment inquiry, that the court should stay its hand?
That was to be my last point, sir, and I will make it right now. The notion that because there is concurrently underway an impeachment inquiry for the House of Representatives, that somehow makes this a non-justiciable political question is, we think, a remarkable notion which is not supported by sound constitutional law or by any of the decisions of this court. And indeed, I submit that to the extent that the court has discretion in the matter, and although this court has now been given discretionary certiorari power, district courts have no such option, it would not even be a wise exercise of discretion for this court to stay its hand. This case before the court is not a request for an opinion between two congressional committees as to who has jurisdiction over a particular bill. It's not even a request or a dispute between cabinet officers or the president and a cabinet officer over what proper executive policy ought to be. This is a criminal proceeding, a federal criminal case against 6 defendants. A subpoena has been issued to obtain evidence for use at the trial, which is scheduled to begin on September 9th. The court cannot escape the fact that this is a trial of tremendous national importance, but a trial that was brought to a head without regard to the impeachment inquiry. This is an independent, separate constitutional process that is underway. And a traditional, ordinary, prosaic remedy, a subpoena, has been utilized to obtain evidence for that trial. There's some debate about whether the evidence is critical to our prosecution. I noted in Justice Rehnquist's opinion a few weeks ago in Michigan against Tucker that he echoed, or presaged perhaps, the same point that Judge Sirica made, that it's really the obligation of the prosecution to present all of the material evidence for the jury, for the fact finder to pass upon. That's what this case involves. Now, to say that there will be public consequences, even political consequences, to the court's action does not mean this is a political question so that the court must regard it as non-justiciable. The same argument would have prevented this court from deciding Marbury and Madison. It's common knowledge that Chief Justice Marshall himself was threatened with impeachment if he decided the case against President Jefferson. He went ahead and did his duty on behalf of this court. Later, in connection with the Burr trial...
He really decided it in favor of President Jefferson, didn't he?
No, sir.
He didn't?
No, sir. He stated expressly...
He surely decided it. Jefferson won the case, the battle, but lost the war.
Well, if you...
Of judicial supremacy.
The case is normally thought of as being solely concerned with original jurisdiction. But if one reads the case again, sir, I submit, Chief Justice Marshall got to the original jurisdiction point only after he had been very decisive in saying that a lower court could issue and should issue and would be obliged to issue the mandamus to Secretary Madison because the President had no legal power to order Secretary of State Madison not to issue that commission. He held that. It might be called dictum, but it certainly in the time was a courageous act.
But the basic ruling in the case related to the original jurisdiction of the court under Article 3, did it not?
I concede that, sir. Later, however, when he did go on in 1807 to issue the subpoena to President Jefferson, That was an act of profound political consequences, but he stated again eloquently that it was the court's duty to obtain evidence if it were material to the trial. The notion that political consequences should stay the hand of the court is a notion that, again, speaking through Marshall, the court rejected in Cohen's against Virginia and the Cherokee Nation case, where it was common knowledge that the state legislatures in Virginia and Georgia would interpose themselves and defy this court. And Marshall uttered the words which I think are justly famous, that just as the court can't reach out for jurisdiction it doesn't have, it has an obligation to exercise the jurisdiction it does have, whatever may be the political consequences of that act. The court's action in Ex parte Milligan in telling President Lincoln that he did not have the power to conduct the Civil War the way he wanted to conduct it. Again, profound political consequences. Come to the war power cases in World War II, the Japanese exclusion cases. This court did not say that because of the consequences for the president or because of the political reaction to a decision one way or the other, the court should stay its hand. And Youngstown, where our colleague's brief closes by quoting Justice Frankfurter's brilliant concurring opinion, saying how the court should, as an institution, be reluctant to decide great constitutional questions. But he went on to say, we have an obligation to look into an assertion of presidential power. And even if the embarrassment to be caused to the president by our disagreeing with him would be profound, it is still the duty of the court to tell him when he's wrong. This court, in Powell against McCormick, how could there be a more political case than telling a House of Congress that it had to seat a member that it had excluded? But the court said the Constitution forbade it. It's up to the court to decide what the Constitution allows. And even though the court interprets the Constitution differently from another branch, that's the judicial process. So separation of powers here, or the notion of political question, whether something is committed to the final determination of another branch, far from supporting the president's position, demands that the court affirm the action that Judge Sirica has taken. This is emphatically the province of this court to decide. Not to belabor the point, but perhaps the finest chapter in the court's recent history has come, and finest chapters have come in the fields of reapportionment, civil rights, and the procedural rights of the criminally accused. It would be naive to say that those were not profoundly politically important decisions, but they were made as decisions of constitutional law, despite the consequences that political branches might face. Despite the public reaction, the court understood its duty to interpret the Constitution. That's all we ask for today. That's all Judge Sirica has done. We believe he has done it correctly. We believe the case is fully justiciable. We believe the principles that have been briefed by the parties support the correctness of the decision below. And we submit that this court should fully, explicitly, and decisively and definitively uphold Judge Sirica's decision.
Thank you, Mr. Lockerbara. Mr. Sinclair, you have 15 minutes left.
Thank you, Mr. Chief Justice, members of the court. In response to my brother's most recent argument, of course Sawyer was an important case with political implications. Of course the other cases were, in and of themselves, important cases with political implications. But this case is different in that the decision in this case will have an undeniable impact on another proceeding. And another proceeding, which the Constitution says is essentially a political proceeding, from which the court is excluded. And for this court to be drawn into that thicket, if I may call it that, seems to me highly inappropriate, at least at this time. As I indicated at the outset, the House Committee has made certain political decisions. The President has made certain political decisions. They will each have to bear the responsibility of those decisions with the American people. This court should not impair, interfere with, or otherwise participate directly or indirectly in that proceeding. and it's inevitable that it would happen. This courtroom wouldn't be full today if this were simply a suit on a subpoena brought by the special prosecutor against the president, even though that would be an important political matter because the president is involved. But this is important for other reasons, quite apart from that. Other reasons which I suggest indicate quite clearly that this court ought to, in its discretion and in its judgment, stay its hand, at least until such time as those proceedings have run their course. Because those are political decisions being made, they should not bear the burden either way of a judicial decision.
Well, under that theory, all the criminal trials that are going on should stop then.
That would not be the first time, Mr. Justice Douglas, that a criminal trial was delayed. And in balancing the importance to this nation, I would suggest that that is clearly indicated, and I don't believe the defendants would be crying very bitter tears. But in any event, the justiciability of this case seems to me to be the single important, obvious matter that my brother would prefer not much to talk about. But there can be no doubt about it. If you read page 59 in his brief, he says, he, the President, is now the subject of an impeachment inquiry by the Committee on the Judiciary of the House of Representatives, and the subpoenaed evidence may have a material bearing on whether he is impeached, and if impeached, whether he is convicted and removed from office. And I suggest the Constitution and all of the history of the framers makes it quite clear that the framers conceived impeachment as a legislative process. The court was excluded specifically from that function. Marbury against Madison itself, I agree with the Chief Justice that it decided the case in favor of the President. The rule was discharged and the commission was not issued. But it also held, and it's been the law since that case, that the courts will not interfere with or direct a discretionary act on the part of the President or any other branch of government. And that's been confirmed in Mississippi against Johnson and any case since that time. And the discretion that the Constitution, by implication and by necessity, that has been vested in the President in determining which of his confidential communications shall be made public or released, is a discretionary act that this court ought not, by its decision, to undertake to do for him, because this court is not equipped in knowledge, background, or in any other way to exercise that discretion for the President of the United States. This is not a ministerial act. Finally, I observe a slight but significant shift in my brother's position with respect to the prima facie nature of a naming of the President as a co-conspirator. They say it can be made now that it can be made prima facie. I take it that is by examining the evidence before the grand jury in order to determine whether or not that evidence in fact supports that determination. We have invited this court and Judge Sirica to do just that. The special prosecutor has opposed in each instance this or any other court looking behind that to see whether in fact the evidence can be made, as he now states the position, to support a charge of criminality. Before the argument was that because it was a finding or a vote, it was prima facie. Now it is, I take it, somewhat different. But in any event, an action by a grand jury purporting to assess criminality to a President of the United States is a clear intrusion upon the legislative function and power with respect to impeachment. As I said earlier, the President is not above the law, nor does he contend that he is. But he does contend that as President, the law can be applied to him in only one way, and that's by impeachment, not by naming as a co-conspirator in a grand jury indictment, not by indictment or in any other way. And therefore, in this case, I urge that this court take such action as is appropriate and overrule Judge Sirica's decision and order that this case be dismissed.
Thank you, Mr. St. Clair. Thank you, Mr. Jaworski. Mr. Lacavara, the case is submitted. I have the disposition to announce for the court Number 73-1766, United States against Nixon, together with 73-1834, Nixon against the United States. We granted certiorari before judgment in these cases to review certain pretrial orders of the District Court for the District of Columbia in the case of United States against Mitchell and others. In that case, several former aides of the President were indicted by a federal grand jury for crimes including conspiracy to obstruct justice. Prosecution for the government was commenced by a special prosecutor who had been appointed by the Attorney General pursuant to federal regulation. The special prosecutor had been given broad authority. He moved for a subpoena ducis tecum to secure from the President as a third party certain specifically described material, chiefly records of various conversations between the President and others, including named defendants in pending cases. The District Court authorized the subpoena pursuant to Rule 17C of the Federal Rules of Criminal Procedure. Counsel for the President moved to quash the subpoena on the grounds, first, that the court lacked jurisdiction of the case, and second, that the courts did not have the power to review the claim of executive privilege as asserted here. The District Court, after hearing, denied the motion to quash the subpoena. The President appealed to the United States Court of Appeals for the District of Columbia Circuit, and on the same day the special prosecutor filed a petition for certiorari before judgment in this court. The grand jury, which had issued the indictment in United States against Mitchell and others, had also named the President as an unindicted co-conspirator. Shortly after the special prosecutor had filed his petition for certiorari in this court, counsel for the President filed a cross petition for certiorari before judgment also, challenging the action of the grand jury as improper and as being unsupported by the evidence. We granted both petitions for certiorari, expedited the consideration, and heard arguments on July 8. At the outset, we should say that we conclude that the cross petition raises an issue which it is not necessary to decide in order to resolve the issues of this case, and the cross petition is therefore dismissed as having been improvidently granted. The President is not a party to the proceedings for which the evidence is sought. He is a third party who has in his possession or under his control material the special prosecutor claims he needs to proceed with the cases now pending in the District Court. The special prosecutor made a preliminary showing to the District Court, satisfying that court that the evidence he wanted was probably relevant to these cases and probably would be admissible. The special prosecutor was able to describe what he wanted in the subpoena ducis tecum because the daily logs and diaries which are routinely kept in the White House were supplied to him. The special prosecutor's petition to this court advised that the case for which the evidence was sought would be tried in the District Court early in September, and that he needed time to analyze the large amount of material involved. The first question to be decided is whether we have jurisdiction to review the District Court's order denying the motion to quash the subpoena. If it was a final order, it would be an appealable order. Ordinarily, an order of this kind is not regarded as final and therefore not appealable. And a party is not permitted to challenge it in an appellate court until it has become certain that the District Court will in fact command compliance on pain of contempt. There are, however, some exceptions to this, and this is one occasion for such an exception. To follow the ordinary procedure in this case would very likely produce more delay and defeat the very purpose of the rule that only final orders are appealable. For this and other reasons, we therefore conclude that this court has jurisdiction. The President's counsel contends in this case that it presents a dispute between the special prosecutor and the President, and that since both are part of the executive branch, it is an intra-branch, a jurisdictional dispute, which can be resolved only within the executive branch and not in the courts. However, the special prosecutor in this case is not an ordinary subordinate officer of the Attorney General, because by regulation of the Attorney General, the special prosecutor was given unique authority and tenure concerning specific investigations and prosecutions. His authority is to represent the United States as a sovereign, and it includes express authority to contest any privilege asserted by the executive branch. It is now well established that when the government or its departments promulgate regulations, the government is bound by those regulations even though they may be revoked or modified. But until they are revoked or until they are modified, they have the force of law. We therefore have before the court a claim by the special prosecutor vigorously contested by the President's counsel on constitutional grounds. And we hold that this presents a controversy of the kind that, as we said in Baker against Carr, provides that concrete adverseness which sharpens the presentation of issues upon which the court so largely depends for the illumination of difficult constitutional issues. Ordinarily, as we have indicated, a dispute between two officers of the executive branch is not a subject to be settled by litigation in the courts. But this case presents one of the unusual exceptions, and we therefore find no barrier to justiciability. If we were to decide that the subpoena, ducis tecum, was not properly issued in the first place, that would be the end of the matter, and no other issues would call for resolution by this court. However, from our examination of the materials submitted by the special prosecutor in support of his motion for the subpoena, we are satisfied that the district court acted within its powers under Rule 17C for the production of evidence before trial. In the performance of assigned constitutional duties, each branch of the government must initially interpret the Constitution, and the interpretation of its own powers by any one branch is due great respect from the others. The President's counsel reads the Constitution as providing an absolute privilege of confidentiality for all presidential communications. Many decisions of this court, however, have unequivocally reaffirmed the holding of Marbury against Madison in 1803, that it is emphatically the province and the duty of the judicial department to say what the law is. Our system of government requires that federal courts on occasion interpret the Constitution in a manner at variance with the construction given to that document by another branch. Any other conclusion would be contrary to the basic concept of separation of powers and the checks and balances that flow from the scheme of a tripartite government. We therefore reaffirm what was said in Marbury against Madison, that it is emphatically the province and the duty of this court to say what the law is with respect to a claim of privilege such as presented in this case. There is nothing very novel about a claim of governmental privilege asserted in litigation in federal courts. For example, in the Waterman steamship case in 1948, a case that dealt with the President's powers relating to foreign airlines, where a decision of the President had to be made in camera on confidential reports and studies relating to foreign relations, the court sustained the privilege of the President. In United States against Reynolds in 1952, claims were made against the United States for the death of various persons and the injury of others in the crash of an experimental airplane which was being tested for military uses. There, the government's claim was based on the secrecy of these very confidential and secret military instruments. In each case, Waterman and Reynolds, the claim of privilege was upheld by the courts. However, there are important differences, and only a few of them need to be mentioned here today. First, the Waterman steamship and Reynolds case were not criminal cases, and the government was not in the posture of a third party in possession of relevant evidence. Moreover, those cases, as I've noted, involved confidential military and diplomatic information. But here the claim of privilege rests simply on the generalized, undifferentiated claim of the need to keep all presidential communications private and confidential. We at once recognize the high deference that is due to protect all of the communications of a president. As early as the case of United States against Burr in 1807, Chief Justice Marshall, sitting as a trial judge, had authorized a subpoena to President Jefferson to secure certain letters in the possession of the president. And Marshall noted, among many other important passages in that opinion, that in no case of this kind would a court be required to proceed against the president as against an ordinary individual. However, the deference traditionally shown by the courts toward a president does not mean that all material in the possession of a president is immune in all circumstances from judicial process. We recognize the importance of the need to protect the confidentiality of the communication of a president with his aides and advisors. And we recognize the risk that publication of those communications may well have an adverse effect upon the ability of a president to secure candid advice and opposing views on important questions. However, no case of this court has extended this high degree of deference to a president's generalized need of confidentiality. Nowhere in the Constitution is there any explicit reference to the privilege of confidentiality, yet to the extent this interest relates to the effective discharge of a president's powers, it is constitutionally based. In this case, we must weigh the importance of the general privilege of confidentiality of presidential communications in the performance of his responsibilities against the inroads of such a privilege on the fair administration of criminal justice. Although the interest in preserving confidentiality is, as we have noted, very weighty indeed and entitled to great respect, we cannot conclude that advisors will be moved to temper the candor of their remarks by the infrequent occasions of disclosure that may be brought about because of the possibility that such conversations will be called for in the context of a criminal prosecution. On the other hand, the allowance of the privilege to withhold evidence that is demonstrably relevant in a criminal trial would cut deeply into the guarantee of due process of law and gravely impair the basic function of the courts under Article 3. A president's acknowledged need for confidentiality in the communications of his office is general in nature, whereas the constitutional need for the production of relevant evidence in a criminal proceeding is specific and central to the fair adjudication of a particular criminal case in the administration of justice. Without access to specific facts, a criminal prosecution may be totally frustrated. The President's broad interest in confidentiality of communications will not, in our view, be vitiated by disclosure of a limited number of conversations which have preliminarily been shown to have some bearing on a pending criminal case. We conclude, therefore, that when the ground for asserting the privilege as to subpoenaed materials sought for the use in a criminal trial is based solely on the generalized interest in confidentiality, as distinguished from the situations where it may be based upon military secrets or diplomatic secrets, it cannot prevail over the fundamental demands of due process of law in the fair administration of criminal justice. The generalized assertion of privilege must yield to the demonstrated specific need for the evidence in a pending criminal trial. Accordingly, the judgment under review is affirmed. Mr. Justice Rehnquist took no part in the consideration or decision of these cases.
The Associate Justices of the Supreme Court of the United States. Oh yay, oh yay. All persons having business before the Honorable, the Supreme Court of the United States are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
The first case we will argue today is case 19-715, Donald Trump versus Mazars, USA. Mr. Strawbridge?
Before these cases, Mr. Chief Justice, and may it please the Court, the subpoenas at issue here are unprecedented in every sense. Before these cases, no court had ever upheld the use of Congress's subpoena power to demand the personal records of a sitting president. And no committee of Congress had even tried to compel production of such a broad swath of the president's personal papers, let alone for the stated purpose of considering potential legislation. There is a reason that this is the first time a congressional committee has attempted such a gambit. It has long been understood that because Congress's subpoena power is implied, it is auxiliary and subordinate. And when that power is deployed against the president, it must yield absent any long-standing tradition or particularly compelling showing of need. The committees can satisfy neither condition here, and that should decide this case. The committees contend that these subpoenas satisfy the limits this court has always applied to congressional subpoenas, but their arguments would render those limits meaningless. For example, they contend that this court should ignore the committee's avowed improper purpose so long as they simply tack on a broad reference to potential legislation. They claim that Congress can use subpoenas to uncover individual wrongdoing simply because that will always inform the sufficiency of existing laws. And they challenge this court's ability to even question the constitutionality of the potential legislation that they rely upon. The committee's obvious overreach is sufficient to invalidate these subpoenas even in a typical case. But the court simply does not proceed against the president as it does against an ordinary individual. And the committees have not even tried to show any critical legislative need for the documents these subpoenas seek. Now, it is no secret the relationship between the House of Representatives and the President is frayed, but this is neither the first nor the last time that one House of Congress will be at odds with the President. The rule that the court applies here will affect not only this President, but the presidency itself. The court should deny the committees the blank check they seek and reverse the decisions below.
Mr. Strawbridge, I want to make sure that I understand the scope of your argument. Your brief begins by questioning whether the House has any power to subpoena presidential records, but you seem at the end of the brief to pull back from that. You say that such subpoenas, quote, press the outer limits of Congress's authority, end quote, and that there is every reason to doubt whether subpoenaing the personal documents of the president is a necessary incident of lawmaking. Do you concede any power in the House to subpoena personal papers of the president?
I think it is very hard to imagine that the House is ever going to have the power, pursuant to its legislative powers to subpoena the records of the president, because, quite frankly, the House has limited powers to regulate the presidency itself. So I think it's very difficult to imagine a situation where its implied power to subpoena.
Well, that's another formulation for what I was just focusing on. Difficult to imagine, reason to doubt. In other words, is your position recognized? Does it recognize in a particular case that the Congress, the House, may have such authority, and that in such a case it would be for the courts to decide whether it's exceeded any bounds in that situation?
Yes, we have argued that at a minimum this court should apply the demonstrated need standard that it has applied in other cases when there's an attempt to serve process that targets the president. So
okay, so you say there is some power in the House. You think there's a high standard. I understand the House to concede there is some limit to its authority. So it sounds like at the end of the day, this is just another case where the courts are balancing the competing interests on either side. Is that the wrong way to look at it?
Well, I don't think that we're asking this court to do anything different than it has to do in an ordinary case. We're just noting that the restraints upon the powers of Congress are emphasized in this case because this is a separation of powers dispute. And although
thank you, counsel. Justice Thomas? Justice Thomas? Justice Ginsburg.
Counsel, in so many of these prior cases, there was a cooperation. For example, tax returns. Every president voluntarily turned over his tax returns. So it gets to be a pitched battle here because President Trump is the first one to refuse to do that. And initially he said because of an audit was ongoing. Now it seems to be broader than that. But the aura of this case is really sauce for the goose that served the gander as well. So how do you distinguish, say, Whitewater, when President Clinton's personal records were subpoenaed from his accountant, or even Hillary Clinton's law firm billing records were subpoenaed? It seems that in prior cases, you say this one is one of a kind, but it seems in prior cases there was a much greater collision of interests. Take the Nixon tapes. How do you distinguish all of those cases, Watergate, Whitewater, the Nixon tapes case, the Paula Jones case?
Well, Your Honor, we distinguish them in a number of ways. With respect to Watergate and Whitewater, obviously those are cases of relatively recent vintage, and in separation of powers disputes, this court has generally, such as in Noel Canning, looked back for a much longer precedent for the type of issue that needs to be decided, examples of the encroachment upon the separation of powers. And the recent examples, and there are just a handful of them that the House identifies, are too recent, under that stricture, as the court recognized in Southwest General. Now, it's also important to note that almost all of those cases, I think all of those cases, actually involve cooperative efforts. And as the court recognized below, consent is not the measure of constitutionality. In none of those cases was there a challenge to the scope or to the power of the legislative committee in that case to request those documents. And I think Whitewater...
Thank you, counsel. Justice Thomas.
Yes, thank you, Chief. Counsel, I'm very interested. Do you think that there are any implied powers for the Congress to request or to subpoena private documents?
I think that there might be limited powers in some cases for the House to subpoena private documents, although the court has been very clear in Watkins and a number of other cases that Congress lacks any power to just inquire.
Would you define what you mean by that limited power?
Well, I think that we don't quarrel with the general notion that Congress has some implied power to exercise its legislative powers, and we recognize that in some cases Congress has been able to seek information that would be directly relevant to its consideration of potential legislation. But as the D.C. Circuit recognized in Senate Select Committee and Judge Livingston recognized below, most often that's going to take the view of forward-looking information, perhaps aggregated information, and not an attempt to reassemble a precise factual history. That's
well,
precisely
the dissent in the D.C. Circuit opinion says that this sort of information or subpoena should be requested under the impeachment power. What's the line between a legislative subpoena, and an impeachment-related subpoena?
Well, in Kilbourne, this court recognized that there are two very different powers, and that when impeachment is properly pending before either body of the House, the ability to subpoena pursuant to impeachment is coextensive with that of a court. Of course, court subpoenas are not unlimited. But that has no bearing on this dispute because the committees have waived any reliance on impeachment, and nor could they. These committees don't even have jurisdiction over impeachment. So regardless...
Justice Breyer?
Well, I'd like to follow up on both Justice Thomas's and Justice Ginsburg's questions. As to Justice Thomas' questions, are you saying that Sam Ervin's subpoenas, which were done under the legislative power at the time of Watergate, which were fairly broad, are you saying they were unlawful, that a court should not enforce them? Yes or no? And as to Justice Ginsburg's question, I would like to know why, since in Watergate and other cases, Watergate particularly, the court gave contested material involving the very workings of the presidential office to the prosecutor, why isn't whatever standard applies to personal papers a weaker one, not a stronger one?
Well, if I can answer that last question first, I think that the court cannot refuse to see what others see, to quote Rumley, and the threat in this case of subpoenaing decades worth of papers, not only of the president, but of the president's family members, of his children, of his grandchildren, as the House has done in this case, poses an obvious problem with respect to harassment and infringement upon the ability of the executive to discharge his duties 24 hours a day. Unlike Congress, the president is never in recess, and these types of subpoenas are going to be particularly troublesome and burdensome. Are
you saying that a weaker case, look, whatever it is, why wouldn't whatever standard applies to personal papers before the presidency be equal to or weaker than the standard for material that is the workings of the administration at the time?
Well, setting aside any executive privilege concerns, which I understand is not the focus of your question, the answer is because this court has repeatedly emphasized in Kilbourne and Watkins and everywhere else that Congress lacks any power to inquire into the private affairs of any individual. And that's distinct from whatever interest they may have in informing themselves about the workings of government. Now, that informing power does not extend to the president. It generally applies to lower executive branch officials and agencies.
Thank you. I see it. What about the first question? Are you saying that the Irvin Committee subpoenas were unlawful? Yes or no?
This case, we do not argue that, and we do not need to address the power of impeachment because it's not at issue in this case.
It wasn't impeachment.
Justice Alito? Counsel, are there any circumstances in which a House of Congress can justify a subpoena for a sitting president's personal records on the ground that it wants to use the president as a case study for possible broad regulatory legislation?
I think it's difficult to imagine for a couple of reasons. And one is, even setting aside the fact that it's the president, this court has always required some showing that the information being sought is pertinent. I think that the swath and the scope of the subpoenas that are issued here create serious problems even in an ordinary case. But to directly answer the question, no. The president's personal papers are not related to anything having to do with the workings of government. And to empower the committees to simply declare him a useful case study is to open the door to all sorts of oppressive requests. You could have subpoenas directed seeking all of Jimmy Carter's financial history simply because he used to be a peanut farmer and they want a case study on agriculture. You could have all sorts of requests for medical records, for educational records, any imaginable detail of personal records, because Congress does have the general power to legislate in lots of areas.
Well, perhaps before my time expires, I can ask you one other question. I think you said that Congress has limited power to regulate the conduct of a president. Does Congress have any power to regulate the conduct of the president, which is an office that is created by the Constitution itself and not by Congress?
Yes. The answer to that, I think it's clear from this court's cases, is not very much, which is why it frequently applies avoidance principles to avoid even having to decide whether Congress has attempted to reach the president. Now, the one example, obviously, in recent history is the Nixon versus General Administrative Services case. But even in that case, it was a very limited right regarding presidential documents. One could imagine maybe some hypothetical where there'd be some limited personal papers that might be relevant to a question regarding custody of official documents. But of course, even in that case, what saved the constitutionality of that statute was the fact that it was not seeking the president's personal papers and that control remained in the executive branch.
Justice Sotomayor?
Counsel, there is a long, long history of Congress seeking records and getting them, as Justice Ginsburg pointed out, from presidents. And in some of those cases, we have said, especially Eastland and McGrain, that a congressional subpoena is valid so long as there is a conceivable legislative purpose and the records are relevant to that purpose. I see a tremendous separation of powers problem when you're talking about placing a heightened standard or a clear statement, your various formulations of this, on an investigation that a committee is embarking upon. Now, I understand your complaint about the financial services subpoena on the money laundering issue. But are you disputing that the stated purpose of the Intelligence Committee subpoena at issue, investigating efforts by foreign entities to influence the U.S. political process, and related to the financial records of that those were irrelevant to that purpose, and that's an illegitimate purpose by the investigative committee, by the Intelligence Committee?
Well, taking the relevance question first, yes, even if you accepted that there was some legitimate legislation that could be had that reached the president, because what we're seeking here is presidential finances, when you look at the face of the...
I'm sorry, pardon, sir. Not presidential finances. We're asking for his personal returns before he became president. Those are very different things. And we're not asking him to produce it, and some of the subpoenas that Congress, through history as far back as 1792, have asked for personal papers of the president while being president. This is before he was president. I don't understand. It is, and they're not his papers in the sense of he's not in possession of them. These are subpoenas to private entities.
Okay, so there are a number of issues there. With respect to the custodian issue, this court, even going back to Eastland, has always recognized the ability of a person who stands in the precedence whose records are in the hands of a third party to come in and challenge them, and that's certainly the case here.
Well, those papers all have to do with executive privilege questions, and they're not personal. They're not personal papers. All those cases have to do with papers that belong to the office of the president. Again, these are personal papers.
Well,
briefly, counsel.
Yep, Eastland was not, didn't even raise that issue. Eastland was, in fact, personal papers. But with respect, I guess the main point I would make is whatever presumption this court has previously applied in cases that involve separation of powers, it should not put any finger on the scale for Congress's asserted legislative power in this case. And indeed, in numerous separation of powers cases, starting with Kilbourne, the court has declined to extend any presumption that Congress had a legitimate power. That was also true below in the D.C. Circuit in Tobin, in the Senate Select Committee case, and even in the AT&T cases.
Justice Kagan?
Good morning, Mr. Strawbridge. I think what strikes me about this case is, this isn't the first conflict between Congress and the president, as many of my colleagues have pointed out. We've never had to address this issue, and the reason is because Congress and the president have reached accommodations with each other, and sometimes one has gotten more and sometimes the other has gotten more, but there's always been this accommodation seeking. And what it seems to me you're asking us to do is to put a kind of 10-ton weight on the scales between the president and Congress, and essentially to make it impossible for Congress to perform oversight and to carry out its functions where the president is concerned. And you're quite right in what you said before, that this isn't going to be the last such case. And I wonder whether that fact isn't a good reason to reject your proposed rule.
Well, no, I don't think that that's the case. And for several reasons. One, the fact that this is the first time that Congress has attempted to subpoena this scale and this scope of documents from the president, and none of the other historical cases involved a direct subpoena for the president's documents in the way that this one does. I think requires this court to draw a line. It is unfortunate that the House did not attempt to seek these documents directly from the president or engage in any negotiation, but simply ran to third-party custodians and forced the president to bring this, among other things that has the effect of limiting the number of defenses the president can bring. But even on the test this court has always applied in this scenario, these subpoenas fail every hallmark of a legitimate legislative investigation. And whatever...
Go ahead, sorry.
I would say whatever power Congress has to conduct oversight of lower branch agencies or inform itself as to the workings of government, these documents are not relevant to that, and that power does not extend to the president, who is a separate constitutionally created officer.
Yeah, I mean, I think some former presidents might contest the idea that these subpoenas go further than has ever gone before, and this gets me back to what Justice Breyer has said, is that, these subpoenas are for personal records where the president is just a man. They're not for official records where the president might have executive privilege, where we have to worry about the conduct of governance and about the way the executive branch operates. And as with Justice Breyer, I guess I would like to hear your views on why that wouldn't suggest that there is a lower standard here, not a higher one.
Well, because I guess because the fact that they seek personal documents doesn't mean that they're not targeting the president, and indeed both the Oversight Committee and the House Intelligence Committee have identified the president in his role as president as one of the motivating factors for their investigation. Secondly, as this court has noted, even in Clinton v. Jones, when it rejected a broader immunity argument, there's still a need to ensure that the president is not going to face undue harassment or distraction, and there's a necessity to accommodate him. We think that that's best accommodated in this case at a minimum by applying the demonstrated need standard, in which...
Justice Gorsuch?
Counsel, I'd like to pick up right there where you left off. You argue that there is no demonstrated need, no substantial legislative purpose. The House is before us, and I'm sure we're going to hear from them that there is a substantial legislative need. Why should we not defer to the House's views about its own legislative purposes?
For several reasons, Justice Gorsuch. To begin, the subpoena power is an implied power, and this court made clear most recently in NFIB v. Sebelius that Congress cannot use its implied powers to challenge the structure of government. And a subpoena targeting the president's personal documents is a challenge to the separation of powers. In Morrison v. Olson as well, the court did not apply a presumption on either side of that dispute precisely because it was a battle between the branches. As Justice Scalia pointed out in his opinion, there's simply no need for a presumption on either side, whatever might normally apply in a case against an ordinary individual, because the president has his own powers that are created by the Constitution. And then, of course, this court, in a number of cases, as we describe, has recognized, going back to Chief Justice Marshall, that we do not proceed against the president as we do against an ordinary litigant. And so whether that was in Cheney, whether that was the limiting instruction given to the APA.
Counsel, I'm sorry to interrupt you, but I guess my question was more practical than that. Why is this subpoena not supported by a substantial legislative need?
Well, I guess three answers. Congress has not really identified with any specificity what actual valid legislation it could enact that directly reaches the president. Even if it had, it hasn't identified how documents going back upwards of 10 years, in some cases completely unlimited, and seeking the most minute financial details not only about him but his children and his grandchildren, every credit card swipe, every check, has anything to do with some purpose that would actually be permissible legislation. And I think that any allowance of the case study rationale that the House has relied upon for the Financial Services Committee is a door that opens to endless subpoenas and harassment anytime one party controls one House of Congress opposite from the president.
Thank you, counsel. Justice Kavanaugh.
Thank you, Chief Justice, and good morning, Mr. Strawbridge. On your argument that the Nixon demonstrated specific needs standard should apply, or the demonstrably critical standard, explain for me how that would play out in practice in a case like this.
Well, in a case like this, obviously, where Congress is asserting its desire to enact general legislation, I think it's going to be very difficult. I don't hold out the possibility that they could meet the demonstrated need. I mean, I don't completely rule out that possibility, although I think it is telling that the House devoted all of one sentence to each of these subpoenas, attempting to just assert very broadly that they meet the demonstrated need criteria. But if there was some situation in which Congress was actually, had put forth a statute for which they needed some information to decide whether to enact the statute was valid, and for some reason the president's personal papers were necessary to inform Congress, then perhaps in that case it could meet the demonstrated need statute. I can't imagine that any of these subpoenas could come close, given how far back they look and how much of a dragnet they set up. These are the kinds of subpoenas that the court in Watkins said very specific questions about whether they're really attempting to expose alleged wrongdoing as opposed to achieve a valid legislative end.
Secondly, following up on Justice Kagan's point about the future, on page 6 of your supplemental letter brief, you say that, quote, "It is likely that civil litigation over the subpoenas would have been foreclosed had the committee issued them to the president," end quote. And you say this case is different because the subpoenas were issued to a third-party custodian. And there's an implicit assumption there that I just want to make sure of, namely that absent a court order, the private custodians plan to comply with the subpoenas, even if the client directs or requests them not to comply. Is that correct?
The recipients of these subpoenas have indicated that they consider it to be a dispute between the president and the House of Representatives, and absent some sort of court order regarding its validity, they feel obligated to comply. And this court in Eastland recognized that it's just not reasonable to expect in this situation the third-party custodian to risk contempt of Congress or other collateral consequences. And there needs to be a vehicle to allow for review, especially in this case where the president is suffering a personal injury.
Thank you, counsel. General Wall.
Mr. Chief Justice, and may it please the Court, these cases are truly historic. 3 different congressional committees have targeted not the official records of the president, but his personal records, stretching back years before he was even a candidate for office. The potential to harass and undermine the president and the presidency is plain. It's not much to ask that before the House delves into the president's personal life, it explain in some meaningful way what laws it is considering and why it needs the president's documents in particular. The subpoenas here don't even come close. That creates 2 problems for the House. It can't satisfy any standards sensitive to Article 2 and the separation of powers, and indeed, as in Rumley and Watkins, this Court should not decide a serious constitutional question the full House itself has not confronted.
Counsel, you spent a lot of time in your brief documenting that the purpose of these subpoenas was actually investigatory rather than legislative. And if that is a pertinent consideration, I wonder how a court is supposed to look at it. Should a court be probing the mental processes of the legislators? Should members of House committees be subject to cross-examination on why you were really seeking these documents?
No, Mr. Chief Justice, I want to be clear. I don't think any of that would be permissible. All we are saying is that you should review the subpoena on the basis of the contemporaneous objective record that is the basis for the legislative subpoenas themselves. So we have not in our brief turned to legislators' statements. We haven't said that they should be able to get discovery into their mental processes or anything of the like. We have said that Chairman Cummings' memo shows the objective purpose is wrongdoing. But more important, I would just point to the mismatch between the breadth and duration of the subpoenas and their asserted purposes. I think with respect to all 3, they don't match up with what the committees say they're doing if you look at the information they're seeking.
Thank you, Counsel. Justice Thomas.
Mr. Wall, what if, following up on the Chief Justice's question, what if it was clear from those statements that you reviewed that their intention was actually to remove the president from office rather than the sort of pretextual reason that it is for pretextual legislative reasons?
I do think if you look at the statements, and we haven't urged that, but if you do, yes, I think they make clear that the subpoenas are not in aid of valid legislation. That's the only enumerated power to which Congress has pointed here. The House has not relied on impeachment, and so you would simply say the subpoenas are invalid. And to tie that into Justice Gorsuch's question earlier, I think we're not asking to go back and look at what they said or probe their mental processes. I'm just saying if you look at pages 46 and 54 of the red brief, and you look at what they actually say about their intended legislative proposals and then why they need the documents, it's paper thin. They don't give you any specifics on what they're thinking about doing or any specifics on why they need the documents. And that's not an accident. It's not the product of carelessness or thoughtlessness. It is because the purpose here is to expose wrongdoing, and the House has never really tried to substantiate why it needs these documents in service of its legislative powers.
Thank you.
Justice Ginsburg?
One must investigate before legislation. The purpose of investigation is to frame the legislation. You don't have the legislation in mind. You want to explore what is the problem, what legislative change can reduce or eliminate the problem. So, for example, the Ethics in Government Act, Congress may decide that it needs to beef up that legislation. It may also decide that for financial disclosure purposes, there should be disclosure of tax returns. So those are legislative purposes. Investigate to see if you need legislation of that sort. And then to impugn Congress's motive. I mean, even the policeman on the beat, if he stops a car and gives the reason that the car went through a stop sign, we don't allow an investigation into what the subjective motive really was. So here you're distrusting Congress more than the cop on the beat.
Justice Ginsburg, I absolutely agree that Congress can investigate in service of what legislation might be needed. Our submission is much more modest. That when that inquiry involves the president, that you need a somewhat higher standard with respect to purpose, because the room for regulating the president is so much narrower than it is with respect to private parties. And on the need side, because of the dangers of harassing and distracting and undermining the president, and that's a common theme that runs through the court's cases, that the president gets some measure of heightened protection because you can't proceed against the president as against an ordinary litigant. And all I'm saying is that Congress hasn't met that standard here.
How did that work out in the Paula Jones?
Justice Breyer?
Following this up, assume, as I do, that for reasons set out in an opinion by Judge Griffiths, that we're not very good courts at deciding disputes between two powerful political branches. So it should be rare. But if it is in front of us, why not apply the standard that is ordinarily applied to every human being in the United States in respect to, for example, grand jury subpoenas? Any human being in the United States, when he gets a subpoena, can go to a judge and say, "Judge, this is overly burdensome." And then he has a chance to show it. And here, if it's the president, the court's already written in Paula Jones 2 or 3 paragraphs of the kinds of things that a president has that are special need not to take his time, etc. But would you object to a decision of this court that says apply that, taking into account the special needs of the presidency, just like other human beings sometimes have special needs? They might be an emergency medical worker, etc.
I would, Justice Breyer, on 2 grounds. First, the court and the D.C. Circuit have rejected the analogy to grand jury subpoenas served by prosecutors. These are legislative subpoenas, not subpoenas issued by the executive branch for entirely different interests, and they trigger different concerns. These subpoenas need to be in aid of valid legislation, not as a prosecutor's subpoena to probe wrongdoing. And the second is, to take both your question and I think what Justice Ginsburg was going to get at, we do think the analogy to Clinton v. Jones is actually helpful. The court there rejected an absolute immunity, but said the president was entitled to some special protections. And we're here saying the court should take exactly the same approach. We're not saying the House has no power to get at the records of a sitting president. We're saying that it needs to satisfy a heightened standard, because if it doesn't, these requests will become routine, and that weapon in the standing arsenal of the houses of Congress will, I think, be routinely deployed in a way that harms both the separation of powers and that undermines the presidency.
Justice Alito, could you apply the standard that you think is appropriate to the subpoena from the House Intelligence Committee?
Sure, Justice Alito. So there, the Intelligence Committee says that it's investigating foreign influence in recent elections, but the subpoena goes back to 2010. It doesn't link in any way to foreign transactions, and it targets only the president. I have no idea why one would serve a subpoena that broad, both in breadth and duration, if what one is concerned about is a far more specific topic that would apply, I would think, to federal candidates more generally and more narrowly to foreign transactions and to more recent transactions. And there is nothing in the red brief that explains the mismatch. On the other side, the Financial Services Committee says it's investigating money laundering after the 2008 financial crisis, but its subpoena only goes back to the middle of 2016, and again, it targets the president. None of this makes any sense if what you are doing is in aid of legislation.
Justice Ginsburg referred to legislation concerning disclosure requirements that would apply to the president, and there's also mention of conflict of interest legislation that might apply to the president. Does Congress have the power to regulate the president in these ways?
I think think it's very unlikely on the conflicts of interest side, Justice Alito, that even the D.C. Circuit did not rely on that because of the serious constitutional questions it would pose if you disabled the executive from managing some part of the executive branch. I think the financial disclosures are the hardest, and I guess what I would say is if the House in its brief had explained with any specificity what it might want to do to the Ethics in Government Act and why then it needs the president's documents, we could have that debate. I think the room is probably narrow, but the United States is not saying there's no room. But we don't even get there because all they say is we might want to amend the EGA, CEG H.R. 1, which was a bill the House passed before it even issued these subpoenas. And so it's very hard to sort of shoot at a target. I don't know what the House wants to do with any specificity, so it's hard to say whether that's valid legislation.
Justice Sotomayor.
Mr. Wall, that's the issue, isn't it? Which is until Congress investigates, A, it doesn't have a chance to determine what might be valid, and B, we don't have a chance then to look at an actual law and say it may or may not be valid. You're asking a court in the guise of a heightened review standard to speculate as to legislation that's not in effect yet. But I want to go back to the subpoenas at issue and their breadth. You note that the Intelligence Committee goes back 10 years, but I think it's fairly common knowledge that Mr. Trump, before he was president, was thinking about running for president for a very long time. Why is it that Congress can't believe that looking at long-standing relationships and how those relationships changed or didn't change is important to knowing what undue influence might be occurring?
Justice Sotomayor, if it wants to do that, our submission is just a fairly modest one. It needs to do more than wave its hands about general purposes and say that the president would be a useful case study for prospective and generally applicable laws. Again, I'm not denying.
Mr. Wall, in what other setting does any investigative body have to do more than what was done here?
I would point to the prosecutor in Nixon.
For private records.
Well, this particular question hasn't come up to the court before in a constitutional context. But in Nixon, of course, the prosecutor had to show demonstrated specific need. In the Senate Select Committee case, the Congressional Committee had to show.
Please, I don't want you to go to executive privilege cases. I want you to go to papers that indisputably have nothing to do with Mr. Trump while he was a private person. They're not asking for these records post being president. They're asking for these records pre-being president.
I think that makes the problem worse, not better, Justice Sotomayor. They're targeting the personal life of the president before he was a candidate for office. That raises, granted, somewhat different, but deeply troubling and equally problematic constitutional concerns that you will harass on.
Justice Kagan?
Mr. Wall, I'd like to go back to your use of Clinton v. Jones, because I had read that case differently. Of course, Clinton says that you're supposed to treat the president's requests with respect when the president says, like, I need a deposition scheduled at a different time, or can we have written interrogatories rather than a deposition? But the fundamental claim of presidential immunity or even presidential difference was rejected in that case. And I suppose what I'd like to know about your argument, I read your brief and I read the president's own brief, and no place do you make a case as to why these particular subpoenas place a particular burden on the president such that he will be prevented from carrying out his constitutional responsibilities. And that's what I took Clinton v. Jones to be saying, is that's the kind of thing a president has to come in and show, a sort of case-specific argument about burden on the president. And are you making that kind of argument at all?
Well, yes and no. Not if what you mean by burden is sort of compiling and delivering the documents to the House. Yes, if what you mean by burden is what I think the Clinton v. Jones sense, which is harassing and undermining the president. Now, exactly these subpoenas, well, I mean, I think you have to look at it as
undermining the president. I mean, the point of some of those suits is presumably to harass and undermine the president, and the court let them go, let them proceed. And it said the only thing we're going to be concerned about is if you come into us and say, in defending those suits, you're going to be prevented from performing the responsibilities that we, the nation, need you to perform. Are you making an argument of that kind?
Yes. In the courts below, when the House was pressed on the limits of its theory, it said that probably it could not draw the blood of the president or read his teenage diaries. The power that they are seeking and the burden they will impose in the aggregate on the president will, I think, reshape and transform the balance of the separation of powers. So, yes, we are saying that these subpoenas, and certainly these subpoenas taken in the aggregate, once the House has this weapon, will harm and undermine the presidency of the United States, not just this president, the institution of the presidency going forward.
Justice Gorsuch?
Counsel, I believe in earlier discussions with Justice Alito, you indicated that Congress might be able to regulate in the area of financial disclosures of the president. And that is one of the interests the House has asserted here. What more would you require the House to do to assert that interest? What would be enough, in your mind, to demonstrate the heightened need you suggest is needed?
I don't think it has to go provision by provision, Justice Gorsuch, or anything like that. But I do think it's got to describe the possible legislation with enough specificity to enable meaningful judicial review. So we know the president's required to disclose certain things from the Ethics in Government Act.
Well, let me stop you there. I'm sorry to interrupt, but let me stop you there. Let's say the House says we're considering legislation on whether to require presidential candidates to disclose their tax returns for a set number of years. Would that be sufficient? And if not, why not?
I think that might be, and then you'd have to look at what they were going after from the various campaigns. It wouldn't get you anywhere near these subpoenas or targeting the president, of course. But at least in your hypothetical, they'd be identifying with some detail, some specificity, what they were thinking about doing, and then it would tee up what I think is the hard constitutional question of what's the space for Congress in regulating a constitutionally created officer like the president with respect to disclosures? And that's frankly a hard question. That's the hardest of all the possible legislation they've pointed to. I don't see how we can have that debate in this case because they haven't even enabled meaningful judicial review. And that's a fact that I think should cut against the House, not against the president.
Justice Kavanaugh?
Thank you, Mr. Chief Justice, and good morning, Mr. Wall. I want to make sure we touch on one of your procedural arguments. You say that the full House needs to authorize the subpoenas. The other side, the House, argues that Resolution 507 did so. What's your response to that?
The response, Justice Kavanaugh, is that 507, if you look at its terms, it's both a rubber stamp and a blank check. It purports to authorize anything and everything that ever has been done or will be done by the committees. It falls short then even of the fairly meager resolutions in Rumley and Watkins, which at least described general purposes, general legislative topics. This gets back to my colloquy with Justice Gorsuch. And here we're talking about the president. So I know that 3 committee chairmen understood what they were doing. I don't think 218 members of the House have understood that they understand the gravity of the constitutional question they're teeing up. And so the court often requires a clear statement from Congress when the separation of powers is at issue. We'd say the same thing here. That's the cleanest and narrowest way to dispose of this case.
Second question, history and practice matter quite a bit in separation of powers cases, as you know. Justice Ginsburg earlier cited precedent from Watergate and Whitewater, as did Justice Breyer. Can you respond, and those dealt with legislative subpoenas, can you respond to those points about those precedents?
Yeah, so for the first 200 years of the Republic, there's nothing like this. The House's examples either didn't involve the president.
What about, sorry to interrupt, but specifically Watergate and Whitewater?
So that's what I was coming to. I think the Watergate subpoenas were for official records, and obviously they were subject to a heightened needs standard. The Whitewater subpoena is the closest analogy. It's modern. It was never litigated, but I'll grant that subpoena looks very much like this one. I don't think that there's any historical precedent for it, and the concern, Justice Kavanaugh, again, if we go down this road and the houses of Congress can weaponize the subpoena power in this new way, that's going to sit in the standing arsenal for use against the president and any other constitutionally created officer. And I don't think it takes much imagination to know where that road will lead or that we will regret having taken it.
Thank you, counsel. Mr. Letter?
Yes. Mr. Chief Justice, and may it please the court, I would like to jump right in and address some of the very key points that have been made by my friends here. Mr. Wall, my very good friend, Mr. Wall, said that the legislation here doesn't match up. Mr. Wall referred the court to the wrong pages of our brief. If you look at pages 17 through 36, you see that we discussed in great detail the purposes of the investigations and the subpoenas, and indeed the D.C. Circuit said that in telling terms, the House has put legislation where its mouth is. We have specifically provided bills. Mr. Wall said that the full House did not confront the subpoenas. Page 241 of the appendix, I refer you to, where the House specifically referred to these very subpoenas, these specific ones. And I don't think Mr. Wall really meant to say that the members, 218 members of the House, did not know what they were doing when they passed that. That obviously is not a valid argument to be made. Then we turn to something that came out in answer to Justice Sotomayor's question. Remember that key records here, some of the key ones that we want, are ones that President Trump has not even seen. We want records from third-party business entities that their analyses of for instance, requests for loans. So these are documents that there's no privacy interest in, no constitutional liberty interest, etc. Next, we do have limiting principles. The House very much does. This court's precedent set those. Must be pertinent to a legislative purpose, can't violate constitutionally protected liberty interests or privileges, and can't undermine the president's ability to carry out his responsibilities.
Mr. Letter, let's talk about the standard you propose. The quotes in your brief is that it concern a subject on which legislation could be had. Could you give me a plausible example of a subject that you think is beyond any legislation that Congress could write?
Your Honor, I think the best I can do is refer you to the court's decision in Kilbourne, where the court there said that Congress didn't seem to put forward any possible legislation there. It had to do with bankruptcy proceedings that Congress was looking into.
Well, you don't think, do you think bankruptcy proceedings is a subject on which legislation could not be had?
Obviously, bankruptcy could be, but in the Kilbourne case, this court thought that no such reason had been put forward. But no, Congress's legislative authority is extremely broad, especially because of its appropriations.
Well, that's what I'm suggesting, that your test is really not much of a test. It's not a limitation. And it doesn't seem in any way to take account of the fact that we're talking about a coordinate branch of government, the executive branch. Do you have any alternative to that limitless test that would take account of the fact that you're dealing with a coordinate branch of government?
Yes, I do, Your Honor. And by the way, the test that I'm referring you to was the test that this court had set about pertinent to a legislative purpose. But, Your Honor, it's what this court said in Nixon versus GSA and a number of other cases. Congress, there would be a limit if Congress is interfering with the president's ability to carry out his Article II functions. No such claim has been made here, nor obviously can it be made.
Justice Thomas?
Yes, thank you, Chief Justice. Mr. Letter, I'd like you to discuss how the legislative subpoena power is implied, or how we arrive at that power. Because I think that's part of why we're wandering around in the wilderness trying to determine what standards we are to use.
Your Honor, this court has explained in quite a few cases, I think Watkins, Barronblatt, others, that the Congress's legislative power, investigative power, which stems from the British Parliament's power, is an obvious and integral part of legislation. We obviously can't have Congress passing legislation in ignorance. And this court has said, for instance, most recently in Franchise Tax Board, that just because a power is something to be implied doesn't mean that it's not important. For instance, this court's power of judicial review, that's nowhere mentioned in the Constitution. So the power to investigate
another example of a power that a legislative power that is implied.
I'm sorry, Your Honor, I'm not coming up with something right now off the tip of my tongue.
Okay. Can you give me the earliest example you have of Congress issuing a legislative subpoena?
The Congress investigated the St. Clair expedition. It didn't actually issue a subpoena in that case, but it's equivalent of the time. And President Washington consulted with his closest advisors and decided to provide Congress with every single thing that it requested. So that was just several years into
What's the first example of Congress issuing a legislative subpoena to a private party for private documents?
I'm sorry, Your Honor, the Watkins decision has a lengthy discussion of that. I don't have off the top of my head the very first one, but my memory is that this court describes that in great detail in Watkins.
Thank you.
Justice Ginsburg?
The concern has been expressed that Congress could be using this subpoena power to harass a political rival. So what is your answer to, what is the principle, the limiting principle that would say legitimate legislative purpose, yes, looking toward enacting a law, but not to harass a president from the opposing party?
Two answers, Your Honor. First is this court's decision in McGrain, which is extremely important here. Now, McGrain was not seeking papers of the president, but there the lower court struck down and said the subpoena was no good. The congressional investigation was no good because it was inspired by politics. This court absolutely and flatly and unanimously rejected that as a reason that it couldn't be done. And then the other is Clinton versus Jones, where this court said if there is harassment, the courts can take care of that. And that's the answer to the Justice Department's entire brief. There is no responsible claim here that all that's going on is harassment. And if there is, this court has said, we're here.
Thank you.
Justice Breyer?
Thank you. In respect to the authorization, was there proper authorization by the full House of the legislative subpoenas? 2 points. One, Roomley says, look at the subpoena and its authorization as of the time the subpoena was issued. Here, perhaps, the time that it was challenged first, before the later authorization in the full House was passed. 2, compare it with the Senate Select Committee on Presidential Campaign Activities v. Nixon. Look at the authorization. The authorization there is highly detailed, highly specific, and it suggests they could go after the information held by any person presumably including the president. This authorization, which came after the challenge, in fact writes a pretty blank check for anything without detail. Now, those are arguments made by the other side. I'd like to hear what you say.
Thank you, Justice Breyer. Several responses, and I'll try to be quick. First, McGrain, this court said very, very clearly, you don't just look at the authorization. There was no authorization there. Second, yes, Resolution 507 is in part broadly worded, but it is extremely specific in its third whereas clause. Right there on page 241, it refers to these very specific subpoenas. And in addition, authorization is much different now in the modern Congress. The modern Congress has authorized committee chairs has authorized committees to issue subpoenas, and those committees then have, in general, delegated that authority to its chairs. So the modern Congress, there clearly is authorization to committee chairs to issue these subpoenas, and as I said, if there's any doubt at all about that, the full House ratified these very specific subpoenas.
Before or after Roomley? I mean, before or after they were issued and challenged?
This is after they were issued and challenged. The issuance, as I said, is authorized by House rules, which this court has said it will not examine. And then the full House, because there were arguments made, the full House said, oh, no, we authorize these exact subpoenas. We ratify the issuance of these subpoenas. It is extremely clearly worded, page 241A of the petition appendix.
Thank you.
Justice Alito? Mr. Letter, I was somewhat baffled by your answer to Justice Ginsburg about the use of congressional subpoenas for purposes of harassing a president. Your final answer was the courts can take care of that, but that's the issue here, whether something should be done to prevent the use of these subpoenas for the harassment of a president. So could you explain what you meant?
Absolutely, Justice Alito. This court in Clinton versus Jones and in other cases like Nixon versus GSA has said we are here to protect the president if there is harassment from Congress or private individuals. And here, there clearly, though, is, we think, valid legislative purposes. The four courts below all found that there was.
I don't want to cut you off, but I have very limited time. So your answer is that the protection against the use of a subpoena for harassment is simply the assessment whether the subpoena is relevant to some conceivable legislative purpose.
Correct. That's what the court has said, but also, again, Clinton versus Jones and Nixon versus GSA.
And that's not much protection. In fact, that's no protection, isn't it?
It is protection, Your Honor, if what Congress is doing is interfering with the president's ability to do his job. These subpoenas are to private parties. The president does not need to do anything. When you talk about
interfering with the president's ability to do his job, do you mean this is going to take up too much of his time? Or does that include the potential for the use of subpoenas solely for harassment and political purposes?
Your Honor, if they were solely for harassment, then they wouldn't meet the standards of they have to be pertinent to a legislative purpose. So I think the combination of all of those provides ample protection, but there's no...
You were not able to give the Chief Justice even one example of a subpoena that would not be pertinent to some conceivable legislative purpose, were you?
As I said, Your Honor, that's correct, because this court itself has said Congress's power to legislate is extremely broad, especially when you take into account appropriations.
Well, so the end result is that there is no protection whatsoever, in your view, and maybe this is the correct answer, but in your view, there is really no protection against the use of congressional subpoenas for the purpose of preventing the harassment of a president, because the only requirement is that the subpoena be relevant to a conceivable legislative purpose, and you can't think of a single example of a subpoena that wouldn't meet that test.
No, Your Honor, because remember, there may be constitutionally based privileges or things like executive privilege.
Well, there might be constitutionally based privileges. Which constitutionally based privileges apply to a subpoena for records in the hands of a third party?
There could be, Your Honor.
What are they? Would you name one?
Oh, well, it seems to me executive privilege could enter in. State secrets privilege could enter in, depending upon the specific circumstances, Your Honor.
Let me ask you one more thing, if I can, and there's time. Are there any limits on using a president's records as a case study relating to the need for legislation? So, for example, if the salary and the net worth of a future president before election was that of a person who would be regarded as middle class, and Congress says, we want to study possible revisions of tax laws and the provision of services to members of the middle class, so we're going to subpoena all available information about the assets, income, expenditures, and services obtained by this sitting president and his family for purposes of considering that legislation. Would that be permissible?
It certainly could be, Your Honor. So here, that's a very good question. Here, remember, the Financial Services Committee is doing an extremely broad investigation of a financial services sector, and there's massive public reporting that before he became president, President Trump's personal records and his businesses and his family have been heavily involved in those very activities. And we're investigating numerous other banks and individuals having nothing whatsoever to do with the president. This is part of a much larger sector-wide, industry-wide investigation, and President Trump is...
Sotomayor? Counsel, we have said that personal records, with the aim of making the president a case study, threatened to run afoul of this court teaching that there is no congressional power to expose for the sake of exposure. And the other side, some hypotheticals that are troubling. The president's transcripts, simply to pass on educational reform legislation, or subpoenas of his personal medical records, simply to enact general health care reforms. Tell me what we say to ensure against those hypotheticals and against a proposed subpoena that might be just for the sake of exposure.
Your Honor, a couple of answers. One is, yes, you said just for the sake of exposure is no good, but this court said that exposure involving government activities can be. Pertinence would be the key. Pertinence to a valid legislative purpose. And here, the Intelligence Committee, there's an obvious need to focus on the president's financial records to determine if the president is subject to foreign leverage. It's obvious that ties in with that legislative purpose. So pertinence.
Let me put this. I'm sorry to interrupt you, but we're limited in time. On that issue of what laws are possible, I can see the argument on conflicts of law, but aren't there already a lot of disclosure laws in place? How could this investigation help improve those or change those?
I assume what Your Honor is referring to is disclosure laws by the president, and so we would have to look to see what the Oversight Committee was looking at. Do we need better laws about conflicts of interest? Do we need better laws about, for example, a president dealing in contracts with government agencies. The Congress could limit government agencies' ability to enter into or keep contracts with elected public officials. In addition, Congress maybe would want to provide for more exposure of assets and conflicts of interest.
One last question. Was the breadth of these subpoenas litigated below?
Yes, Your Honor. Yes, Your Honor. Those exact claims were made, and they are discussed in great detail by the Second Circuit and the D.C. Circuit. So those were fully litigated below.
Justice Kagan.
Good morning, Mr. Letter. In talking to the Chief Justice about the limits on congressional power, you said, and tell me if I'm quoting you correctly, you said that a subpoena couldn't impair the president in carrying out his constitutional functions. Is that right?
Your Honor, there would have to be a balance there.
Okay, but that's what we should be looking to. And then you said no such claim has been made or could be made. And I also took the briefs not to be making that claim, that this subpoena would impair the president in carrying out his constitutional functions. But Mr. Wall told me that he was kind of making such a claim because he thought that this subpoena would undermine the president in his job. And I guess I would like you to comment on that.
Your Honor, it's fascinating because I wrote a note specifically on that. That argument was not made in the Justice Department's brief, to my knowledge, anywhere. My friend Mr. Wall mentioned it here, but there's no way that this could interfere with the president because he doesn't have to do anything. This is a subpoena to two banks and an accounting firm. And as I said before, in fact, some of the key documents we want, the president probably has never even seen or doesn't even know that they exist. We want to know banks' analyses of his request for a loan, internal bank analyses. But yes, Your Honor, that argument was not made in the briefs.
Okay, and if I could get you to talk about the history that some of your colleagues have talked about, what do you think the history shows us with respect to this issue?
Your Honor, very briefly, what it shows is ties in with a key principle of law that this court has said of constitutional interpretation. History can help inform what the Constitution means. There's a lengthy history of presidents either voluntarily or not voluntarily complying with requests for information by Congress. And we went through presidents Washington, Jackson, Buchanan, Grant, and then more modern times, Nixon, Carter, Reagan, and Clinton, all complying with in various ways, either voluntarily or not. For instance, in the Nixon case, Nixon voluntarily provided certain tax returns. He didn't provide all of them. Congress then got more pursuant to statutory authority, like a subpoena, from President Nixon and his family's tax returns. I don't think that either the Justice Department or Mr. Trump answered that hypothetical. History really matters here, and it shows that the arguments being made here by President Trump are astonishingly ask you to ignore a massive amount of history.
Thank you.
Justice Gorsuch?
Good morning, Mr. Letter. Normally, we use law enforcement investigative tools like subpoenas to investigate known crimes and not to pursue individuals, to find crimes. That's a principle you're well familiar with from your time in the Department of Justice. And I'm wondering what limiting principle you offer us here that can prevent that danger. The first one was it has to be pertinent to a legislative purpose, but I think as we've explored, that's very, very broad and maybe limitless, some would suggest on the other side at least. Constitutional privileges, if you're investigating someone in their private capacity, they're going to be few, maybe attorney-client privilege, things like that. And it can't be burdensome, I heard, was your third, but in an age where everything's online and can be handed over on a disk or a thumb drive, that pretty much disappears too. So what is left to protect that important value that I know you share?
I do share that, Your Honor. And by the way, burden here, none of the subpoena recipients have claimed burden. Your Honor, I answer it this way because, again, it has to be, I'm going to stick with the pertinent to legislative purpose because, for example, Congress did a massive investigation of what happened at 9/11. Obviously, a lot of that.
Let me stop you there. If that's where you're going to go, and I thought that might be, Mr. Letter, and I apologize for interrupting, but I would think a federal prosecutor might say that an investigation of an individual could be pertinent to a criminal investigative purpose too, because there's so many federal crimes out there, and it's possible this person jaywalked or failed to pay his taxes or whatever his concern is. That's a legitimate investigatory purpose for sure. So what takes us out of that realm and that concern?
Your Honor, I think this will largely depend on the courts. The only thing I can suggest that takes it out of that concern is, as we know, Congress can't prosecute, but as we know, it clearly can look into criminal activity in order to figure out whether the criminal laws should be changed. The most obvious example would be this court's decision just a little while ago overturning a key criminal conviction involving white-collar crime. Obviously, Congress could do a very thorough investigation of that to determine whether to pass a different criminal law statute that would actually make it a crime to do what was done in Bridgegate. So it's going to be very difficult to separate the two and say that what Congress is doing in looking into criminal activity for the purposes of determining if the FBI is doing a good job and needs more money, or whether to amend the criminal statutes. There's going to be an extremely rare case where that is going to be invalid on Congress's part.
Justice Kavanaugh.
Thank you, Mr. Chief Justice, and good morning, Mr. Letter. I want to follow up on the line of questioning that several of my colleagues have pursued, the Chief Justice, Justice Ginsburg, Justice Alito, Justice Kagan, and others, which I think come down to the idea of limitless authority and how to deal with that. The other side says that allowing these subpoenas and subpoenas like these, say for medical records, would be a grave threat to future presidencies. It would be open season, they say, on private records of anyone who is president, and maybe other government officials too. And they worry about the harassing nature of subpoenas like that. You say, and Justice Gorsuch was just exploring this, it's okay so long as it's pertinent to a legislative purpose. But I think everyone has explored with you that just about everything can be characterized in terms of a subpoena as pertinent to a legislative purpose. I don't think you could answer the Chief Justice's question about something that wasn't. And the question then boils down to how can we both protect the House's interests in obtaining information it needs to legislate, but also protect the presidency? How can the court balance those interests? I guess the thing I would say is, why not employ the demonstrably critical standard or something like that? This is what the other side would say, as something that's borrowed from a different context, but that might serve to balance the strong competing concerns here.
Your Honor, that's a very good question. I have several responses. The first one goes to the last thing you said about why not employ a demonstrably critical test. I don't know how the courts would do that without violating the separation of powers. I was reminded recently by the congressional leaders that often they're doing investigations. They don't know where the legislation might go at that point. So I don't know how you would force Congress to show some sort of demonstrably critical reason.
Wouldn't it be the same way that it's shown in an investigation where executive privilege is asserted, and the demonstrably critical standard in that context has been the tried and true method for about 50 years.
Because then, Your Honor, you could demand that the executive branch show that its reason for seeking something outweighs the executive privilege claim. But here, and remember, we're not dealing with executive privilege at all. These are financial business records. It's difficult to see how these could ever come within that kind of balance that would override Congress's authority to do investigation. The one other thing I can suggest, obviously, is this court has suggested, I believe, is the voters. But also Nixon versus Fitzgerald, where this court said that the president has absolute immunity from certain kinds of claims. The court said specifically that one of the reasons that's okay is because we have congressional oversight of the president. This court specifically used that to justify absolute immunity for the president in other areas. And last is Clinton versus Jones. This court...
Can I interrupt right there? What about medical records?
Your Honor, medical records of the president would, I think, almost always be not pertinent to valid legislative purpose. On the other hand,
why not?
Look at the 25th Amendment, they certainly would be pertinent.
Why wouldn't they be pertinent to, say, ethics legislation, healthcare legislation, or the like, in your view?
Your Honor, I'm having difficulty thinking of a hypothetical where if Congress is examining and deciding on amendments to the Affordable Care Act, how the president's personal medical records would be relevant to that. As I say, the most important public health statute of many, many decades, I don't think would be affected by that at all. So I'm sure we can come up with some odd hypotheticals where presidential health would clearly be relevant, maybe changing the statutes that involve the succession of when a president becomes incapacitated, something like that, I suppose. But in general, Congress, there would be no valid reason for Congress to be asking for the president's personal medical records that I can think of.
Thank you, Counsel. Mr. Letter, I know you will be delighted to learn that we have time for additional questioning. So I think I'll begin with myself, and then we'll go through in order and just see how far we get. One thing that hasn't come up is the fact that we're dealing here with 3 separate committees, and we're concerned, as you've recognized, with the potential for harassment. And how does that play in? I mean, at what point does the number of committees investigating the president's personal papers become a factor in an analysis of the committees investigating the president's personal papers become a factor in an analysis of the issue of harassment?
Your Honor, I am very pleased there's more time for questions. But, Your Honor, it would seem to me that there are situations, again, you'd have to look to, Clinton versus Jones. When does it reach a particular stage? We're nowhere near that here. And, in fact, the subpoena by the Intelligence Committee matches the subpoena from the Financial Services Committee to Deutsche Bank because specifically intelligence did not want to cause too much of a burden to the subpoena.
What about as you know, very shortly in the second case, we're going to talk about subpoenas from district attorneys. How does that factor in? I mean, should those be counted in the balance in terms of when congressional subpoenas become harassment?
Definitely not, Your Honor. Since we had nothing to do with such the subpoena advance, we had no contact with the city of New York before that subpoena was issued, and so I don't know how that would tell us anything about what the House of Representatives.
What about the Senate? I suppose they can issue subpoenas too, can't they?
Of course, Your Honor. Yes. So
how do you balance that? You've got, in this case, 3 different House committees seeking subpoenas. You've got the district attorney in New York, depending upon party composition of different bodies in the future, you might have the Senate joining in. How do you measure harassment in a case like that?
Your Honor, I think what you would do is if these were subpoenas from the House and the Senate, a massive number of them going to the White House, then there certainly would be, at a certain point, private businesses involving...
Thank you. Justice Thomas, any further questioning?
Yes, I'd like to follow up on that, Mr. Chief Justice. Mr. Letter, at some point, there's a straw that breaks the camel's back. And it seems as though you're saying that we should look at these in isolation as opposed to in the aggregate. Why wouldn't we look at all of them and look at the full effect and whether at some point it debilitates the president?
I'm sorry, I must have misspoken. I meant to answer the Chief Justice's question by saying, yes, if there are a massive number of subpoenas from the House and the Senate to the White House, and the White House can come in and say, look, we can't do anything. All we're doing is answering subpoenas all day long. This is impacting the ability of the president to do his job.
Why would it be limited to the House and the Senate? I mean, it could be every grand jury. It could be every prosecutor. The concern that we had in the Clinton case is at some point it gets out of control. One could be manageable, but 100 could be impossible.
And Your Honor is right. And therefore, if our subpoenas were on top of numerous others from grand juries around the United States, you could look at that. But let me emphasize one more time, our subpoenas the three are not to the president. They are to private business entities. Nothing is required of the president here for these subpoenas to be fully complied with. Not a single thing is required of the president or the White House.
Justice Ginsburg,
we all know it's about the president.
Justice Ginsburg, any further questioning?
No, I'll pass.
Justice Breyer.
Yes, he's emphasized it goes to a private person and it's for tax returns. But the subpoenas that I've seen go far beyond that. They apply to 15 Trump-affiliated entities. They ask for all documents related to opening of accounts, due diligence, closing, requests for information by other parties, etc. Now, that's a lot of information, and some of it's pretty vague. And if somebody subpoenaed you for that information, or subpoenaed your tax accountant, or subpoenaed somebody in your business, wouldn't you at least want to know what was being turned over? Wouldn't you want to ask them? And might that not take time? And might that not take effort? So my problem is there may be burdens here, third party or not, and not just political burdens. The job of the House and Senate, in part, as the president, is politics. That doesn't bother me. But the Clinton v. Jones information does bother me. And the fact that what I hold today will also apply to a future Senator McCarthy asking a future Franklin Roosevelt or Harry Truman exactly the same questions, that bothers me. So what do I do?
Justice Breyer, I fully understand that concern. None of the subpoena recipients have complained about burden. The reason these subpoenas go back a ways is because, as you know...
I'm sorry to interrupt you. I'm not talking about their burden. I'm talking about the president's burden in having to monitor, decide if there are privileges, figure out what his answers are to all those documents you are requesting, which go, in my opinion, way, way, way beyond just tax returns.
Two answers, Your Honor. Yes, we're going far beyond tax returns, but no privilege claim has been made in this case. No party, nobody has raised a privilege claim. Second is we're investigating, for instance, among other things, money laundering. Money laundering requires looking at a whole range of financial activity. What we're doing here is exactly the kind of thing that Senate and House staff do when they're looking at financial sector and what kinds of reform should be made to the banking industry. But let me say one more time, there has been no claim of privilege here. There has been no claim that there is a burden. No claim whatsoever. So those may be relevant in different cases, but certainly not this one.
Justice Alito?
If one house of Congress were to subpoena personal records in the hands of a third party regarding a member of the other house, let's say someone in a leadership position in the other house, do you think that the doctrine of separation of powers would impose any limitation on that subpoena?
Very interesting question. Your Honor, the first thing that comes to mind, though, is wouldn't that violate the speech or debate clause? Remember, no member of either the House or Senate can be questioned anywhere else. And so if there's a request for records, if it's tied in any way to the legislative functions of that senator or House member, that would be invalid.
Well, let's say that it's similar to the subpoenas here. So they don't have anything to do with the performance of a legislative function. They are records regarding the personal activities of this individual, purely personal activities. And we can even say that they concern things that were done before the person was elected to Congress.
That you still, and does part of your hypothetical include that they would nevertheless be pertinent to a legislative purpose?
Pertinent to a legislative purpose. The committee wants to use someone in the leadership position in the other house as a case study for possible legislation.
If it met, then your hypothetical, I think that would be a valid subpoena. I'm not aware that it has ever happened in the history of the House or Senate. I don't know of anything that would be like that.
Justice Sotomayor, anything further?
Yes, that's the whole point, though, isn't it? Justice Alito is raising this hypothetical because he says, shouldn't then we look at history, and it's only modern history where committees have asked for personal papers, so he presumably would discount that, and he would say, shouldn't we respect the separation of powers, that what's personal to the president is similarly personal to a congressperson?
Justice Sotomayor, I have to disagree strongly with one thing you said, a key part. No, the history, we have history of Congress seeking personal papers of Jackson, Buchanan, Grant, et cetera. No, there's been lots of seeking of personal papers by Congress for many, many decades. This is not just a modern practice at all.
So Justice Kagan?
Mr. Leonard, I'm wondering if I could ask you to comment on a potential difference between, on the one hand, the Oversight and Intelligence Committee subpoenas, and on the other hand, the Financial Services subpoena. The first two subpoenas address the president directly, the financial disclosures that the president makes, conflicts of interest, foreign involvement in presidential campaigns. But the Banking Committee, Financial Services Committee, was taking a much broader scope. And when that's true, when the Congress doesn't seem to be looking into the president, but in a much broader topic, might there not be some heightened need for Congress to say why it is that they're focusing on presidential records for that purpose?
Your Honor, I think that still would raise major separation of powers problems, as a court would have hearing. The court would ask chairmen of various committees to come and testify as to what they were doing and why. You're certainly right in your description. There are 11 subpoenas issued by financial services to members of banks, et cetera. And only two of them have to do, three subpoenas, two entities, have to do with the president. This is a much, much broader investigation. And last is, there's massive public reporting about the subjects of these subpoenas and their banking practices. And Deutsche Bank and Capital One have both been sanctioned millions of dollars by banking regulators for failing to properly comply with money laundering law.
Justice Gorsuch, anything further?
No, Chief, thank you.
Justice Kavanaugh.
Yes, thank you, Chief Justice. And Mr. Letter, I want to follow up on Justice Alito's question. And this really goes to the fact, I think, that there's concern about what the limiting principle is here. I think pertinent to a legislative purpose is almost no limiting principle at all. At least I think that's what some of the questions have explored. And his hypothetical about a committee would start subpoenaing members of Congress of the other House or of the other party. And you said, well, that hasn't happened. But isn't the whole point that once you start down this road and this court articulates too low a standard, that something like that will start happening? That's the concern that I heard identified, or that I took away from that hypothetical. So I want to give you a chance to respond to that hypothetical of why it wouldn't spiral.
I greatly appreciate that chance, Justice Kavanaugh. Two responses. First, remember exactly what this court did in Clinton versus Jones. And I was on one of the losing briefs there. But this court said, we're going to let this happen because, but the courts will monitor the situation, and if there are abuses, the courts are still here. In addition, the Justice Alito's hypothetical, I also realize it might be there getting into things like privilege information or information involving constitutional liberty interests, and that's what this court has struck down. Criminal convictions, et cetera, for subpoenas that do involve.
Well, if it was personal records exactly identical to the personal records here, but from members of Congress, none of those would apply, presumably, at least under what you've articulated so far today.
I think that's right. But again, I come back to Clinton versus Jones. This court issued a very clear decision saying we're going to allow this one. But obviously, the courts are going to monitor this. So if, contrary to what has happened in the past, over our lengthy history, if there are situations when the president's ability to do his job is being undermined, thank goodness the courts still exist, and they are there to take care of it.
Mr. Letter, would you like to take a minute to wrap up?
Your Honor, I greatly appreciate that. I'm sorry, just flipping back to my notes. I apologize. As I was saying before, remember that some of the key records here are ones that the president has never seen and never had anything to do with, and we asked the court to focus on the specific subpoenas in this case. Because we're not dealing with what-ifs here. We're not dealing with situations where a lot of the Justice Department argument focuses on. As I said before, fortunately, this court exists to fix those kinds of situations should they arise.
Thank you, Mr. Letter. Mr. Strawbridge, you have 2 minutes for rebuttal.
Thank you, Mr. Chief Justice. My friend from the other side struggled with every hypothetical that he was given about his ability to set some sort of limiting principle or some category of information or documents about the president that would not be obtainable under his theory. And I think that's very telling because there are no limits to their theories. And in particular, let's just consider the example that was given regarding medical records. There's no reason under his theory why the president and his family and his grandchildren could not be declared useful case studies, and therefore Congress would send out a subpoena for their medical records. For that matter, the president eats and drinks like everybody else, and Congress naturally has the ability to regulate food safety. But that does not mean that Congress can subpoena medical records or even the president's DNA. My friend refused to even rule out that hypothetical categorically below, and I think it's telling that he can't provide any meaningful limit today. And I think that's consonant with the fact that they failed to consider what their actual legislative need is. This is an implied power in aid of legislation. It's not a free-ranging warrant to investigate wrongdoing going back 10 years. He cites to a laundry list of legislative proposals, almost all of which were passed before these subpoenas even issued, and at no point in the argument section of their brief or today does he try to tie any particular legislative proposal specifically to the president, the finances, let alone the vast swath of documents that they seek here. This is not an attempt to preserve the separation of powers. It's an attempt to eviscerate that. On that point, I wanted to note, in response to Justice Breyer's question, which I may have misunderstood, the Senate Watergate Committee, in fact, did serve congressional subpoenas under the legislative power, and applying the heightened need standard, the D.C. Circuit invalidated it, just as this court invalidated the attempt to hold in contempt somebody in Kilbourne when it violated the separation of powers, just as the lower courts, every time separation of powers has squarely been presented, has invalidated it. These subpoenas are overreaching. They are an obvious distraction. They are going to multiply if this court accepts the path that the House is attempting to lay. The decisions below should be reversed. Thank you.
Thank you, counsel. The case is submitted.
C-SPAN, your unfiltered view of government, created by cable.
We'll hear argument next in case 19-635, Donald Trump versus Cyrus Vance. Mr. Sekulow?
Thank you, Mr. Chief Justice, and may it please the court. No county district attorney in our nation's history has issued criminal process against the sitting president of the United States, and for good reason. The Constitution does not allow it. Temporary presidential immunity is constitutionally required by Article 2, and accordingly, the Supremacy Clause defeats any authority the DA has under state law adds to the president. the Second Circuit is wrong and should be reversed. If not reversed, the decision weaponizes 2,300 local DAs. An overwhelming number of them are elected to office and are thereby accountable to their local constituencies. The decision would allow any DA to harass, distract, and interfere with the sitting president. It subjects the president to local prejudice that can influence prosecutorial decisions and to state grand juries who can then be utilized to issue compulsory criminal process in the form of subpoenas targeting the president. This is not mere speculation. It is precisely what has taken place in this case and with the subpoena we challenge. In the argument just concluded, we asserted that the subpoenas did not serve a legitimate legislative purpose, and they were burdensome. Yet the DA copied almost verbatim the House Oversight Committee subpoena with an additional 13 words which seek the president's tax returns. How revealing. The exact same language utilized by two congressional committees would subsequently be copied by the New York County District Attorney, covering the exact same documents and sent to the exact same recipients, yet purportedly for two completely different reasons. Under Article 2, or the heightened scrutiny standard under Nixon, the subpoena we challenge today cannot survive. As the Second Circuit concluded and the DA represents, the president's being investigated for potential criminal violations in a state grand jury proceeding with a local DA issuing coercive criminal process against the president. This he cannot do. Thank you, Mr. Chief Justice.
Counsel, for all that, you don't argue that the grand jury cannot investigate the president, do you?
We did not seek to have an injunction, as was the case involving Vice President Agnew, in enjoining the grand jury. We have targeted the utilization of the temporary immunity here to the subpoena. That's correct.
Well, in other words, it's okay for the grand jury to investigate, except it can't use the traditional and most effective device that grand juries have typically used, which is the subpoena.
It can't use a subpoena targeting the president. And under his Article 2 responsibilities and the Supremacy Clause, that is our view would be inappropriate and unconstitutional. So we have not challenged the investigation.
I don't understand. Your theory in terms of distraction and all that would seem to go much farther than resisting the subpoena. I don't know why you don't resist the investigation in its entirety, or why your theory wouldn't lead to that.
Well, our position is that criminal process against the president, and that's what we're talking about, that's what's before the court. Criminal process targeting the president is a violation of the Constitution. We did not seek to enforce an injunction or seek an injunction against the grand jury investigating the situation with the president.
You focus on the distraction to the president, but I don't know why in Clinton versus Jones we were not persuaded that the distraction in that case meant that discovery could not proceed. And there are different things that distract different people, but I would have thought the discovery in a case like Clinton versus Jones, even though civil, would be distracting, as you argue the grand jury proceedings are here.
Well, Clinton versus Jones, of course, was in federal court. This is in state court. Clinton versus Jones was a civil case. This is a criminal case. And as this court noted on page 691 of its opinion, if, in fact, the Clinton versus Jones case had originated in a state court proceeding, it would raise different issues than separation of powers, concerns over local prejudice. And in footnote 13, this court said that any direct control by a state court over the president may implicate concerns that are different than the interbranch disputes under separation of powers. So it would be
Ms. Thomas?
Yes, counsel, just a couple of questions. I'm interested in whether or not you can point us to some express language at the founding or during the ratification process that provides for this immunity.
Well, there's a couple. There was a colloquy between ultimately Vice President Adams and Senator Ellsworth, where they talked about process against the president, and they took the position that any process against the president would be constitutionally problematic. Thomas Jefferson, of course, wrote in the letters he had regarding subpoenas that were issued in the Byrd trial that allowing local magistrates to banter about a sitting president from north to south and east to west would interfere with the president's responsibilities. And as this court just in the previous argument just stated, the burdensome nature of this is categorical. It's not, you can't just look at the one subpoena. It is the potential for 2,300 DAs, or just 1% of them, 23 DAs issuing process against the president. But the concern over interference from our founding with the president's responsibilities was discussed, and that's why in the Constitution there's process to deal with it.
Does it make a difference when a subpoena goes to a third party?
Certainly not here. Number one, the respondents have either forfeited or waived it. They have conceded in their brief that they are seeking the president's documents. These are the president's documents. He is the real party in interest, and he has the burden, including review with his counsel over any existing privileges and what these documents might entail.
Thank you.
Thank you, Justice Thomas.
Justice Ginsburg?
We have said in the grand jury context that the public has a right to every man's evidence. Is it your position that that is save for the president, every man's evidence, save for persons protected by privilege? And there is no privilege involved here. These are non-privileged, non-confidential papers. So is the grand jury right to every man's evidence exclusive of the president, every man except the president? That's one question. And then I wanted you to answer specifically. Paula Jones has held that the president was not immune from civil suits for conduct occurring before he took office. If Paula Jones had sued in state court rather than federal court, would Clinton have had absolute immunity?
Well, this to the second question first, if I might, Justice Ginsburg. This court in Clinton against Jones said that if the case was brought in state court, it would raise different issues of concerns over local prejudice. It was different than the separation of powers issues at play. It was issues involving the Article 2 and the Supremacy Clause. So the court said that on pages 691 and footnote 13. With regard to every man's evidence, this court has long recognized that the president is not to be treated as an ordinary citizen. He has responsibilities. He is himself a branch of government. He is the only individual that is a branch of government in our federal system. So our position is that the Constitution itself, both in structure and text, supports the position that the president would be temporarily immune from this activity from a state proceeding while he is the president of the United States.
Justice Breyer?
Every man's evidence excludes the president.
If I may, Mr. Chief Justice, Justice Ginsburg, it's not that it excludes the president. The president is not to be treated as an ordinary citizen, and this is a temporary immunity. This is for while the president's in office, and we think that is required by the Constitution. Thank you.
Justice Breyer.
Well, you make a point of the 2,300 district attorneys, but of course in Clinton v. Jones there might be 1 million, I don't know, tens of thousands of people who might bring lawsuits. Perhaps all of them were unfounded, but they could file the paper. Why isn't it sufficient just to apply ordinary standards? I gather ordinarily any person gets a subpoena, can come in and say it's unduly burdensome. And what counts as unduly burdensome for a doctor who's in the middle of an operation might be very different from a person who's a salesman. And similarly for the president, all the factors you raise could come in under the title unduly burdensome. So why not just go back? Let the president say, I'll show you precisely how this is burdensome. I'm going to spend time, effort, working all these things out, figuring out what they mean, etc. And if he shows undue burden and lack of connection, he wins, and otherwise not. That's true of every person. That's Clinton v. Jones. Why not the same here?
Justice Breyer, the hypothetical you just gave, I think, proves the point. By the time you were to prepare, review, analyze the various requests, just in these three cases that we have today, shows the burdensome nature. And then to require the President of the United States, and as you raised in your opinion, in a concurring opinion in Clinton versus Jones, that burden is being met just by us being here. But to require the President to have to respond to each and every state district attorney that would like
he would hire you, and he'd hire a lawyer to list what the burdens are. That wouldn't take a lot of time. And then he wouldn't be burdened because you'd go in and say what the burdens are. And if you're right, you win that case. They are saying the other side, there are no burdens here.
Well,
you say there are. So send it back and let them figure out what they are.
I think doing that establishes the problem with an analysis of a case-by-case analysis. For instance, in this very case, in this subpoena found on page 118A and 19 of the petition appendix, there's a list of documents that are extensive. You would have to meet with the President of the United States. I mean, could you imagine just for a moment, Justice Breyer, that and you said let's assume the President were to hire me, that I'm going to call the President of the United States today and say, I know you're handling a pandemic right now for the United States, but I need to spend a couple of 2 to 3 hours with you going over a subpoena of documents that are wanted by the New York County District Attorney. I know you're busy, but can you carve me out 2 hours?
Justice Alito?
Are there at least some circumstances in which the U.S. Constitution would permit a local prosecutor to subpoena records containing information about a sitting president? So think of this situation. Suppose that the prosecutor has good reason to believe that the records contain information that is not available from any other source about whether a third party committed a crime, and suppose that waiting until the end of the president's term would make the prosecution of that crime impossible or at least very difficult. Would you say that at least in that circumstance it would be permissible for the grand jury subpoena to be enforced?
In a state court proceeding, the issues of time and burden are still there. Now, in U.S. v. Nixon, that was a case where the president was a witness, and the documents were asked for, and this court said it should be handed over. But in that case, it was very clear that the president was a witness, and the attorney, the independent counsel there, Leon Jaworski, specifically stated to this court that the president was not a target. So if we had a pure witness standpoint, while it's a different case, the same constitutional principles would be at play, but here we're talking about criminal process targeting a president.
Well, was the answer that that would be permissible if the prosecutor were willing to say that the president was not a target, whatever that means?
Well, it wouldn't mean that it's constitutionally permissible. It would raise different issues for the president to consider. But constitutionally, I think that I have to be very clear here. That constitutionally, under Article 2 and the Supremacy Clause, adds to a state court proceeding here, we think even as a witness, it raises serious issues. Obviously, a very different case than this, but serious issues nonetheless.
Thank you. Thank you, counsel. Justice Sotomayor.
Counsel, it seems that you're asking for a broadness of immunity that Justice Thomas pointed out is nowhere in the Constitution. And in fact, the Constitution protects against presidential interference with state criminal proceedings. It doesn't allow the president to pardon offenders for state prosecutions, for state criminal convictions. And yet, I find it odd that you want us to rule that there's essentially an absolute immunity from investigative powers, the height of a state's police powers, and that we would permit a civil damages case by a private litigant, which we did in Clinton. Prosecutors have ethical obligations with respect to grand jury investigations. They have to keep those investigations secret. They can be prosecuted if they leak that information. Don't we usually presume that state courts and state prosecutors act as they should and in good faith?
Even if you were to assume that...
If you let me finish. And doesn't the president always have the opportunity to show that a particular subpoena in fact, was issued in bad faith. President was given that opportunity here, and a affidavit, I understand, was filed under seal, setting forth the reasonable grounds for the investigation. I'm not sure why he's entitled to more immunity for private acts than he should be for public acts.
Well, he's the President of the United States. He is a branch of the federal government.
We only give judicial officers and congressional officers immunity for acts within their official capacity. If they don't, if judges sexually harass someone, we've said that's not within judicial functions, they can be sued. If congressmen do the same thing, they can be sued. So my question still comes. You're asking for a broader immunity than anyone else gets.
Well, we're asking for a temporary...
We have time for a brief answer, counsel?
I will. We're asking for temporary presidential immunity. I would point out that under New York state law, witnesses before a grand jury are not sworn to secrecy. They can state that they testified and what the nature of their testimony was. I'd also like to point out that there are hundreds of members of the United States Congress and 100 members of the United States Senate. There is one president. Thank you.
Justice Kagan?
The president can't be treated just like an ordinary citizen, but it's also true, and indeed a fundamental precept of our constitutional order, that a president isn't above the law. From our first days, Chief Justice Marshall told Thomas Jefferson that he could be subpoenaed, he could be examined as a witness, he could be required to produce papers. And so I guess going back to Justice Breyer's question, why isn't the way to deal with these two things, that the president is special, but that the president is like an ordinary citizen in that he's subject to law, is to say the president can make these usual objections that a subpoena recipient can make about harassment or about burden, and the court, in reviewing those, of course, should take seriously the president's objections and treat those with a certain kind of sensitivity and respect due to somebody who is a branch of government. Why isn't that the right way to do it?
For two reasons. First, and I think the case here is the perfect example. Here, the district attorney copied verbatim the House Oversight Committee and Ways and Means Committee subpoena verbatim. So, and we were just discussing in the previous case the nature of that burden. For counsel, the president hiring counsel, for each time he could be subpoenaed as a witness, or in this particular case as a target, would raise a serious impact on the president's Article 2 functions. So we think a categorical approach, and it's very specific here, state process as to the president, targeting the president's documents in a criminal proceeding should be prohibited.
Justice Gorsuch?
Counsel, I'd like to return to the question of Clinton versus Jones and how you would have us distinguish it. Yes, it took place in federal court, but it was a civil case, and as has been pointed out, there could have been multiple versions of that in multiple different districts across the country. So what's different about that? How do we avoid the conclusion there that the president wasn't subject to some special immunity, but here is?
I think the nature of the case that we're dealing with here is not in a vacuum itself. There are other cases that the president is dealing with at the same time. So what may have been a situation for President Clinton with a lawsuit, we have multiple litigation going on, including with the New York Attorney General. So I think the Supremacy Clause issue and the Article 2 issue here is pronounced, as this court alluded to, in Clinton against Jones, for that very reason, this idea that local prejudice would impact the president. So the idea that we would wait until there's more of these, we're already here on 4 subpoenas, or 3 subpoenas, 3 cases involving multiple subpoenas, much of which covers the same documentation. So I think it in fact, Justice Gorsuch, proves the point. We're here because the House has asked for documents that now the district attorney is asking for. So we are seeing that in real time, the burdensome nature of what's happening here.
How is this more burdensome, though, than what took place in Clinton versus Jones? I guess I'm not sure I understand.
Well, I mean, there's a big distinction between a defendant in a civil case and a principal in a criminal case here by the state district of the local DA.
Let me stop you there. Yes. They sought the deposition of the president while he was serving. Here, they're seeking records from third parties.
But they're his records from third parties, Justice Gorsuch. The third party is simply the agent custodian of the president's tax returns on the president's statement of financial conditions. So these are the president's documents that they're asking. And what's to stop them from seeking a deposition of the president, or, for that matter, asking the president to appear before a grand jury? Because if the official versus unofficial was the deciding factor, and our view is that the initiation of process here interferes with the president's official duty, but if there was going to be this unofficial-official distinction put in place, well, then what stops the local district attorney from having the president testify, having the president tried?
Justice Kavanaugh?
Thank you, Mr. Chief Justice, and good afternoon, Mr. Sekulow.
Good afternoon.
Just following up on Justice Gorsuch, just explain, if you can, the rationale for having one rule for criminal and another rule for civil. Just assume there's one criminal investigation, that's it, and just explain the rationale for a different rule there.
Well, it's not that it's a different rule, because in this case, because it's within the context of a state proceeding, you have Article 2 concerns, and it's the supremacy clause issues, as this court alluded to in Clinton against Jones, that create the issues of concern about local prejudice. But the criminal nature of it creates a burden very distinct from a civil case, to be clear. Someone that is target. Well, the idea that you are the subject or a target of a criminal case being brought against you is very different than a civil suit, where at the end of the day it results in monetary damages, not a loss of liberty. So there's a big distinction between a civil case and a criminal case in that regard, and I think that impacts the standard upon which this court should be looking at the president's temporary presidential immunity. We're talking about stopping a process targeting the president, this subpoena targeting the president. That's what we're talking about here. It is that burden that is our concern.
I think the other side says that the position you're articulating is a bit more consistent with Justice Breyer's concurrence in Clinton versus Jones than with the majority opinion. In his concurrence, he said that judges hearing a private civil damages action against a sitting president may not issue orders that could significantly distract a president from his official duties. And it's pointed out that that language was not in the majority opinion. What do you think about how we should assess that?
Well, I think civil discovery versus criminal processes are two very distinct processes. And in a civil context, in a civil proceeding, we have the federal rules of civil procedure in the federal court that govern how that process goes forward, and federal judges can take into various considerations, especially dealing with the president. This is a state proceeding initiated by the local district attorney against the sitting president of the United States. So our concern here is the nature of the proceeding itself is why we view categorically that a subpoena targeting the president and his records here would be violated.
Sorry to interrupt. How do you deal with statute of limitations issues?
Well, the statute of limitation issues, of course, are decided under New York state law, and under New York state law, there would be procedures that could be utilized if, in fact, the DA were to elect to start a process like that, or if there were to eventually be action. But I need to say something.
Thank you, counsel.
Thank you, Mr. Chief Justice.
General Francisco.
Mr. Chief Justice, and may it please the court. At a minimum, a local prosecutor should have to show he really needs the president's personal records to subpoena them for two reasons. First, as the court suggested in Clinton against Jones, state proceedings can pose a greater threat to the presidency. The 2,300 prosecutors across the country necessarily place more emphasis on local interests than national ones. A special needs standard ensures that federal courts balance the prosecutor's local need for information against national interests, including the president's need to do his job. Second, ordinary grand jury rules are not designed to protect Article II interests. That's why in Nixon, the court held a federal prosecutor had to show a demonstrated specific need for the information sought. A local prosecutor should at least be required to meet the same standard. As the court has repeatedly said, in no case of this kind would a court be required to proceed against the president as against an ordinary citizen. And here the district attorney hasn't tried to meet the special needs standard.
General Francisco, we just heard Mr. Sekulow argue in favor of an absolute standard, no circumstances, no how. Your position is that, as you say, at a minimum, the special needs test must be met. Of course, Mr. Sekulow is representing Mr. Trump. You're representing the United States. You're arguing for a more flexible standard. So what was wrong with Mr. Trump's position?
Your Honor, I actually think that Mr. Sekulow makes a very strong argument on the immunity issue. We just don't think it's one that the court needs to address, at least until the prosecutor argues and attempts to meet the special needs standard. Here, since the prosecutor hasn't argued and isn't arguing before this court that he meets the special needs standard, there's no reason for the court to address the broader immunity question, and it's the court's ordinary processes to try to avoid those broader and more difficult questions when possible. And here we think that the special needs standard would fully resolve this case at this stage of the proceedings.
Well, in a typical case with adequate allegations to say that the standard's implicated, you would say that it goes before a court, and the court will examine whether or not the criteria you talk about, which I gather is the test under Nixon, are met. And under Mr. Sekulow's standard, would not immediately go before the court. He was looking for a ruling from us saying that he's absolutely immune, so the court would have no business addressing such a case. That's a very significant difference.
Well, Your Honor, I think that in both instances, the argument would be available to an article. You'd be able to make that argument to an Article II federal court. Under our argument, if the court found that the prosecutor hadn't met the Nixon special needs standard, it wouldn't need to address the broader immunity question. If it did find that the district attorney met the special needs standard, it would have to then address the broader immunity question. And all we are saying is that unless and until the special need issue is addressed at the threshold, there's no need to address the broader immunity question in this case.
Thank you, counsel. Justice Thomas?
Yes, General Francisco, you mentioned the level of threat to the president or burden on the president. How do we determine that when it's too much?
Well, Your Honor, here I think there are a couple of things that you can take into account. First, the fact that we're in state court, I think, is quite significant. Local prosecutors are necessarily going to put more emphasis on local interests than national ones. It simply reflects the manner in which they rise to office through elections by local, relatively homogenous political communities. And in New York State, I would also add that the trial court judges are elected in a similar way. So there you've already got this risk of local prejudice. And so what the special needs standard does is that it ensures that there's a federal court that's available to balance the local interests against the national ones, including the president's need to do his job. And then secondly, it also has to do with the ordinary grand jury rules that would apply to a local prosecutor exercising his authority. Those rules were not designed to, and they're not sufficient to protect Article II interests, since under ordinary grand jury rules, a district attorney never has to make a particularized showing of need. Instead, the burden is on the witness to show that the subpoena can have no conceivable relevance to any plausible subject of an investigation. Now, that is a perfectly appropriate standard in the ordinary case, but the reason why Nixon applied the special needs standard above and beyond the ordinary rules of criminal procedure was because the court recognized that the president is the sole person in whom all Article II powers are vested. And so he is entitled to a measure of protection above and beyond the ordinary rules. And the special needs standard is one of those measures of protection. To point back to Justice Breyer's very persuasive concurrence in Clinton against Jones, I think Justice Breyer correctly predicted that this court would need to develop special protective procedures precisely for the president in the context of litigation like this.
Justice Ginsburg?
You stress that the states are subordinate sovereigns and they are subject to the Supremacy Clause. But you don't give any credit at all to the 10th Amendment and the reserved powers of the state. That's one question that I have. And as far as the impact of the president is concerned, I think there's no case more dramatic than the Nixon tapes. Devastating impact on the president. He resigned from office, but yet that was okay. So I really don't get it.
So, Your Honor.
Yes?
So, Your Honor, in terms of the 10th Amendment, all we're saying is that Article 2 vests all executive power in a single president of the United States. He is the sole person in whom all executive power is vested, and so that necessarily implies that there are limits on what others can do to unduly burden him in his ability to do his job. So all that the special needs standard does is ensure that a prosecutor really needs the president's information before he can enforce that subpoena. Since if he can't even show that he really needs the information, he's necessarily imposing an undue burden on the president and creating a serious risk of harassment. And if you multiply that by 2,300 prosecutors across the country, I think that the risk to the presidency is quite obvious. In terms of the Nixon case, we are actually arguing for the same standard that the court applied in the Nixon case, the special needs standard. We're just saying that a local prosecutor in state court should be, at a minimum, be required to meet the same standard that the federal prosecutor in Nixon had to meet and show that he really does need the information that he's seeking. Since, again, if he doesn't, it's unnecessarily... Yes, Your Honor.
The grand jury is an investigatory body. It doesn't make, at the outset, specific charging decisions while the investigation is underway. It investigates in order to determine should there be specific charging decisions. But you would have them make charging decision before they investigate, and that seems to be backward.
Your Honor, respectfully, no. I would simply urge that you apply the same standard that Judge Wald applied in the Inree Fields case, which was a grand jury subpoena issued to the White House, where she concluded properly, in our view, that Nixon's special needs standard ought to apply to grand jury subpoenas. It's not, you don't have to make a charging decision, but you do have to show a demonstrated, specific, particularized need for the information pursuant to which you are issuing the grand jury subpoena.
Justice Breyer?
Thank you. General, I think that Nixon tape case has one thing for you, one thing against you. The thing against you, I think it was a case where executive privilege was asserted. But what's for you, and I think might be more relevant, is in that case, the court said, well, there has been first a weighing of the burdensome nature, etc., a lot of other things in that, in the lower courts that have decided that it is appropriate to go forward. Now, what I don't see is why you need a special standard more than that here, the ordinary standard. You would need a decision by us that it's reviewable in federal court. I understand that. But I don't see why you have to go beyond that, where the things you're talking about would be taken into account.
Your Honor, you are absolutely correct that at a minimum we would need federal court review. And in that regard, I would note that the district attorney here agrees that there are Article 2 limits on what he can do and that those Article 2 limits are in federal court. But respectfully, I would suggest that Nixon stands for more than simply some kind of weighing of interests. Nixon applied the special needs standard, and it said that the prosecutor did, in fact, have to show a particularized need for the information. That's all that we're suggesting ought to apply.
Yeah, but wasn't that in the context of assertion of executive privilege?
Excuse me, Your Honor?
Wasn't that in the context of an assertion by the President of executive privilege?
Yes, Your Honor, it was, but litigation about private conduct is also burdensome, and as the court recognized in Clinton against Jones, the president might well need more protection in state court than he gets in federal court precisely because of the risk of local prejudice, and that's why the court reserved judgment on that question. So I think when you put those two things together, it does make it entirely appropriate to hold a local prosecutor in state court to the same standard as the federal prosecutor was held to in the Nixon case. And indeed, even if you were to take the district attorney's own case-specific test, I think you would need the special needs standard. After all, we don't typically get discovery into a grand jury proceeding. So the only way to assess at the front end whether the prosecutor is issuing an unduly burdensome subpoena or issuing a subpoena in bad faith is to require some kind of showing of special needs. After all, why would a local...
Justice Alito?
And General, could you explain in more specific terms how you think this showing of special need would be carried out in district court? I assume that the prosecutor would have to make some kind of, would have to reveal what was being investigated and why this particular information was needed for or essential for the investigation. Now, would that be done, would that be reviewed by the judge ex parte? Would it be available to whoever the sitting president is to object to that, to review it and object to it?
Your Honor, it's difficult to answer that question in a vacuum because I think it would very much depend on the particular case, but let me make my best stab at it. I think that in order to have meaningful judicial review, you would need, the prosecutor would need to make public as much as could responsibly be made public so that the president would have an opportunity and the president's lawyers would have an opportunity to make their case on the particular facts. If there is a certain amount of evidence that really cannot responsibly be made public, then I think it would be appropriate to consider ex parte proceedings or filings under seal. In all events, we think that that's the type of assessment that needs to be made when you're talking about subpoenas, unprecedented subpoenas like this one, that are from state and local prosecutors targeting the President of the United States. The other place I would point you to is, again, Judge Wald's very good opinion for the D.C. Circuit in the In re Field case, where she does walk through in some amount of detail and unpack how the special needs standard applies to grand jury subpoenas.
How essential must the information be in order to meet this special needs standard? Does it have to be absolutely indispensable, not available from any other source by any conceivable means, or simply very useful?
Your Honor, it's probably somewhere in between those two things. I think it's got to be. I think it's got to be critical to the charging decision, so it can't just be marginally useful or merely duplicative or interesting to a tangential side issue. It does have to be critical to the charging decision. If the information is readily available elsewhere, I don't see how a prosecutor could meet the special needs standard. And if the information he currently does have is sufficient for him to make a responsible charging decision, I also don't think how he could meet the special needs standard. So I guess I would put it somewhere.
Justice Sotomayor?
General, there's always danger in taking a doctrine adopted for one set of needs, and that has to do with needs that are balancing what is clearly recognized in law as executive privilege versus the needs for the proceeding at issue, and transplanting it to a situation that's totally different, where we're not talking about a claim of executive privilege, and we're not talking of executive immunity, we're talking about private activities that predated the president's tenure. So why are we using all that transplanted language, and why don't we get to a standard that takes care of what you're worried about, which is harassment and interference, and simply ask whether the investigation is based on credible suspicion of criminal activity and whether the subpoena is reasonably calculated to advance that investigation. A standard that looks to whether there is a good faith basis for the state prosecutor's actions and whether the subpoena is reasonable in its scope and burdens. I don't understand why that sort of standard is inadequate, especially for a proceeding that involves secrecy like a grand jury subpoena.
For two reasons, Your Honor. First, for the reasons that I think Justice Breyer did persuasively explain in Clinton against Jones, even litigation about private conduct can be quite burdensome, and that is particularly so when you're talking about private conduct that's being litigated in state court pursuant to state procedures. So I think that's why he correctly predicted that this court would need in future cases to develop special protective procedures precisely in this context. And secondly, I think that the special protective procedure that we are proposing here is necessary even under Your Honor's general approach. After all, why would a prosecutor take the unprecedented step of issuing a subpoena to the President of the United States for personal records from a local prosecutor if he can't even show that he really needs the information that he's seeking? If he can't make that showing, I think there is a pretty good reason to be a little bit suspicious. After all, very few prosecutors...
Justice Kagan?
So, General, a couple of times now in response to Justice Breyer and Justice Sotomayor, you've explained why we should use the standard from executive privilege cases by saying, well, litigation about private conduct is also burdensome. But the point about executive privilege cases is not that it's burdensome. I mean, the critical factor is the weighty interest that a president has in communicating with advisors on official matters, often about national security, often about military matters, and the need for confidentiality in that. And that's why the Nixon standard was developed, not because of generalized ideas about burdensomeness, which can be dealt with in other ways. So again, why should that standard be used here?
Respectfully, Your Honor, because I think that they're parallel interests. Executive privilege, you are right, is meant to protect the confidentiality of communications, but Article 2 more generally is meant to protect the president from being unduly burdened in his ability to carry out his responsibilities. And I think that's particularly necessary when you're talking about state court proceedings by the many, many 2,300 local prosecutors across the country who, again, are more responsive to local political constituencies and local interests than national ones. So I think that when you look at Article...
this heightened standard in order to take account of burdensomeness. Burdensomeness is something that can be addressed in any subpoena, and I'm sure that courts, when it gets to the president and the special responsibilities of the president, will address those interests with respect, with sensitivity, especially if we tell them so. So why would you need this heightened standard that is meant to protect confidential communications about official government business?
For two reasons, Your Honor. First, because under the ordinary grand jury rules, the only question as to burdensomeness is whether the subpoena has any conceivable relevance to any plausible subject of investigation and therefore is unduly burdensome. And secondly, I think that judgment has to be made by federal courts, not state courts, because state courts, like local prosecutors, are going to be more responsive to local interests. After all, in New York State, trial court judges, like the district attorneys, are elected in partisan elections. So all we're saying is that this is the type of assessment that needs to be made in federal court, and the most appropriate and easy to apply standard is the standard that you've already been applying for 50 years under the Nixon case. And we think that that is...
Justice Gorsuch?
Counsel, I'd like to just explore a little further how this standard that you're proposing would play out in practice. I suppose you'd have a local prosecutor saying, I'm investigating a tax infraction. And the best and maybe only evidence of that potential infraction are the tax records in the possession of the potential defendant. Why wouldn't that meet the special heightened test that you proposed in every case? And if it does, then what have we achieved?
Well, Your Honor, I think it would depend on who the potential defendant is. If the potential defendant is the President of the United States, here the district attorney doesn't contest the fact that he cannot indict the President of the United States until after he leaves office. So he wouldn't be able to show that he needs the information now in order to indict the President of the United States. Of course, if the potential defendant is somebody else, then it might start looking closer to the Nixon case itself, where the special counsel was investigating a third party. And I think that would, in fact, be a relevant consideration under the special needs standard.
I guess I didn't follow that last portion of it. Let's say the infraction is by a corporation or some entity. And we need the prosecutor is going to say we need these materials in order to determine whether there is an infraction. Why wouldn't that qualify under your standard?
I think that would certainly be a relevant thing to take into account under our standard. And if he actually met the special need test with respect to the information and found that it was really necessary in order to bring charges against that third party, he may well meet the special needs standard, and then you'd have to address the broader immunity questions. In this particular,
how much showing of a special need is required under your standard? The prosecutor says I have some reasonable suspicion that there's a tax deficiency by some entity. Is that enough?
Your Honor, I think it's more than that. I think he's got to show that the information he's seeking is critical to him responsibly making a charging decision, that he can't get that information from somewhere else, and the information that he does have is insufficient. It's essentially the same standard the court applied, this court applied in Nixon, the D.C. Circuit applied in the Resealed case. You know, it's not like it's a hard and fast, bright line rule, but it is an administrable rule that courts have been applying for some 50 years now.
Thank you, counsel. Justice Kavanaugh.
Thank you, Mr. Chief Justice, and good afternoon, General Francisco. I want to follow up on Justice Thomas and Justice Kagan and really zero in on what the Article 2 interest is before we talk about what standard. And I think in Justice Breyer's concurrence in Clinton against Jones, he referred to the interest in time and energy distraction, which he drew from Nixon versus Fitzgerald, a different Nixon case, as an independent Article 2 interest that is distinct from distortion of official decision-making, which would be more the executive privilege kind of interest. Is that the Article 2 interest you're zeroing in on, or is it something else?
Well, Your Honor, respectfully, I think it's both of them, and as I read Justice Breyer's opinion, he likewise understood it to be both of them. The whole idea is that Article 2 vests all executive power in a single person, and that necessarily means that others can't unnecessarily hobble or debilitate that person in his ability to responsibly carry out his duties. So the whole point of the special needs standard is to ensure that others, including prosecutors, can't unnecessarily impede the president in carrying out his responsibilities. So at a minimum, they have to show that they really need the information that they're seeking. Since if you have 2,300 prosecutors that are unnecessarily hitting the president with subpoenas and none of them can actually show they really need that information, you're necessarily going to be undermining the president's ability to effectively carry out the Article 2 duties that the Constitution entrusts to him and to him alone on behalf of the entire country.
Thank you, counsel. Mr. Dunn.
Mr. Chief Justice, and may it please the court. There are two principles at issue in this case. One is the central role of the president in the functioning of our national government and the need to avoid interfering with the president's ability to carry out those important duties. The other principle is that under our Constitution, when a president acts as a private individual, he or she has responsibilities like every other citizen, including compliance with legal process. In particular, this court has long held that American presidents are not above having to provide evidence in response to a law enforcement inquiry. We're mindful that as a state actor, our office cannot investigate a president for any official acts, and that we cannot prosecute a president while in office. But here, we're talking about a subpoena sent to a third party concerning private conduct by a variety of individuals and businesses. Yes, one of them is the president, but no one's been targeted or charged with anything. There's no claim of any official acts or any executive privilege. As the courts below found, the subpoena imposes no Article II burden whatsoever and was not born of any political animus or intent to harass. Instead, it was prompted by public reports that certain business transactions in our jurisdiction were possibly illegal. Given those allegations, our office would have been remiss not to follow up. In response, the president asked the court to overturn 200 years of precedent by declaring he has a blanket immunity while in office from any legal inquiry, even for his prior private acts, even though that could result in a permanent immunity for him and the other parties if the statutes of limitation expire, and even though it could prevent the discovery of evidence that could exonerate the individuals involved. Finally, his novel claim also asked the court to presume that state actors have a, quote, reckless mania that will cause them to, quote, relentlessly harass presidents, and that state and federal courts will allow prosecutors to do so. Of course, there's no historical support for this claim, which flies in the face of federalism. The supposed floodgates have been open for generations, and there's never been a flood. The only thing new here is the subpoena comes from the state. But absent a constitutional burden, that shouldn't lead the court to abandon its long-standing respect for state criminal proceedings.
Thank you, counsel. We've had the cases this morning and this case, and they are in many respects very similar. In the case of the subpoena itself, they're identical. But I think in other respects, they're really quite different. The separation of powers case this morning involved entities in an ongoing relationship, the House and the President, and issues of this sort, although always very important, come up with some regularity. There's often disputes between the White House and Congress over documents, and almost always they're worked out because each of those branches have authorities and powers that affect each other. If the Senate asks for documents from the White House and the White House doesn't give them, then the Senate says, well, we're going to, take our time confirming your nominees and back and forth. But with respect to local prosecutors, you don't have that ongoing relationship. So the possibility of working something out is far less evident, and if you're doing that, the stakes are, well, it's just a little more difficult because there isn't that ongoing relationship. So shouldn't there be a higher standard before we permit the district attorneys from around the country, but there are also more of them than the two houses of Congress, 2,300 of them. Shouldn't there be a higher standard than in the case of the separation of powers dispute?
Your Honor, I think our answer to that is yes. And putting aside its relationship or not to the separation of powers analysis, I'd like to address the DOJ's proposed heightened showing standard because we see that, let me put it this way, we see that there are three reasons, I think, why the DOJ's new heightened showing proposal doesn't work. And a number of questions in the last argument, I think, touched on some of these concepts, if I might. First, one problem is that the approach that they're suggesting really reverses the court's prior approach to fact-finding in these types of cases in a way that I think would harm the grand jury process, which I can explain. So again, we agree there should be a heightened showing requirement, but my point is only after a president has already established an actual Article II burden. Otherwise, there's nothing for a court to weigh in the balancing of Article II interests against the need for legal process, and that balancing and that sequencing, frankly, was both central in both Nixon and Clinton cases. Here,
could you articulate for me precisely what standard you think should apply in your case, and in what sense is it more rigorous than that would apply in the dispute between the White House and Congress?
Yes, I think we believe that a prosecutor, if there's been an affirmative showing by a president of an Article II burden, and of course the courts have below held that there has not been such a showing here, but if in a different case there was such a showing made, we believe a prosecutor should be required to show, one, an objective basis for the investigation, and two, a reasonable probability the request would yield relevant information. We think language like that would be more consistent with past cases of this court and with the realities of a grand jury investigation. And frankly, the courts below also already found that we've met that standard here. The problem is that the alternative of requiring a state prosecutor to get permission first from a federal judge for any request relating to a president's business activities would undermine this court's prior rulings, like the one in R Enterprises, that a grand jury shouldn't be burdened by procedural challenges and delays because it's a confidential process and not an adversarial proceeding. And the DOJ's new standard just ignores that. The other problem—
Justice Thomas?
Thank you, Mr. Chief Justice. Mr. Dunn, you were about to say how DOJ's approach would harm the grand jury process. Would you finish that?
Yes, and I think I was just addressing that, Justice Thomas. That is, if to require us in any given case to run across the street to federal court and say, by the way, we have an investigation underway. It happens to touch on a president's prior business transactions in which he and others were involved in, and we'd like to get permission to send a subpoena for records that are in either the possession of a president or maybe the president's agents, like his accounting firm here. Again, it completely upends the way that a grand jury process is supposed to work. If I might, the second big problem, I think, with the DOJ's analysis is that the language that they've chosen just doesn't work, contrary to what I just set out, because it only applies in the context of a trial subpoena. It calls for a, quote, stringent showing that the request is, quote, directly relevant to central issues at trial and charging decisions. Again, that language just doesn't apply in the context of a grand jury when no charging decisions have been made. So that's why the formulation that we've suggested, I think, would be more consistent with what's needed in a grand jury context. But again, we think that it's utterly unnecessary here to apply in our case because, A, there's already been a finding of no Article II burden, and B, we have already met the standard by the district court's finding that our investigation is well-founded and brought in good faith. So
what limits a grand jury process in New York? What are the limits?
Well, the limits are, I think, the same basically as they are in a federal court in most other states, Your Honor. I mean, yes, the recipient of a subpoena who has a basis to argue either a privilege or a burden of some sort has the right, as the president did here, to go into court and make those factual arguments that it's that either it should be quashed or constrained in some fashion. There's a grand jury judge who supervises all grand juries and their activities, who's always available here. But I think the more important point, perhaps, Your Honor, is that obviously, given the decision of the Court of Appeals below in this case, and to address that concern and that footnote in Clinton, at this point, it's clear that a president in particular who has a concern about this kind of impact on Article II duties now always has the ability to go into federal court and not into state court, which was the main concern in that footnote in Clinton.
What if you thought it was the president said it was impossible for him to do his job as opposed to just being burdened? Would we have a role to limit or somehow end the grand jury process?
Absolutely, Your Honor. I mean, I think that's the point of the case-specific analysis is that it gives a court, and here a federal court, to hear a concern like that expressed. And if the concern is, somehow this shuts my office down, or it's a real burden, it's not just a speculative mental distraction claim, then yes, the courts are empowered to impose a wide variety of limitations, including, if necessary, to shut an investigation down or to shut a subpoena or a litigation down. That's the beauty of this court's prior decisions in Nixon and Clinton and others, which have decided consistently to apply the case-specific analysis and have rejected the notion that this is best treated with a categorical prophylactic rule. I just think that that's not appropriate here when it's also case-specific. Thank you.
Justice Ginsburg?
The principal objections that have been raised is that when you're dealing with federal prosecutions, it's all controlled by the Attorney General. But here you have 2,300 district attorneys, each armed with grand jury subpoena power. So the control that exists in federal courts with the Attorney General at the helm and no one controlling all of these state district attorneys.
I understand, Your Honor, and I think really what that gets centrally to is the consistent argument here about the parade of horribles, if you will. And if I could address that, I think there's several answers to that concern. First of all, there's really no empirical basis in history for this apocalyptic prediction. The same claim was made and rejected by this court in Nixon and then in Clinton. That, of course, was decades ago, and there's not been a flood of subpoenas or litigations or prosecutions of presidents by states or federal prosecutors. Second, as a practical matter, this notion that there are 2,300 prosecutors out there writing with their subpoena pads open, there's just no basis to think that an army of local prosecutors like that would even have jurisdiction over a president, especially for private conduct in the first place. Here, New York City, of course, has a particular connection to the Trump organization and its financial transactions because it's headquartered here. It's not likely that more than one or many states, much less 2,300 counties, would ever have that kind of connection to a president's private conduct. Third, I think as Justice Ginsburg, you mentioned in the last argument, this view that there's a reckless mania by local prosecutors contradicts this court's longstanding presumption in favor of regularity and deference to state proceedings. And so to finish off, the limitation I think that you're asking about really comes in the form of the case-specific showing that past cases from this court have established. Because if there is a concern about the behavior of a local prosecutor, any president, when necessary, but it's been few and far between over the decades, can run now not just into state court, which Clinton thought could be problematic, but can run into federal court and raise exactly the kind of claim that the president has raised here. That's the limitation.
Thank you.
Justice Breyer.
Thank you. I agree with you that the two basic principles you set at the outcome are there: every man's evidence versus the constitutional statement that the president is the executive, Article 2, and they conflict. Just as in the first case, the power of Congress, Article 1 and Article 2 conflict. All right.
I think that I would say they don't conflict, but yes, they're in tension.
They're in tension. Fine. All right. Now, a possible solution is, say, no absolute rule, but just send it to the ordinary system for weighing the needs versus the burdens, and the different sides have to say what they are, and then have that reviewable in federal court. And because of the nature of it, and we could list in an opinion the kinds of things that might not be or might be relevant depending on the case. And eventually with the president, we might review it. All right, now all that would take time. But time itself would discourage prosecutors from doing this, which might be good. And time itself would encourage House, Congress, President to work things out in a non-judicial way. All right, I don't put that as being wedded to it. I want to know your reaction.
Well, Your Honor, I think what you're describing is exactly what this court held in Clinton, and it's exactly, frankly, what has happened now in this case, which is, yes, in this case, the president decided to pursue his claim of immunity in federal court versus state court, which is fine and now available, I think, in the future to all presidents. But I think the fact that is what should happen in the ordinary course and which can happen in the ordinary course is, again, the solution and the limiting principle here, because it does make it clear that there is a remedy and discourages I would have thought, bad faith impulses by any state or local prosecutor who might harbor such an impulse, and provides an outlet that makes sure that it can't get out of control. But again, that's the beauty of the case-specific analysis. I don't think these things lend themselves to categorical prophylactic rules, and that's been the approach from this court from day one.
Thank you.
Justice Alito?
As I understand your proposed standard, there would be available review in federal court, and the prosecutor would have to show an objective basis for the subpoena and the relevance of the subpoena to the investigation. Is that correct?
Basically, on our language like that, I said point 2 was a reasonable probability that will yield relevant information, but yes, that's the concept.
Okay, reasonable probability. What would be your objection to a somewhat more demanding standard? So the prosecutor would have to show that the information can't be obtained from another source, or it would be very difficult to obtain it from another source, and the information unless the information is obtained right now, as opposed to at the end of the president's term, there would be some serious prejudice to the investigation.
Your Honor, I frankly don't think that any of those concepts are foreign to the standard that I articulated, and I think they are relevant, in fact, to the objective basis and relevance points. Here, for example, and again, I think the court below, the district court in particular, heard our explanations, and including the fact that, the reason why we went to Mazars is not to do an end run around negotiations with the president's lawyers. It's because Mazars, as the outside accounting firm, is, as far as we could tell, the only repository of what might be the most important documents in an investigation like this, which are not just the tax returns, but the surrounding accounting materials and work papers, et cetera, which shed light on the good faith or not of the transaction. So my short answer, I'm sorry, is that I think those concepts would be fine and not unduly burdensome in the context of the standard that I set forth.
Can I ask you one other thing? Do you think that the adjudication of this in all cases of a similar nature would depend in any way on state law and practice regarding grand jury secrecy? In federal court, the rules of grand jury secrecy are, of course, very strict. States have different rules. Suppose a particular state imposes no restriction on the revelation by a member of the grand jury, or perhaps even by the prosecutor, of the information that is supplied in compliance with a subpoena.
Well, Your Honor, I'm not aware of any other states having that kind of lax or non-existent grand jury secrecy rule. I can assure the court that in New York State, our grand jury secrecy laws are at least as strict as under the federal system. But putting that aside, if in fact the fact pattern presents to a judge the prospect that the information in fact will become public, and the president were to persuade a judge that the publication of the documents at issue would themselves impose some sort of Article II burden or other interference with his executive duties in that given state, I suppose that would be part of the case-specific analysis that the court could understand and take into account in deciding whether that there should be some limitation or even a quashing of the subpoena itself. I think that's part of the case-specific analysis.
I mean, we both know that prosecutors that there are prosecutors who leak all sorts of information, including grand jury information, to all sorts of media sources, including specifically the New York Times. If there were a showing that was a risk, would that have a bearing on this?
Your Honor, it's hard for me to I'm not aware of any kind of real pattern or practice of leaking of actual grand jury materials that are covered by grand jury secrecy. Yes, in all different kinds of offices, there are at times, leaks of status of cases and that kind of thing. But I am not aware, and our grand jury secrecy rules really prevent prosecutors, I believe, from actually turning over confidential grand jury secrecy materials to.
You're not aware of this ever happening your office is never requested by media in the New York City area to disclose confidential investigative information?
No. Well, they ask all the time, Your Honor, and the answer is consistently no, at least as far as I can represent. But what I'm trying to draw a distinction between is people commenting to reporters all the time, off the record, that kind of thing, versus turning over actual materials like, voluminous tax returns or other sensitive documents that have been gathered and which are covered by grand jury secrecy. That's what I just don't see happening here, and I think history supports that view.
When you refer to an Article 2 burden, does that include the burden of harassment, the burden of using subpoenas for political purposes?
Yes, Your Honor, I would certainly include that there. And again, there's been an express finding below here that there is the investigation was well-founded, that there was no harassment or bad faith in our bringing of the subpoena.
Thank you. Justice Sotomayor?
Counsel, did I understand your answer to Justice Alito to be that you are in agreement with the SG that we should impose a heightened need standard, a special needs standard?
No, Your Honor, I think we're all now calling it the heightened showing standard, or in the DOJ's lexicon now, the heightened need standard. But I think what I'm articulating is a very different standard in terms of the actual language to be looked at and imposed. Again, I think...
But wait, if you can, counsel, because I want to be very precise. If your standard includes what the heightened need standard has, then why not call it what it is, heightened need? There has to be a reason you think we shouldn't call it that, and I don't know that I understand what difference you're proposing.
I'm sorry, Justice Sotomayor. The concern I have with the DOJ language is, again, calling for a stringent showing that a subpoena request is directly relevant to central issues at trial and other concepts like that. What I'm trying to propose is something I think which is not so strict and which is not limited to charging and trial-related concepts, but which would be workable in the context of a grand jury subpoena. And again, whatever the standard is that we're articulating, I want to stress that I believe that our office has met that standard here, even under the DOJ's proposal, because of the findings by the district court.
Tell me why the heightened standard would interfere with the grand jury process.
Well, I think, Your Honor, among other things, the DOJ's proposed application of its standard, if you read its brief, would confer the same absolute immunity that the President is seeking here. What they say is, since you can't indict while in office, you don't need the documents while he's in office. And frankly, that's an outcome that would apply in every case. No subpoena could pass that test, because they basically say, you have to wait until he's out of office before gathering information because you don't need it in the meantime. And so their definition of heightened need says you don't need it while he's in office. Well, that's not workable here.
Why not?
Because, well, obviously, Your Honor, if we were to wait until a president was out of office in a situation like this, first, it would risk the loss of evidence, the fading of memories, and unavailability of witnesses, which is exactly why the DOJ Moss memo, of course, specifically contemplated that a president could be subject to a grand jury while in office to avoid losing that kind of evidence. Secondly, and equally important here, no one should forget that we've got an investigation that is, looking at the conduct of other people and businesses, and waiting like that would benefit those other participants. They could all end up above the law if the limitations period expires. So delay here is the same as absolute immunity and absolute permanent immunity for the president and others if a statute of limitations expires. That's the problem with the delay.
Well, the other side says the statute would be told against the president, but you're right, it wouldn't be told against other people who may or may not have been committed crimes that he may or may not be a part of, correct? Correct,
and that's important, Your Honor, for the third parties. But just to address my friend on the other side's comment about the tolling, I'm not aware in state law of any doctrine of implied tolling that would apply here to protect the state's interests in investigating and potentially prosecuting if necessary down the road. I don't know where that concept comes from, but it's never been articulated by this court. There's no act of Congress which permits that kind of tolling here. And so for us, the statute of limitations is a big concern. Frankly, we've already lost 9 months of time in this investigation due to this lawsuit. And again, every minute that goes by is, basically without even a decision on the merits here, granting the same kind of temporary absolute immunity that the president is seeking here.
Justice Kagan?
Mr. Dunn, you've been talking about how to analyze these burdens in a case-specific way, the burdens both in terms of the president's time and in terms of any possibility of harassment of the use of a subpoena for political purposes. And Mr. Sekulow said that the burdensome nature of these subpoenas is categorical. That was his term. And I take him to mean that that any subpoena interferes with the president's responsibilities or undermines the president in his handling of the office. So what's the answer to that?
Your Honor, I would make 3 points. I think the fact is that the court addressed this question, I think, in Clinton and concluded that a president can't realistically be shielded from every sort of private distraction, including some forms of legal process, especially in our modern age. So that's why it's up to a court to evaluate and protect the president, depending on the circumstances, on a case-by-case basis. Secondly, here, the claim of, the possible mental distraction is completely speculative, really. It's based on the notion that the president might be, worried and distracted about where an investigation might lead someday. It's not based on any actual Article II burden or interference of the sort the court was asking President Clinton to demonstrate in Clinton v. Jones. And third, I'd say if that's really the concern, I think it's wrong to think that even a categorical rule here would provide comfort to a distractible president like that. So, for example, nobody suggests here that we should be barred from continuing to investigate the president's prior colleagues. So if we now gather documents from them that reflect past communications with him while he was CEO, are we then supposed to be stopped because it could create a fear in him that the investigation of others might lead him to be accused of something someday? Again, my point is that this speculative mental distress standard is not an appropriate basis to draw a constitutional bright line. That's why the case-specific approach is more appropriate.
And speculative mental distress, how about if they really mean political undermining?
Well, I mean, that's beyond the ken of our office, Your Honor. And as, again, the district court found, there was no bad faith intended by virtue of our subpoena. So I don't know. It's already been determined here there's no intent to politically undermine. So I don't know how a court could try to evaluate that, and I'm not sure that would be appropriate.
Mr. Sekulow suggests that you've shown your bad faith by taking the language of the House Oversight Committee's subpoena.
Yes, Your Honor, and I think we've tried to address that. I mean, the simple fact is that in 2018, when our investigation started and thereafter, as we've spelled out, and there were a series of public disclosures in the press about possibly illegal transactions involving tax and other financial improprieties. And at the time of the House subpoenas and then our subpoena, it was clear that both our office and the House committees were looking at the same public allegations in that regard. In a situation like that, once the House subpoena became public, it's not unusual for an office like ours to model our subpoena language on that which has already been made public from a different source when it's going to the same recipient. It makes it easier on the recipient in the process. There was absolutely no communication between our office and the House about this. There's nothing sinister about it, Your Honor.
Thank you.
Justice Gorsuch?
Counsel, I'd like to return to your colloquy with Justices Alito and Sotomayor, because I guess I'm uncertain what the daylight is between the test you're proposing and the test the Solicitor General has suggested. It seems like both of you agree that these questions should be resolved in federal court, and you've suggested that the prosecutor should have to demonstrate an objective basis for the investigation and that there's at least a reasonable probability that the information sought will be helpful to that investigation, that it can't be obtained elsewhere, and that it's needed now rather than at the end of the president's term because of some serious prejudice that might take place in between. As I understood your discussion with Justice Sotomayor, you suggested that the difference is the Solicitor General thinks there should be an absolute immunity till the end of the term. I confess I didn't read the briefs that way. I read it as suggesting the district attorney has to show why there's a need for the president's records now rather than at the end of the term. And I understood your discussion with Justice Alito to agree that that would be a relevant consideration. What am I missing?
I think, Your Honor, putting aside the language differences, which I tried to highlight, I think the most important distinction is what I tried to note at the outset, which is the sequencing of the showings that need to be made. Because what the DOJ is proposing, as I understand it, is that in the first instance, it has to be the prosecutor who goes to court, goes to federal court in this instance now, and makes an affirmative showing that the standard has been met, that there's some objective basis, and it can't be obtained elsewhere, et cetera, and only after such a showing has been made by the prosecutor, according to the DOJ, does the burden then shift to the president to show Article II burden. And I think that's what's completely backwards and inconsistent with Nixon and Clinton. I think it's much more appropriate for the president, as the moving party, as here, to be required to make a showing, as any other litigant would be the case. Again, here we're talking about purely private conduct, to explain why this request somehow impacts not just on a need to gather documents, which is not the case here, but on an actual Article II burden. And only once that showing has been made should, I think, the burden shift to the prosecution, consistent with past cases by this court, to explain why, nonetheless, it's still necessary to permit the court at that point to conduct the balancing of apples and apples in terms of coming to the right conclusion in a specific case. To me, that's
Mr. Dunn, am I correct in thinking then that you agree that the forum should be federal court? You agree on all the relevant considerations, the necessity of the information, that it can't be obtained elsewhere, the timing issues, all are relevant considerations. It's just who bears the burden?
Yes,
Is that
Your
what
Honor.
we're fighting over?
Well, I'm maybe with the DOJ, there's less daylight between than us and the president's lawyers. But I think the important point that I would want to leave the court with is that even if one were to adopt that standard, or even, frankly, I think the DOJ standard, the fact is we've already met that test given the findings of the courts below.
Oh, I know you think you win no matter what. We have to write a rule that's presumptively of some value going forward and isn't just about one president, but it's about the presidency. And I'm just trying to understand what daylight actually exists. And is it fair to say that the only daylight that exists between you and the Solicitor General is who bears the burden of proof? I'm not trying to put words in your mouth. I'm trying to understand.
No, Your Honor, I think it is the burden and the difference in language, which I pointed out to Justice Sotomayor. I think that those differences are important because I don't think that the DOJ's language works in a grand jury investigation.
Thank you.
Justice Kavanaugh?
Thank you, Chief Justice, and good afternoon, Mr. Dunn. On that last point that you were talking about with Justice Gorsuch, the difference between the Nixon heightened needs standard, you said it doesn't work in a grand jury. What do you do with Judge Wald's opinion in In Re's sealed case, which took Nixon and did apply it in a grand jury context?
Yes, well, Justice Kavanaugh, as I think you mentioned in the earlier argument, the fact remains that the In Re's sealed case was indeed applying the Nixon standard as the Nixon court contemplated to a claim of executive privilege. And as has been pointed out earlier today, I think that's a very different analysis to be undertaken for a very different purpose. And I don't think one can just simply import that language and apply it to
I'm sorry to interrupt. Let's leave that for a moment. But the point on the grand jury versus trial, just on that point, Judge Wald's opinion did take Nixon and apply it in the grand jury context.
And indeed, even in the grand jury context, when we're talking about a privilege analysis, I think that language is appropriate. Because at that point, you already have, once there's been an affirmative showing that established that there is a privilege to be addressed, then of course, like with any attorney-client privilege, for example, it's necessary for the court then to turn to the demand or the request and the documents that are at issue and evaluate them in light of
Let's, if we can, move on to the Article 2 issue then. Do you acknowledge that there's an Article 2 interest at stake here?
Yes.
And what do you think it is?
I think it's the Article 2 interest to be free from unreasonable burdens on the duties and obligations of the presidency, and that's the same analysis that was applied in Nixon and in Clinton.
Do you think time, what Justice Breyer referred to as time and energy distraction, are appropriate Article 2 interests?
Well, yes, as a matter of degree. Again, that was the court's analysis in Clinton. Recall there that although this court allowed the litigation to proceed, of course, appropriately, as I think is the case here, there's a need to make sure that the courts that are overseeing this kind of objection are undertaking an analysis of what the burdens are, including on a very practical level. I think the Clinton court hypothesized that perhaps a request for actual in-person testimony at trial by a president might be inappropriate. And
I think the other side made two distinctions with Clinton, and I want to make sure you have an opportunity to address them. One is the federal state. The other is the civil criminal. On the civil criminal, I suppose one thing I'd like to hear you address is, in a civil case, and the court emphasized this in Clinton versus Jones, there's an individual person at stake who has a claim. There's not the same in a criminal context. Obviously, there are different and very important interests there, but not the individual interests. Can you address that?
Well, that's one distinction, Your Honor. I suppose on the other side of the coin, there is the important difference that there are potentially thousands or many more potential private litigants out there who are not bound by the kinds of ethical and jurisdictional and other constraints that prosecutors are bound by, and to which this court has long paid deference. I think that the reason for concern in the civil context is actually much higher than it should be.
Sorry, if I can get my last question in on the federal state. If there is an Article 2 interest at stake, and you said that there is, it's different, of course, from the executive privilege interest, but there's some Article 2 interest at stake. I think the other side says it would be odd if the standard were easier to meet for a state prosecutor than for a federal prosecutor, and I just want to give you an opportunity to address that.
Yeah, frankly, I don't really understand that distinction. I think under the analysis that this court has applied before and the one we're talking about now, the same analysis would apply in terms of a case-specific evaluation in the context of the particular facts of a particular request.
So just to stop you there, you're okay with whatever standard applies to a federal prosecutor in a case where there's an Article 2 interest also applying to the state prosecutor?
Well, I'm not sure exactly what you have in mind, Your Honor, but I think
the Nixon standard. You're not okay with the Nixon standard, I don't think, but I just want to explore that.
No, because of the fact that was applying to claims of executive privilege. But I think to get to your point, I think what it comes down to is that in the Nixon and Clinton cases, we're talking about Article 3 versus we're talking about separation of powers analysis. Here, the analogy is we're balancing federalism and 10th Amendment concerns about police power of the states against the Supremacy Clause. So it's a different analysis, perhaps, but it's very analogous.
Thank you.
Counsel, we have time for a little bit of a second round. And I guess the thing that I would like to focus on first is this question of how you examine the burden on the president or the presidency. I just don't understand how it works in terms of you or the president being asked to devote a certain amount of time to reviewing, for example, in this case, the 10 years of documents or whatever. I mean, is there supposed to be a hearing where he says, here's what I'm doing, I've got this pandemic thing, China's causing all sorts of trouble. Most presidents throughout their term have a pretty long to-do list, and I'm just wondering how it's ever going to be any different in evaluating what that burden is. It seems to me that it would be the same no matter what. You really wouldn't need a particular hearing on that.
Well, I guess, Your Honor, when we're talking about in the context of a particular subpoena like this one, or a litigation or what have you, like in Clinton, again, this court has already decided that you can't shield a president from every sort of private distraction. And I just want to emphasize here again that
that was in the civil context. The question is whether or not a criminal investigation might be a little bit more distracting.
Well, I'm not sure, Your Honor. I mean, I'm not sure whether the stigma of, a simple secret grand jury investigation, even if it becomes publicly known, is more distracting and stigmatizing, perhaps, than being accused even civilly of sexual misconduct, which was, of course, allowed to proceed in the civil case involving President Clinton. So I'm not sure that, again, the abstract concern about, possible mental distraction or even public stigma under this court's prior analysis is sufficient to adopt a new bright-line constitutional rule that forbids any kind of process like this, given the history
that is what the president's personal lawyers advocated. It's not what the Solicitor General advocated, not an absolute rule.
Yes, I know, Your Honor, and therefore the answer in that case is what's happened here, which is a case-specific analysis before a court, which, as they do all the time, is able to balance and listen to arguments about burdens. And as here, when the court finds there's no Article II burden whatsoever after an opportunity to be heard, that should be the answer, and that's what's happened here.
Justice Thomas, anything further?
One brief question, Mr. Dunn. There's been much discussion about burdens on the president. I'd like from you a couple of specific examples of what you think a burden would be that actually counts in your analysis on the part of the president.
Well, I guess, Your Honor, again, hypothetically, because our subpoena imposes, we say, no burden whatsoever.
I understand that.
But I think I would again point to this court's language in the Clinton analysis, where it was observed in passing in the opinion, I think just as dicta, but it was relevant, that if a president was asked to actually appear and testify at trial someday, someplace outside of the White House, that might be the kind of thing that you'd say really shouldn't have to happen. I would suggest there, along those lines too, that if a president were to be asked to show up for multiple days of consecutive deposition testimony or something like that, those are practical burdens. Or if the demands were that he show up at a particular time or place that is where there are conflicts and that kind of thing. Again, since we're talking here about private conduct and no executive privilege, what we get to are really practical concerns about impositions on presidential activities, and that's, I think, what we're talking about.
Thank you. Justice Ginsburg, anything further?
Nothing further.
Justice Breyer?
No, thank you. Go ahead.
Justice Alito?
One quick question. I don't know how good this court is about predicting the consequences of some of our decisions, but would you say that the court's prediction in Clinton versus Jones that the decision wouldn't have much of an impact on the presidency has been borne out by history?
I guess, Your Honor, my view of the chronology in Clinton v. Jones, I'll try to be brief, is that I think, contrary to some people's view of history, I think that the district court, following this court's decision, kept a rather close rein on discovery in that case, and don't forget, later granted summary judgment in favor of the president long before trial. It was only that it came out later, of course, that it turns out that in his brief deposition in the case that the president committed perjury, which is what led to the impeachment proceedings and other travails he had. So I don't think it was this court's opinion or the litigation itself that led to those problems. Frankly, it was his decision to lie under oath. So I think that this court's conclusion in both Nixon and Clinton that you could not accept the notion there's going to be a parade of horribles, either in a particular case or across the board, still has borne out over history.
Justice Sotomayor?
I'm not sure that I understood your statement earlier, that the only difference between you and the SG, well, there are two differences. One in the articulation of special needs or heightened standard, but you said it's the burden of proof. But you've already conceded to one of my colleagues that there is an automatic burden on the Article 2 clause by subpoenaing a sitting president, period.
No, I've not, Your Honor. I'm sorry, but I've not conceded that.
All right. What then are you conceding when you say there's a burden? I'm conceding. And what kind of burden are you talking about? And number three, articulate more precisely what problems you have with the heightened standard that Nixon set in its grand jury subpoena.
Yeah, I guess in my response, I think to Justice Gorsuch, my concern, what I acknowledged was that, yes, a subpoena like this implicates Article 2 issues and potential burdens, and it's those which have to be weighed in a case-specific analysis. I wasn't conceding that the mere fact of the subpoena imposes, quote, an Article 2 burden. I think that's the distinction I would draw. And again, getting back to the language question, again, it's the DOJ's language that calls for a stringent showing that a request is directly relevant to central issues at trial and specific charging decisions. And again, very simply, as a practical matter, no court and no prosecutor could meet that standard because in a grand jury, one is not thinking about charging decisions or central issues at trial. And that's why I think the simple language that the DOJ is applying in its new heightened showing standard is just not workable.
Justice Kagan?
Mr. Dunn, on the question of a possible distinction between state prosecutors and federal prosecutors, the president's lawyers have urged that there's a legal difference arising from the supremacy clause. And I don't think we've talked about that argument yet. What is your response to that?
I think the response, Your Honor, is I alluded to it before, and I think all it means is that there is a balance to be struck between, in this case of state prosecutors, the supremacy clause concerns against the rights of states under their police powers and the concepts of federalism and the requirements of the 10th Amendment to allow the states to exercise their rights, especially in the criminal context, which are so important. So I think that's the parallel to the balancing in the federal prosecutor context. But I think it's even more important given the federalism concerns and the fact that state prosecutors, of course, not only do they have the reserved police power of the states, but in context of criminal investigations, a large body of criminal conduct is only prosecutable by the states. So that's the thing that has to be balanced here.
Justice Gorsuch?
Nothing further. Thank you, Chief.
Justice Kavanaugh?
Thank you, Chief Justice. I just wanted to ask again, deferral of the investigation until after the presidency, assuming statute of limitations issues were solved, which is a big assumption, I understand. Can you tick off the concerns you would have about that so that we have those clear?
Yes, Justice Kavanaugh. Again, it's point number one would be the putting aside statute of limitations concern, which I don't think one can discount here because I don't think it's been addressed, ever obviously by this court in this context, and that's our paramount concern, to be honest, at this point, because the clock is ticking. But even if that were to be addressed somehow, the risk of over time by waiting of losing evidence and losing witnesses and that kind of thing is a very real risk. Again, I think the OLC Moss memo addressed that expressly in saying that a grand jury proceeding should be allowed to proceed. But secondly, here, and it's not unusual, since there are other third parties at issue in the investigation, requiring us to delay because a president is still in office as to those third parties in gathering important evidence could yield them being above the law if the statute of limitations runs as to them.
Thank you.
Mr. Dunn, would you like a minute or two to wrap up?
Yes, Your Honor. Thank you. Your Honors, the issue presented here today is extremely narrow but extremely important. We have a state investigation that's well-founded, implicates no official conduct or executive privilege, involves a variety of third parties, faces serious time constraints, and has been found to impose no Article 2 burdens. These facts put our subpoena well within the scope of legal process permitted by this court for generations, indeed back to 1807. Past decisions have consistently found that courts already have robust tools to protect presidents from abusive claims or demands. There's no need here to upend precedent or to write a new rule that undermines federalism, especially when such a rule would create a risk that American presidents, as well as third parties, could unwittingly end up above the law. Thank you.
Thank you, counsel. Mr. Sekulow, you have 2 minutes for rebuttal.
Thank you, Mr. Chief Justice. Let me start with this, and there's some agreement. The New York County District Attorney acknowledges that their subpoena implicates Article 2 issues and burdens. They also agree that there is harms that could rise to the presidency. We say those harms have actually existed. The other aspect of this is the ordering. Who carries the burden here? That seems to be the issue that's left open. This court's decision in Cheney answered that very clearly, and it said that the exacting standard is carried by the party requesting the information. So it would be carried by the respondent in this particular case. There has been no showing and no findings of heightened need standards being met here. And I think it's, again, also important to remember, and I think this came up in the context of earlier questioning, there's a different stigma that attaches to criminal process than civil litigation. And I don't think that stigma should be ignored in a case like this. But the irony of all of this is that the House of Representatives and the district attorney issued essentially the same subpoenas to the same custodian for the same records. The House said it wants the records so it can legislate, not for law enforcement reasons. The district attorney says he wants the same records for law enforcement reasons. He has no legislative authority. But what's really happening here could not be clearer. The presidency is being harassed and undermined with improper process that was issued, in our view, for illegitimate reasons. The copying of the subpoena speaks to that. The framers saw this coming, and they structured the Constitution to protect the president from this encroachment. Thank you, Mr. Chief Justice.
Thank you, counsel. The case is submitted.
The Honorable Court is now adjourned until tomorrow at 10 o'clock.